So for the counter for your honor.
Thank you. Please be seated. All right. Good morning, everyone. We're on the record on case CR 22-21-1623, State of Idaho versus Chad Guy Daybell. We're continuing with evidence on the state's case in chief. The court notes the jurors have all returned, and I've received the juror affirmation from each one of the jurors that they've followed the court's admonishing instruction as we broke for the day yesterday. So thank you again to each of you for following that instruction. At this time, then, I believe the state is prepared to call its next witness. Is the state ready to proceed with a witness?
Yes, Your Honor.
Who will that be?
Doug Hart.
Very well. You can call your witness, Ms. Blake.
Solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
That's just right into your show.
All right. Before we get started with direct examination, then would I refer to you as Agent Hart?
That's fine, Judge.
Agent Hart, with the court's exclusionary order here, I'm going to ask, because this case has been live streamed as well as open to the public, have you watched any of the trial testimony that's taken place?
No, I have not.
Have you talked to anyone else about testimony they've provided?
No.
All right. Thank you. Ms. Blake, you can inquire on your direct.
Thank you. Agent Hart, can you remind the jurors where you currently work?
At the present time, I'm the chief deputy for the Canyon County Sheriff's Office.
And where did you work before that?
Prior to that, I was an FBI agent for 27 years.
And when you were with the FBI, did you become involved in a case involving some missing children named Tylee Ryan and JJ Vallow?
Yes, I did.
Did you personally assist in that case or work on that case?
Yes, I've worked on the case since its inception in November of 2018. Or 19, excuse me.
And can you explain why the FBI came to be involved in that particular case?
Yes, it's a very common occurrence for the FBI to be asked to assist in cases involving missing children. Of course, when those cases come to us at the onset of the case, we don't know what has happened. There could be elements of those cases.
Judge, I'm going to object at this point. This has become a narrative.
Overruled.
There could be elements of those cases that would, at a future date, indicate a federal prosecution. And so we're brought in early to assist our city and county partners. And that assistance continues through the entirety of the investigation.
Prior to being involved in this case, had you worked on cases involving missing children?
Several.
With regard to this case, did the FBI follow up on leads?
Yes, there were a tremendous number of tips and leads that were received during the course of this investigation. Those leads that involved information out of the state of Idaho were primarily handled by the FBI, and those tips and leads that were within the state were generally handled by the Rexburg Police Department or the Fremont County Sheriff's Office.
In this case, let me back up. Is it common in a case with missing children to look at the parents?
You look everywhere. You cannot have blinders on as a case develops. You have to follow the evidence and follow all of the investigative measures and leads that exist. And that's the process. Sometimes parents are involved, but you don't automatically look to any one individual at the onset of a case.
And is that in fact how the investigation proceeded in this case?
Yes.
Are you aware if other specialists or other branches, I may be using the wrong term, other areas of expertise within the FBI became involved in this investigation?
Absolutely, several did. The FBI possesses individuals and units that have particular skill sets that oftentimes can't be replicated due to resources by a city police department or a county sheriff's office. And so in this case, we had forensic accountants, we had electronic cellular telephone specialists, we had the FBI lab, we had our evidence response team, we had analysts, so on and so forth. Each of those individuals or units have a particular expertise and skill set that were brought to bear in this case as our needs dictated.
And Your Honor, I'm going to ask if I can be handed State's Exhibit 170.
Very well.
Agent Hart, as part of your work with the FBI, did you work on reservations?
I did. I have spent approximately 14 years of my career, either full-time or part-time on various different Indian reservations.
And with that, did you deal with any kind of burial sites?
Yes, when you're assigned to an Indian reservation, there are specific trainings that you go through in preparation for the types of cases that you might see. One of those trainings is the identification of clandestine grave sites, as well as how to process and exhume clandestine graves.
We talked about you being involved in the search for some missing children. Were you also involved in recovering their remains?
I was present on June 9th and June 10th of 2020 for the search warrant that was executed at Chad Daybell's property, where we located the remains of JJ and Tylee.
Your Honor, I'm going to ask to be allowed to publish State's Exhibit 170C, D, E, and H,
All right, can
one
you,
at a time.
with Exhibit 170, what does that entail in total?
The Exhibit 170 runs from 170A to 170U. And then there are some additional portions of it. The packet or the portion that I'm focusing on deal with images taken from the body recovery site.
Okay, and that's an admitted exhibit, correct?
It is.
Okay. Thank you for the clarification there. So you've requested 170 C, D, and H.
E and H.
Okay, those may be published.
Thank you. And Agent Hart, I believe there may be a pointer up there if it's helpful with your testimony.
Got it.
And for the record, I'm currently publishing C. Agent Hart, can you tell us if there's anything within this image that you noticed when you were on scene?
Yes, I think there's some better photographs, but this is a photograph of the location of JJ's burial, which you can see kind of in this area.
And I'll move now to States Exhibit 170D. And when you said there were some photos showing it a little bit better, is this one of those?
Yes, this demonstrates what we look for when we're searching for a clandestine grave site. One of the telltale signs is a change in the plant growth that's fairly distinctive. So you can see consistency all around, but in this rectangular area here, you have a different color of plants, as well as just some lack of growth. And so as you look, you can see a fairly distinctive area here. And this is what I observed as we were doing our initial survey of the property.
And now publishing 170E. Does that show anything additional?
It's just a closer demonstration of the a pretty specific line. And as we felt in the dirt, you could actually feel a seam where the sod had been taken up. And again, just an indication that that may be an area where digging has taken place, which proved to be true.
And when you talk about you can actually feel, do you mean with your hand?
Yes.
And now publishing 170H. And do you recall what is in this image?
Yes, as we were walking the property, we have probing sticks, and that's a way to push a rod into the earth. On that spot where we've shown the different growth, I couldn't penetrate that area with a probing rod. And as we took up the first layer of sod, we found a board and rocks, which is what I was hitting with the rod as I was attempting to probe that site.
And again, that's something that you had done previously in your career?
Yes, I've had specific training for that. And prior to that time, I had personally been involved in search warrants with the exhumation of burial sites.
And once those things were removed, what was found underneath those?
JJ's body.
After the recovery of the children's bodies, at any point, did you attempt to speak with the Daybell children?
Yes, myself and another agent went over to their residence, which is kitty corner to the Daybell property, on the evening of June 9th, and spoke with them at length about what was taking place.
Was it your understanding initially that they would agree to speak with you?
That's the request that I made to them. We explained that we had some things that we wanted to tell them and talk with them about, and asked if they would sit down and meet with us.
At some point, did they decline to meet with you?
Initially, they agreed to meet with us. and then the following day declined to keep that appointment after speaking with Chad Daybell.
Judge, I'm going to object at this point. There's no foundation to suggest that information. I'm going to move to strike.
It's overruled.
Agent Hart, as part of the investigation, and I think we've talked about this before, but did you review some iCloud data?
I spent well over 100 hours reviewing iCloud data, yes.
Do you recall what iCloud accounts those were?
There are two. There's one entitled Lori for Style at iCloud.com, and the second is called Lolly Time at iCloud.com.
And who were those accounts ultimately associated with?
Both of those accounts were registered to or subscribed to Lori Vallow.
And in going through those, was that a significant amount of information?
It's a tremendous amount of information, tens of thousands of text messages, multimedia messages, voicemails, thousands upon thousands of photographs, videos, emails, everything that you would find on a modern smartphone. The iCloud is simply a cloud storage device for all of that content.
And in preparation for your testimony today, did you prepare an exhibit?
Yes,
Do you believe that exhibit would assist you in testifying today?
it would.
Do you believe the exhibit would assist the jurors in understanding your testimony?
I do.
Your Honor, I'm going to hand to the court what's been marked as Exhibit 183B. I will note there are printouts of a PowerPoint. The PowerPoint or the exhibit itself is actually contained within Jump Drive.
All right.
And with the printout, I do have a courtesy copy for Your Honor as well as counsel and one for the court.
Thank you.
And if I may have the witness handed a copy of 183B, the printout.
And Judge, could we have a sidebar, please?
Yes. All right, thank you, counsel. Based on that sidebar, there's a evidentiary ruling the court is going to need to take up on the record, but outside the presence of the jurors. I think this will be a quick argument in lieu of a break here. If we could just have the jurors line up in the hall, please. And we'll go on the record with the objection. Once the objection's resolved, the jurors will come right back in.
All right, wait.
All right, thank you. Please be seated. We're outside well, in the courtroom, the jurors have been excused for hearing on an evidentiary objection. The state's proposed Exhibit 183B. Defense has an objection at this point, and I found it's proper to take it up outside the jurors' presence so that any reference to what may not come in would not be heard by them. So, Ms. Blake, perhaps if you'd give additional foundation of what the proposed exhibit is, and then I'll hear any objection from the defense.
Yes, Your Honor. The exhibit is content from the iCloud accounts associated with Lori Vallow, that Lori for Styles and Lolly Time. Both of those are stipulated to exhibits, meaning the entire content has been stipulated to come in. This particular proposed exhibit is excerpts directly from those accounts, I believe mainly from the Lolly Time account. This was turned over to defense counsel at the end of January as a proposed exhibit. There was a few modifications made and the modified version was provided to counsel. However, the modifications made included removing 3 slides in their entirety. There were no other additions or changes made at all to the exhibit. So given that, that's just what the exhibit is.
All right, thank you, Ms. Blake. Mr. Pryor, is there an objection from the defense?
Judge, the objection is not the admission of the exhibit. The objection is that counsel throughout this trial has had a repeated course of action of providing me summaries either late the night before the testimony is to incur or the morning of or late in the evening on, again, the day before. I'm not objecting to the admission of the emails from Lolly Time. In fact, that was a stipulation of the parties that those be admitted. What I'm asking for is an opportunity to ensure that what Ms. Blake is representing doesn't contain anything outside of what was stipulated to. And the fact that I got an email, I believe it was last night or the night before, that there were modifications made to this, I want to ensure that those modifications are as they were represented, and I ought to be afforded that opportunity.
All right, Ms. Blake, to be clear then, the modifications were taking things out of the proposed exhibit, not adding things in. Is that correct?
Correct. None of the remaining slides have been modified or altered in any manner from what was turned over in January. The only modifications were the removal of 3 slides.
Okay, well, considered the objection here then. First, expressly was indicated there's not an objection to the admission of the exhibit. So with that and it being offered, the court will admit Exhibit 183B. In terms of the timing, while I understand it's certainly difficult in the middle of trial to be dealing with any modifications because this involved the taking out of some information, not adding it in, I think the court could presume that defense counsel has had an opportunity to review that. So I'll have it now that it's admitted. It may be published. However, if during the course of publishing you see something that doesn't seem to comport with your understanding of the exhibit, Mr. Pryor, you are allowed to make an objection, and I would ask the state be ready to stop publishing on quick notice if an objection comes up.
The state has no problem with that, Your Honor.
Okay, thank you. And I'll note also then this would be a summary exhibit under Rule 1006. Is that how the state's offering it?
Yes, Your Honor.
Okay, well, the exhibit's admitted then, and with the objection resolved, we'll have the jurors return for additional evidence.
Yes, Your Honor. All right, please. Result, President Counter for Your Honor.
Thank you. Please be seated. All right, we're back on the record after resolving that evidentiary issue. The court notes that Exhibit 183B has been admitted, and you can continue with direct, Ms. Blake.
Thank you, Your Honor. The state would request to publish 183B.
You may publish.
I believe the court has the original jump drive if you would like me to publish from that.
All right, we'll get that submitted.
Agent Hart, does this appear to in fact be the exhibit created by you?
It is.
And Your Honor, I'm going to pause here to allow the jurors to read.
Very well.
And Agent Hart, can you indicate who these messages were being sent from and who these messages were being sent between?
These are messages between Lori Vallow and her brother, Alex Cox.
And can you read the date of these messages into the record?
These three messages are from March 20th of 2019.
When we look at these particular messages, what about them caught your attention?
Alex Cox was a figure during the course of our investigation, and what caught my attention about this particular interaction between Lori Vallow and Alex Cox is in line 1837 that Lori Vallow had to check everything with her quote source to make sure she had her information correct, but that it was really good.
Did this indicate to you that Lori herself didn't have this information?
Yes, that's why I think it's significant.
And did you also see in here that Lori was then going to pass that information on to Alex?
Yes,
Did you learn through the investigation who Lori's source was?
Foundation.
Sustained.
Through the investigation, did you see messages from Lori to Chad quite frequently?
very frequently.
In those messages, was she oftentimes requesting information?
Yes.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, would you indicate the date these were sent into the record?
Yes, these four text messages were sent on July 18th of 2019.
What had happened 7 days prior to these messages?
Lori Vallow's husband, Charles Vallow, had been shot and killed.
Through your investigation, did you learn who Hillary was a reference to?
Yes,
And who was that?
Tylee.
And there's also a name in here, Raphael. Did you learn who Raphael referred to?
Raphael is a name, another name used by Chad Daybell between he and Lori Vallow very frequently throughout the course of their communications.
And also a name, James. Do you know who that referred to?
Yes, that is another name for Chad Daybell as referenced in the James and Elena communications between Lori Vallow and Chad Daybell.
And did you learn who Amy was in reference to?
I could not find out specifically who Amy was.
What about this series of messages stood out to you?
There were three very critical components to these messages.
Can we go through them one by one, please?
Yes,
What was the first one?
the first is line 2667. This is a text that is initiated by Chad Daybell to Lori Vallow, indicating that he has been instructed to focus his efforts on Tylee Ryan.
And what was the second thing that stood out to you?
The second thing is present in the following two lines, 2665 and 2660. Lori Vallow makes a reference to Chad Daybell or a request to find out her, meaning Tylee Ryan's percentage, as well as JJ's percentage. That word is referring to the death percentage for Tylee Ryan and JJ.
Judge, I'm going to object. Calls for speculation. Move to strike.
Overruled.
In fact, in subsequent texts, the
Judge,
exact,
I'm going to object at this point. Non-responsive. There hasn't been a question.
Sustained.
Agent Hart, you were explaining why those lines stood out to you. Could you please continue your explanation?
the words death percentage are used in subsequent texts. This series of text messages is the first in a series of texts that will take place over the next 3 weeks between Lori Vallow and Chad Daybell. In those text messages, in varying degrees of detail, they refer to the death percentages of Tylee, JJ, and Tammy. Those text messages over that course of 3 weeks.
Judge, I'm going to object at this point. It's again becoming a narrative.
Sustained.
And what course of time or what period of time did those messages cover?
Approximately 3 weeks.
And when we look at that line 2660, there's reference to specific percentages, it appears.
Yes.
Could you talk about that a little bit?
Again, this is a message from Chad Daybell to Lori Vallow wherein he is indicating his death percentages for Tylee at 0.13 and for JJ at 99.99, which follows with a reference that Raphael or Chad Daybell had visited JJ and told JJ to follow Amy into the light, which is a common reference for death.
In this particular message, there's also a reference to turning up the pain to 10. Who said that again?
Chad Daybell,
And also a reference to placing a spiritual virus in her. Who said that?
Chad Daybell,
And then in that last sentence, did anything about that stand out to you?
well, line 2660 is a specific conversation regarding the deaths of Lori's children.
Judge, I'm going to object. That's calling for speculation and conclusion, and I'm going to move to strike.
I'll sustain the objection and strike the response.
Based on your investigation, your experience and review of these messages, what did you believe line 2660 to be referencing?
It's referencing their death percentages,
And who are they?
Tylee and JJ.
And what is Lori's response to that, to the talk of death percentages of her children?
That it's sweet and she misses Chad Daybell desperately.
Was this the first time in these messages that you had seen reference to these death percentages that you can recall?
Yes, this is the first message, and there are several that follow in the next 3 weeks, and then later on, there are additional similar conversations regarding Tammy.
Were there additional messages on July 18th of 2019?
Yes, this conversation continues for the next couple of slides.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, you indicated these are a continuation from the messages on the previous slide. Is that correct?
Yes.
What about these particular messages stood out to you?
Primarily lines 26, 22, 2608, and 2607.
Through the investigation, did you become familiar with what has been referred to as the James and Elena story?
Yes.
Did you become familiar with some of the texts that appeared to be a reference or continuation of that story as well?
Yes.
And do you know were you familiar with the term storm?
I am.
And did you know what that was in reference to?
Yes.
And what was that?
That's Chad Daybell's penis.
And Chad's texting to Lori to grab him by his storm and he'll
Judge, I'm
follow
going to
her
object
anywhere?
at this point. It's somewhat leading. And I think
Sustain on leading.
What else about that series of three messages caught your attention?
Well, throughout Chad Daybell and Lori Vallow's relationship, Lori is pushing Chad Daybell. And so I included these to show Lori Vallow questioning. Chad Daybell remarks that he'll follow her to the end of the universe. And her response is when? When might that be? Chad's response is in reference to a planned trip that he would take the following week, July 24th through July 26th of 2019, to be together with Lori Vallow. That's the reference to Wednesday evening to Friday. But we see Lori Vallow pushing Chad Daybell as it relates to their relationship.
So it would be Chad and Lori were going to be together physically or at the same time.
Yes, Chad Daybell traveled to be with Lori Vallow for a period of 2.5 days.
And again, during this time, was Tammy Daybell still alive?
Yes.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, I believe you indicated these are a continuation as well from the previous two slides.
They are.
What was it about these messages that caught your attention?
Primarily, there was two things.
And can we go through them one by one?
Sure.
What was the first thing?
The first is again, we see Lori Vallow manipulating Chad Daybell. In the prior slide, Chad Daybell had indicated that they would have this time together Wednesday through Friday. And Lori Vallow's response to that is, then what? And she then says, back to crying and saying goodbye, back to the box, as a reference to being trapped with their inability to be together.
And at this point in time, Charles Vallow has been killed,
This is 1 week following his death.
but Tammy's still alive.
Correct.
And what was the second thing?
The second thing is line 2603, which is Chad Daybell's response to her. And he references that extreme changes are coming for him, and he welcomes those changes.
And do you recall from previous testimony references Chad also made about feeling trapped?
Judge, I'm gonna object. It's leading.
Overruled.
Yes,
And do you recall approximately, or do you recall what those statements were, what that was in reference to?
yes, that conversation took place at the conclusion of this trip that they're talking about. So that would have been on July 26th of 2019, where Chad Daybell references the Harry Potter stories and feeling trapped, having to live under a stairwell, and he gets to escape occasionally to have adventures with his goddess lover.
And when you look at that line 2603, there's a reference to extreme changes. Did that catch your attention?
It did.
What did you, through your investigation and experience, what did you believe that to be in reference to?
Judge, calling for speculation. Objection.
Overruled.
Well, within 3 months of this date, Tylee, JJ, and Tammy are all dead.
Moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you indicate the date these messages were exchanged into the record?
Yes, this is July 20th of 2019.
And who are these messages?
Lori Vallow and Chad Daybell.
There's an individual reference named Blake. Did you learn who that was?
Blake is Melanie Boudreau's son.
Do you know his approximate age?
3 to 4 years old at the time of this message.
What about these messages caught your attention?
There were two things primarily that caught my attention in this series of communications.
What was the first one?
The first is, again, Lori Vallow is petitioning Chad Daybell to find out Blake's percentage. So repeatedly, we see Lori Vallow asking Chad Daybell to provide that information. Chad Daybell is the source of the death percentages.
What was the second thing?
The second thing is that this is a conversation about a 3 or 4-year-old child. And in line 2481, Chad Daybell writes that he decreased that child's pain tolerance to 1% and greatly increased his pain.
And do you recall in one of the previous slides in reference to Tylee Ryan, Chad talking about turning up or causing her pain?
Yes.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you indicate the date these messages were exchanged into the record?
July 23rd of 2019.
And who were these messages between?
Lori Vallow and Chad Daybell.
What about these messages caught your attention?
Again, two things primarily caught my attention.
And what was the first thing?
The first is, if we look at the time of these messages, there's an 11-hour gap between line 2276 and 2244. In line 2276, Lori Vallow petitions Chad Daybell to check JJ. In the subsequent line, 11 hours later, she's asking Chad Daybell to check Tylee to see if Tylee has been, quote, switched. And so these messages are 5 days after the initial first message that I ever located regarding death percentages. And so this is now the second time that I could find in the review of the iCloud where Lori Vallow is asking Chad Daybell specifically to check on JJ and then to check on Tylee. So that's the first thing that stood out to me.
And Charles Vallow had been killed not long before these messages.
12 days prior.
What was the second thing that stood out to you?
The second thing that stood out to me is in line 2241, which is Chad Daybell's response to her. And he replies that, yes, Tylee has been switched. And he says, let me know when you can talk and I will explain it. So Chad Daybell is the one who will explain to
Judge,
Lori
I'm going to
Vallow.
object at this point. Speculation.
And what was the last part of that answer?
Lori Vallow is making inquiries to Chad Daybell, and Chad Daybell tells her, I will explain it.
Prior to Charles being killed, are you aware if he was deemed to have been possessed?
He was.
And ultimately he was killed.
He was.
Moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you read the date of these messages into the record?
Yes, July 26th of 2019.
So this is just 3 days after those last messages we looked at.
Correct.
What about these messages caught your attention?
That the pattern of Lori Vallow asking Chad Daybell to check is continuing. So on line 2119, Lori Vallow writes, need you to check JJ, and references his behavior, which was a departure from what was normal for him.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you read into the record the date these messages were exchanged?
These messages were also, as with the previous slide, on July 26th, 2019.
What about these particular messages stood out to you?
Well, in response to the previous slides, request by Lori Vallow to Chad Daybell to check JJ, Chad Daybell replies that essentially JJ is still his true self, but he indicates whoever told Lori Vallow that JJ was calm and watching movies had been lying. So Chad Daybell answers Lori Vallow's inquiry regarding checking JJ.
And looking to that next message, are you aware who Brighton is?
Yes,
And who is that?
Brighton is another of Melanie Boudreau's children.
And the name Mel there, do you know who that was referencing?
That's Melanie Boudreau.
Was there anything about that next message that caught your attention?
This next message is is somewhat vague, but we see a reference to a big plan, which is a word that we see repeatedly in conversations between Lori Vallow and Chad Daybell referencing their plans.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you read the date of these messages into the record?
Yes, these 4 messages were exchanged on July 29th of 2019.
Who were the messages being exchanged between?
Chad Daybell and Lori Vallow.
What about these particular messages caught your attention?
At this particular time in the investigation, Lori Vallow, Melanie Boudreau, and their children, as well as Alex Cox, had decided to take a trip to the California coast. And so these messages were sent to Lori Vallow as they were driving in the car, as Lori Vallow, Melanie Boudreau, Alex Cox, and the children were driving to California. And so Chad Daybell makes an offer to Lori Vallow to cause pain to the 2, quote, threes that she was riding with.
And looking at that, at the line 1872, did any of that catch your attention?
Of course. In line 1877, the 2 threes are referencing 2 of the children that are in the car with them. And in line 1872, Chad Daybell indicates that he would at least give them a reason to scream, indicating a supposed ability to cause physical pain to those children.
After offering to cause physical pain to the children, what were the next things he said?
He told Lori that he loved, cherished, treasured, and adored her. The wonderful memories just keep coming back. She was mesmerizing, and that Raphael, which is the name for Chad Daybell, is one lucky guy.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, would you read the date of these messages into the record?
These messages were exchanged on July 30th of 2019.
And who are these messages between?
Chad Daybell and Lori Vallow.
What about these particular messages caught your attention?
There were three very critical components of these messages.
Can we start with the first one?
Yes.
And what was that?
The first one is in line 1781. This is a text initiated by Chad Daybell to Lori Vallow. And you can see that Chad said he had the inspiration to go back to my original death percentages. So this is the first time that we see the full phrase of death percentage, and it is attributable to Chad Daybell by the use of the word my. And then he indicates that these death percentages helped him track Charles, which is a reference to Charles Vallow. Ned is the name of the demonic entity that was alleged to be possessing Charles Vallow. And then he indicates that Tammy is very close. Her death percentage has fallen steadily, and concludes with, "It is encouraging!" exclamation point.
Do you also see the reference in there to Hiplos or Iplos?
Yes,
Do you know who that's in reference to?
that's the name of a demonic entity that was supposed to have been inside of Tammy Daybell.
And you said Tammy
Um,
on Hiplos.
Yes. So it says Tammy is very close. Her percentage, meaning Tammy's percentage, has fallen steadily since Hiplos left. So that entity is now out of her.
Do you recall if Hiplos was an entity that was indicated to be associated with Charles Vallow?
Judge, I'm going to object. That's leading.
Sustained.
Do you know who else Hiplos may have been associated with?
There was another reference to that using that same demonic entity name with Charles Vallow.
What was the second thing that stood out to you?
The second thing that stood out is this reference to Chad Daybell's death percentages that helped track Charles Vallow. Charles Vallow didn't have a heart attack or pass away in his sleep.
Judge, I'm going to object. It's narrative.
Overruled.
He was shot and killed. And so these death percentages by Chad Daybell are not simply a reference to natural deaths.
And what was the third thing?
Well, the third thing is in lines 1779 and 1778. Lori's response to Chad is to inquire, what is the percentage now? Meaning, what is Tammy Daybell's death percentage? And then she follows that up with yet another inquiry. This would be now the third inquiry about JJ's death percentage. Chad Daybell responds, Tammy is at 3, JJ is at 2.
And based on your review and your investigation, in relation to death percentages, what was the indication the lower the number got?
Well, it's not consistent. So you have references where the lower the number, the closer to death they are. And then you have references where the higher the number, the closer they are. So in the previous communication, you saw Chad Daybell indicate that JJ was at 99.99. And he instructed JJ to follow Amy into the light. In this occasion, we flipped and they're at the opposite end of the spectrum, saying that Tammy is at 3 and now JJ is at 2 versus the prior message. So there's a lack of consistency, but the higher the number in one case, the lower the number in another.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you indicate the date these messages were sent into the record?
Yes, July 30th, 2019. These are a continuation from the previous slide.
And what about these messages stood out to you?
Well, first, Lori Vallow's response back to Chad Daybell after receiving his answer that I believe it was Tammy was at a 3 and JJ was at a 2. She replies 2 and 3%, not 0. So we see Lori Vallow pushing 0, meaning the time has come for those individuals to die.
Judge objection calls for speculation. I'm going to move to strike, Judge.
Well, the objection's not timely. I'll overrule it at this point, but Ms. Blake, I am concerned if the witness is making his own interpretations of these messages, not based on the investigation. So if you could direct the examination that way, that'll help with the objections.
And in coming to that conclusion, was that based on your experience and your review of the information?
Yes,
What else stood out about this particular message?
line 1776, where Chad Daybell says, "I will explain when we talk," indicating he is the source of what's happening.
Was that consistent with your review of these messages?
Yes, we see that exact phrase multiple times. "I will explain."
Anything else about this particular series that stood out to you?
Well, lastly, again, we see how Lori Vallow is attempting to manipulate Chad Daybell. She concludes this conversation with, "Okay, still feeling hot for you."
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you indicate the date these were being sent into the record?
These two text messages were also on July 30th of 2019.
And who were these messages between?
Chad Daybell and Lori Vallow.
What about these particular messages caught your attention?
Two things.
What was the first one?
The first is a continuation to further explain Chad Daybell's death percentages. In the second sentence, he references this chart that checks what percentage mortals are still in their body, and then indicates that it worked for his friend's wife who died. And so we see just a further explanation of death percentages, and that this is talking about physical, real death, not spiritual death or some other kind of death.
Was that chart that was referenced, was a copy of it ever located?
No, we could never find the actual chart. I I can't account for where it might be.
And what was the second thing that stood out to you?
Well, there are two more. The first is that he references Tammy Daybell, his wife, that she said she felt lightheaded as if her body and spirit weren't connected.
And then what was the third thing?
The third thing is in line 1773, where Chad Daybell indicates he would update the list and figure out Brandon, Adam, and others. The reference to Brandon is Brandon Boudreau. And on October 2nd of 2019.
Judge, I'm going to object at this point. This is definitely becoming a narrative.
Sustained.
Who was Brandon referencing?
Brandon Boudreau.
Do you know of something that happened in relation to Brandon Boudreau?
Yes,
What was that?
on October 2nd, 2019, an attempt was made on his life.
Are you aware of an attempt that was made on Tammy Daybell's life?
Judge, I'm going to object. Calls for speculation.
Overruled.
I am.
And when was that?
October 9th, 2019.
Moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you indicate the date these images were sent?
These were both sent on August 7th of 2019.
Were you able to, looking at that first image there, who is that?
That is Chad Daybell.
Can you tell from the photo what type of building he may be in?
Yes, it's the lobby of an LDS, an old LDS church.
And who sent that photo?
So the photo of Chad Daybell was sent by Alex Cox to Lori Vallow with the caption, "Look at the bubbies."
Do you know what Bubbies was a reference to?
That was a word.
Judge, objections, calling for speculation, no foundation.
I'll sustain that without additional foundation.
Through your investigation and review of messages, were you able to determine what Bubbies was in reference to?
Yes,
And what was that?
it's just simply a pet name that Lori had for Chad Daybell and Alex Cox or other men in her life.
And could you see the time that that message was sent?
10:48 a.m.
And turning to the next image, who are we seeing in that photo?
That's a photograph of Alex Cox.
Does that appear to be in the same location?
Yes,
And what time was that message sent?
1 minute prior on 10:47 a.m.
Who sent that message?
Chad Daybell,
And who did he send it to?
Lori Vallow.
What was the caption that Chad included?
Two exalted beings.
Was Tammy Daybell still alive on August 7th of 2019?
Yes,
Moving to the next slide, I'm going to pause to allow the jurors to read. Would you please indicate the date these messages were sent into the record?
These messages were exchanged on August 7th of 2019.
Who were the messages exchanged between?
Lori Vallow and Chad Daybell.
And these messages were sent on the same day as those two images?
Correct.
What about these messages stood out to you?
The thing that stood out the most in this text series is in line 1391 in the text from Lori Vallow to Chad Daybell, where she indicates, "We are both so tired of taking care of demons. We are weary. Please ask the Lord to take them!" Exclamation point.
And Lori was sending that request to Chad?
Correct.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you indicate the date these messages were sent into the record?
These messages were exchanged on August 10th of 2019.
And is it fair to say that some of the next slides are going to correspond with the same date?
Yes, it's this slide and the next 5 slides are all a continuous exchange of messages between Lori Vallow and Chad Daybell.
What about this first slide with these messages caught your attention in relation to the investigation?
What first caught my attention is we see now, I believe, the 4th time that Lori Vallow is asking Chad Daybell to check on JJ. And Chad Daybell responds once again that JJ is still JJ.
And at this point, Charles has been dead for almost a month.
Correct.
Through the investigation and your review of the information in this case, did Lori have help with JJ prior to Charles passing?
Absolutely.
And who was helping her with him?
Charles Vallow spent a considerable amount of time and effort in caring for
Judge, I'm going to
JJ.
object at this point. Move to strike. There hasn't been sufficient foundation.
Sustained.
Through the review of iCloud, did you review videos?
Yes,
Did you review other content?
yes,
In that content, were there references to Charles taking care of JJ?
many.
And at the time these percentages are being pursued, Charles is no longer able to assist with JJ.
Correct.
Moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, you'd indicated this is a continuation of the previous slide.
Yes.
And what about these particular messages caught your attention?
Well, primarily line 1170. In the last line of the previous slide, Lori Vallow asks Chad Daybell if JJ is at 0 yet. And we see Chad Daybell's response to that question. Yes, he's at 0. He was probably partly through the veil, talking to people both light and dark.
And on the previous slide in this one, we again see a reference to Blake. Again, who was Blake?
Blake is Melanie Boudreau's child.
Moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, is this again a continuation of the previous two slides?
It is.
Who are these messages being exchanged between?
Lori Vallow and Chad Daybell.
What about these particular messages stood out to you in relation to the investigation?
This particular conversation is some of the most critical evidence that I located within the iCloud. It represents the clearest and most specific reference.
Judge, I'm going to object again. This is speculation.
Overruled.
It represents the clearest and most specific reference to a plan regarding Tylee and JJ. That plan is spearheaded by Chad Daybell.
Judge, I'm going to object at this point. That's a narrative
Also,
and it's argumentative,
it's sustained.
and I'm going to move to strike.
That last part of the comment is stricken.
When you indicate that there's the reference to the plan, who is asking if there's a plan?
Lori Vallow is asking Chad Daybell if there is a, quote, perfectly orchestrated plan to take the children.
What is Chad's response?
Chad's response is that there is a plan being orchestrated for the children.
Where were Tylee and JJ's remains ultimately located?
On Chad Daybell's property.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, is this also a continuation from some of the previous slides?
Yes, it is.
Who are these messages being sent between?
Lori Vallow and Chad Daybell.
What about these particular messages stood out to you in relation to the investigation?
Well, first off is line 1159. In the previous slide, there was a question about a plan and a verification of a plan. Then Lori Vallow asks Chad Daybell, what should I be doing? And in the subsequent line, 1158, Chad Daybell provides an answer to her, which concludes with being unencumbered and fully free.
There's also a reference in that to telestial issues. Do you know through the investigation what telestial would be referencing?
I do.
What is that?
Issues pertaining to this earthly life.
And in some of the previous messages, Lori was inquiring about the death percentages of Tylee Ryan and JJ Vallow.
That's correct.
What else stood out in relation to these messages?
Line 1155 is very critical. Chad Daybell texts Lori Vallow and indicates that JJ is, quote, getting close. When I was sitting across from him eating bacon, I sensed he was barely attached to his body.
Do you know when the last time JJ Vallow was seen?
I do.
When was that?
September 22nd, 2019.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, again, is this a continuation of some of those previous slides?
Yes, it is. And I believe there's one more that is part of this conversation.
I'm going to move to that slide and pause to allow the jurors to read that one as well. And going back to that previous slide, what about this one caught your attention?
Well, this is just the continuation of the conversation. I think the more important content is on the following slide.
And what about these particular messages stood out to you?
Primarily lines 1117 and 1113. In 1117, Lori Vallow, as we've seen previously, says to Chad Daybell, I can't wait, literally can't wait. I have no patience. I want you now, with 2 fire emojis. And then we see Chad Daybell's response to that, which point.
Based on your investigation, your review of the content of the iCloud, what did you determine the finish line to be?
The finish line was for Chad Daybell and Lori Vallow to live this fantasy life together that they had constructed and referenced in this plan that they're talking about.
Did that include being unencumbered?
Judge, I'm going to object. Calls for speculation.
Overruled.
Unencumbered from her husband and her children and from his wife. Yes.
Your Honor, looking at the time, I don't know if you'd like to do the mid-morning break.
I think this would be a good time for that. Thank you, Ms. Blake. We will take our mid-morning recess. We'll come back on just 10:30 or perhaps shortly before 10:30. Thank you.
All rise, please.
Pleasure to be here with you all. Thanks for watching the trial of the people of the great state of Idaho versus Chad Daybell. It's getting close to wrapping up. The prosecution has indicated that this is going to be their last witness, which is, of course, draws great attention to what will the defense do. As you may recall, the defense has said that they are going to recall lots of witnesses. And so we are here with great anticipation as to see what the defense is going to do. Now, this is kind of a big wrap-up summary. You know, here's some more emails that make it look like certainly one could reasonably infer from the evidence that Chad knew something bad was going to happen to JJ, and he could hardly wait. Like you would almost think like one could reasonably argue that he was, what's the word I'm looking for? Knew what was going on. Now, obviously that's a decision for the jury to decide, but we need to see if when this witness ends, they just took their mid-morning bear. They being the government just took the court, I guess, actually, sorry. The court just took its mid-morning break. The prosecutor must be getting very, very close. It's a little trick in the trade is if you want to make sure you do everything, but before you end, you ask for a break. Hey, Judge, this is a good time to break. You know, maybe we could resume tomorrow morning so I can refine my direct or cross-examination of this witness. You don't get to say that, but that's what's taking place. So I think that's what the DA was doing. She's just about wrapping it up, wants to end on a note. They're thinking about it. Come back, ask a couple more questions. What does this mean to you, detective? Well, it means that Chad Daybell's guilty. Oh, okay. Objection by the defense. And there you go. But so then what will take place is that the jury, depending on how long the cross-examination goes, they'll probably take their lunch break. At some point, the prosecution is going to rest. You know, they're double checking to make sure they have met all the elements. They're literally going through their little checklist, making sure they've got all the elements as it relates to the charge, that they presented some evidence for that to go to the jury, and so that it won't be sustained on a motion for judgment of acquittal. At that point, the prosecution will eventually rest once they think they're satisfied with the presentation of their evidence. The jury will be excused, and then the defense will make a motion for a judgment of acquittal. Now, remember, the motion for judgment of acquittal, they're rarely granted, usually only if the government forgets to present some evidence that to an element of the offense charged. Not going to happen in this case. The judge will say, I have to view the evidence in the light most favorable to the prosecution, drawing all inferences in favor of the prosecution. And it's not the judge's job to substitute themselves as a 13th juror and let the jury decide. Then the big question will be, is the defense going to present a case in chief? Remember, the defendant never has to prove himself innocent. The defendant never has to call any witnesses whatsoever. The defendant has an absolute right not to testify. And if his attorney requests it, he will get an instruction presented to the jury stating that you cannot infer anything negative by a defendant's right to remain silent. So then the issue really is, I wouldn't say the issue, but the moments of suspense is going to be, are they going to call Chad Daybell to the witness stand? Now remember, the lawyer has certain ethical duties. Obviously, they cannot put up perjured testimony. So if, for example, Chad, hypothetically speaking, has told his attorney, yeah, you know what, everything they said, yeah, that's pretty much what happened. But since they're trying to kill me, we're going to go to trial and we're going to see what we can do. The attorney then cannot then put him on the stand and say, oh, none of this ever happened. I had no idea, right? Now, I can tell you as a defense attorney, I have won more cases when the defendant does not testify than when they do. And the reason why I think that is because the jurors are looking at all this evidence when the defendant doesn't testify and like, wow, did the prosecution really prove their case beyond a reasonable doubt? I'm looking at these instructions that the judge gave me and I just don't know. But when the defendant testifies, all of a sudden the focus is to him. And if the jury doesn't like or believe the defendant's story or the events, it's like game over. Yeah, we don't believe him. We just don't believe him. And because oftentimes the defendant is their own worst enemy. Now, we've never heard Chad Daybell say anything, other than recordings and things like that. He didn't give an interview to the police. He lawyered up immediately. So it'll be interesting to see what his decision ultimately is and understand the decision for Chad Daybell, if he chooses to exercise it to testify, is his decision. It is a very personal decision. And it's not the attorney's decision to say whether he testifies or not. When I say it's a personal decision, he is the only one that ultimately is responsible for making that decision. Now, some courts will inquire. Here, for example, where I practice law, they do what they call a Curtis advisement. It's based upon a case, People v. Curtis. And it basically says that the court will advise the defendant of his right to testify or not to testify, and understand that it's an individual right, a personal right. You certainly want to listen to your attorneys, but it's ultimately your decision. So even if your attorney has advised you against testifying or advised you to testify, it's your decision. No one in the courtroom, not your attorneys, not the prosecutor, not the judge, anyone can force you to make that decision, and it has to be knowing and voluntarily made. And the courts will ask, have you made a decision whether you testify or not? Now, that decision doesn't have to be made until all the evidence is presented. If the defense has any case, the courts will inquire again. It's normal general practice. Now, once you get to the federal court system, for example, I've done several trials in federal court, many trials in federal court, I should say, and the judges never give an advisement. Sometimes if the federal judge has been a state judge, they may ask about it generally, but it's very generic. But as a defense attorney, always make that record, because one of the things that why the Curtis case where I practiced came into effect was because the defendant would lose. They would, lose the appeal. Then they would do their post-conviction stuff and say, my attorney never told me that I had the right to testify. He told me I shouldn't testify. I just believed I didn't have any decision to make. So the court said, fine, we'll fix that problem, because it was becoming a problem. And so therefore they made sure that they understand exactly what is taking place. Now, obviously a defendant has a lot to think about if he chooses to testify. First, you got to make sure they're prepared. Now, Chad Daybell has been sitting through it. What are we on, day 24, I think, of trial right now? So he gets how things are going. He sees how the good witnesses testify. Usually the police officers are better witnesses. They listen to the question, get it from the district attorney, turn and talk to the jury, and then when they're done, they go back and get the question again, and then they turn and talk to the jury, They only answer the question that is asked. They give a pause so that if there's an objectionable question, the other, the prosecutors have an opportunity to object, and then they know not to answer until the judge has ruled. So, well, we'd be curious to see if he's prepped. Then he has to recall that he is going to be subject to cross-examination just like any other witness. And obviously he doesn't have any felony convictions that are coming in. I'm not aware of any other, 404B conduct. He's not involved in any other, homicides like that as it relates to like Charles Vallow in Arizona. But that has certainly come in, but he was never charged. But it's come into evidence through this, is what they refer to as kind of res gestae 404B evidence, to lay the foundation, to give full perspective as to how all these things have somewhat unfolded. So you have to consider that. And then you have to consider, geez, my client even likable, right? I mean, let's face it. There are some people that are just not very likable. It's just the way it is. And you have to consider that. I had a guy once, he was a nice guy, but he looked scary as hell. He had like devil horns tattooed on his bald head with various other tattoos on his head. Nicest guy when you sat and talked to him. Looked scary as hell. You have a client I had a client once, man, everyone in the courtroom thought we were winning. Everyone. The court reporters are always the best judges. Like, hey, do you think, think you got shot, right? But the jury saw my client mean mugging the client, even though I told him, don't do that. Don't, act the tough guy, all that good stuff. We beat the first degree murder charge, but we lost on the second degree murder charge. And fortunately the case came back on appeal for an instruction issue. But the whole point of it that I want to tell you this story is sometimes your client's just not a likable guy. Now, Chad, we got this middle-aged guy. His attorney stated in opening statements he was oblivious to this. He had no idea what was going on. He was just as big a sucker as everyone else is. That he got played by Lori Vallow and Alex Cox, and Alex Cox did this. And, I was around, we were texting, we were in love, we were infatuated, but there was, never any plot to do this. I mean, but like I said, these last little text messages, notes that they're writing, the JJ, he's close, he's almost to the other side. If he is going to testify, you better have a really good explanation as to what you said. And the prosecutors were talking about like this fantasy world. And it's weird. Okay. All this belief about this dark side and they're going to do that stuff. To most everyday people, that's just weird stuff, right? They don't get it. But what I've noticed in the practice of law, if you have individuals that have various kind of groups, they literally live in this fantasy world. It's very bizarre to me. We were asked to take a case and involved basically people that were involved in like they're living in homeless shelters. And it's a world that I'd never been exposed to. And it's like its own little subculture, sub-universe. And they have kind of their own language, not like they're, coming up with some weird dialect, but different terminology that they use. They have, people they refer to as street mom, street dad, street brother, street sister, even though there's no biological relationship whatsoever. And they run around in this weird fantasy world like they're living in like a Mad Max movie or something. It's very weird. So then you get like the Lori Vallow and the Chad Daybell where they start thinking about this stuff. They don't kind of hanging out with these people, like-minded individuals. They start believing their own nonsense. And, I don't know if it's like a self-fulfilling prophecy or they actually believe it. They think they're going to get away with it. It's weird stuff, ladies and gentlemen. And I just don't, I don't know. I don't know. It'll be interesting to see, if he does get up and explain it. There were several experts that the defense was going to call in their case in chief. A lot of the officers, they thought we're going to, bring you back. Frankly, I don't know if that's for theatrics for the defense. Obviously there's certain things, if the prosecution doesn't get into it, the question then becomes, well, can we go off on some far-fetched, tangent when this witness is on the stand? Well, maybe you have to recall those witnesses. Generally, I'm telling you, from the defense perspective, you want that witness up there. You want to get all the good stuff that you can from that witness when they're on the prosecution's. The prosecution called. The prosecution's own witness said A, B, C, and D, right? You want that in your case. And you get to cross-examine them, which means you get to do leading questions, which means you get to suggest the answer. Why would you want to, recall them, particularly hostile witnesses, to the defense and ask them open-ended questions? So what happened next? Oh, your client, was a weird freak, and he was conspiring to kill all these kids, etc. Right? Why would you risk that? I don't know. It doesn't make any sense to me whatsoever. But usually for the defense perspective, less is more. The less you say, the better. The more that the prosecution's witnesses ramble on, the more likely they're going to make an error, the more likely they're going to say something that nobody has anticipated, and hopefully it will raise reasonable doubt. Obviously, in this particular case, people already know that Lori Vallow has been convicted. Obviously, they cannot consider that. They, being the jury, cannot consider that. But everybody knows it, right? And so 12 other people have already said, hey, she was guilty of killing these people, that there was a conspiracy. The jury's found, this other jury had found that there was a conspiracy between Lori Vallow, Chad Daybell, and others known and unknown to the grand jury, i.e. Alex Cox. So we'll have to see. We'll have to wait and see what goes on. Let me take a look at these questions. If you have a question, now's a good time to set it up. I'm with you, Scott. Alternate universe. Yeah, it's, like I said, I consider myself, I try to keep up on the news. I try to keep up on the trends of the world, so to speak, because I do trial work, and I, okay, what is this person's perspective? What do they think? How is this going to play out if I have to, if this person's on my jury? So I try to keep up kind of with the trends. I try to keep up with various things. And, but there's some of the stuff I just don't get. And this people that want to go live in these pretend universes, I just don't get it. I know, I guess some people can't go into these, what are they, meta universes or whatever, where they buy stuff. Hey, if that's your thing, knock yourself out, man. I'd rather go do something like real. It looks cool. I'll try it once, I guess, but I would rather, go out and do real world stuff. But I see more and more of these stuff where the people are literally just like, and they believe it, but they know it's pretend. And they're pretending. So it's not like they're incompetent or, but do they have mental health issues? I'm just seeing more and more of it. And, we've always had religious cults, I guess Utah's had a couple too, but I'm trying to think of anything in Idaho that jumps off the top of my head, but mostly it's, Utah, or people going down, like a Jim Jones type of thing down in, Ghana, stuff like that. But, it just takes one charismatic personality, and all of a sudden these people will start doing whatever somebody else says to do. And was the charismatic personality in this case, Lori Vallow? Did she play this guy, or did she come out and say, hey man, here's my intentions. I want to be with you, Chad Daybell. And the only way I'm really going to be with you, that we can really be together, is got to get rid of all these, hindrances in the way. Well, first of all, your wife, and if we get divorced, she's going to get half, and gee, we're not going to have any money, and we got to get rid of these kids because they're really expensive. But hey, if we can make them disappear, we're going to be able to get all this money from Social Security because, their dad is dead, and disabilities and things like that. it just depends. Oh, hey, Scott, define charismatic. Well, it just depends. Somebody that can really, inspire people to do great things. A leader, I guess. Or in this particular case, maybe Chad was just completely blown away that, he's got some middle-aged guy with his dad bod writing, bad novels in his basement, so to speak. And then all of a sudden, this girl who's, probably hotter than anything he's ever had in his life, has interest in him, and he just doesn't know what to do with it. And he'll be doing everyone. He was, being read around like a little dog, looking for a treat. So yeah. But we'll just have to, we'll have to wait and see. And this is what you got to love about trial, right? This is, it's supposed to be scripted. This is supposed to be, you try to script a trial the best you can, right? It's theater with the unknown of what the hell is somebody else going to say. Most of the time, you know what they're going to say. Most of the time, what you think they're going to say, they're say. Every now and then, something goes completely haywire. Everybody has the evidence. They all pretty much have the same facts. It's basically just, how do you argue and spin those particular facts or lack thereof in that particular case. So it's going to be interesting. It's going to be interesting to see. Like I said, the prosecution's wrapping up. Frank, did he say what time he's coming back from his break, the court?
No.
They just gave their mid-morning break.
Yeah, mid-morning, like 15 minutes.
Hold on a second. Can you mute my mic real quick?
Yeah.
Sorry, had to take a little break. Assistant had, somebody got arrested for an attempted murder and previous client, but well, why aren't you there? Haven't been retained. Somebody needs to come retain me. I'm not going to enter my appearance on a case where I have not been retained. Somebody needs to pay me. If they're not going to be there, then that's the way it is. Nothing personal. It's nothing personal. You got to play. You got to pay for Scott to jump in and play, so to speak. That's just the way it is. And so my assistant was letting me know that the mother was not happy. Well, guess what? I don't work for free. So it's just the way it is. So excuse my interruption there, but that's what we had to do. So, hey, let me know in the comments so far. Obviously, it's kind of this was a redo of Lori Vallow's trial, but what do you think is the worst evidence? What do you think is the worst evidence that they've presented here as it relates to Chad Daybell? It's usually the defendant's own words that get them. That's been my experience. There's something that the defendant says somewhere along the line that his own words, his or her own words, come back to bite them in the butt, which usually means a conviction. And you can say, well, you don't understand the context in which that was made or anything along those lines. You simply have to be able to explain that away totally and completely. All right, here we go. See, the prosecution is wrapping up. Got
Thank you. Please be
detective up
seated.
on the stand. Let's go back to the court, and then we'll see what the
All right,
cross-examination
Mr. Bailiff,
is
we'd
like.
like the
And,
jurors brought in, please.
now it's getting good.
All right, please. Here's our President Counter for you, Your Honor.
Thank you. Please be seated. All right, we're back on the record on CR 22-21-1623, State of Idaho versus Chad Guy Daybell. Continuing with direct examination. Agent Hart, if you'd like to continue, Ms. Blake, you may.
Thank you, Your Honor. And may I go back to publishing?
Yes, you may.
And Agent Hart, we'd left off with this slide. Do you recall that?
Yes,
And we'd left off talking about the finish line.
correct.
Was this the last slide that was part of this particular series of texts?
Yes, it was.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you indicate the date that these messages were being exchanged?
Yes, this text exchange is from September 3rd of 2019
Who are the messages being exchanged between?
between Alex Cox and his sister Lori Vallow.
Do you know where Lori Vallow was living at this time?
Yes, both Alex Cox and Lori Vallow moved to Rexburg, Idaho from Arizona on September 1st of 2019.
Was there anything else about these messages that stood out to you?
Line 264 from Alex Cox to Lori Vallow, where he indicates the network password is too many kids. And her response is funny, exclamation point, exclamation point.
When was the last known sighting of Tylee Ryan?
Last known sighting of Tylee Ryan was September 8th of 2019.
And when was the last known sighting of JJ Vallow?
September 22nd of 2019.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, is this a continuation from the previous slide?
Yes, it is.
Who are these messages between?
Again, between Alex Cox and Lori Vallow.
What about these particular messages caught your attention in relation to the investigation?
In relation to the investigation, these few messages provide a little bit of insight as to Alex Cox's role within this small circle of people, Lori Vallow and Chad Daybell.
And in that line, do you know what the Z's was referring to based on your investigation?
I do.
What would Z's be in reference to?
Z's is an abbreviation for zombies.
And then when we look to that line 261 in particular, was there something about that that stood out to you?
Yes, Lori Vallow indicates that they're trying to get to the bottom of what we need to do to eliminate them completely. And then she indicates to Alex Cox that he would be told also. And so to me, that sheds light on
Judge, I'm going to object. It's becoming a narrative and it's calling for speculation.
Overruled.
it sheds light on Alex's knowledge, how much knowledge he has, and that he too would be told what to do or what his role would be.
In your review of these messages, was Alex included in the text regarding death percentages?
He was not.
And this message indicates Alex would be told.
Correct.
And what was Alex's response?
Excellent.
And again, those messages were exchanged on September 3rd of 2019.
Yes.
What are we seeing in this slide?
This slide contains a very short, it's just a few seconds, video that I located within the iCloud. As part of our investigation, we went to great pains to try to determine when Tylee was killed and when was the last known sighting that we could verify. And that last known sighting is on September 8th, 2019. This is a video of a trip that was taken with Lori Vallow, Alex Cox, JJ, and Tylee to Yellowstone National Park. It's the last known living proof for Tylee.
And this is 5 days after the messages about eliminating zombies completely,
Yes,
and 5 days after the messages about Alex being told what to do.
yes.
And who else was in that video?
Tylee is hugging her younger brother, JJ, and Alex Cox is standing off to the side.
Can you tell us what we're seeing in this slide?
Yes, in a similar vein, we searched for what would be the last known sighting or living proof of JJ. And this is what I located on the iCloud. It's from September 22nd of 2019 at 10:46 a.m. in the morning. Subsequent to this video, there are no other photos or videos existing in the iCloud of JJ.
And again, where were JJ and Tylee's remains found?
Chad Daybell's property.
Moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you indicate the date these messages were exchanged?
These are from September 24th of 2019.
Who are these messages between?
These are messages between Sydney Woodbury and Lori Vallow.
And in relation to this date, was it significant?
Yes,
And why was that?
the date is 2 days after our last known living proof for JJ.
What else about these messages stood out to you in relation to your investigation?
These are the first lies we can find documented by Lori Vallow regarding JJ and his whereabouts.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, there's 3 messages here that all contain a different date. Is that correct?
It is.
At the time these messages were exchanged, was Charles Vallow alive?
No,
Was Tylee Ryan believed to be alive?
no,
JJ Vallow believed to be alive?
nope,
Was Tammy Daybell alive?
yes.
Looking at the first message, can you indicate the date that was sent?
First message was sent on October 3rd of 2019.
Who was it being sent from and who was it going to?
This was a message from Chad Daybell to Lori Vallow.
Was there something about that message that stood out to you?
Yes, Chad Daybell indicated that he was so excited to go on a date with Lori Vallow.
And the next one, can you indicate the date?
It's the following day, October 4th, 2019.
And who is that message from?
That's a message from Lori Vallow to her brother, Alex Cox.
And what about that, if anything, caught your attention?
Well, at this point, both Alex Cox and Lori Vallow had moved to Rexburg, Idaho, were living in Rexburg, Idaho. And the investigation indicates that Tylee and JJ were both deceased at this point. Lori Vallow says to Alex Cox, "We are supposed to go on a quote, real date tonight, but are discussing it." And then she indicates perhaps an evening at home would be better, so we are not out and about.
And again, at this time, Tammy Daybell is still alive.
She is.
Where was Lori Vallow living at this time?
She was living in Rexburg, Idaho, which is a very short distance from Sugar City, where the Daybell residence was located.
And then looking at that last message, can you indicate the date?
October 5th, 2019.
Who was that message being sent from and who was it going to?
So this is a message from Chad Daybell to Lori Vallow. And then there will be 2 more slides that are a continuation of Chad Daybell reaching out to Lori Vallow approximately 12 hours after the prior text indicating that an evening home may be better rather than a real date.
And in that last message, can you read that last message into the record?
"Hello, sweet angel. big news about Tammy. Please let me know if you are awake and can talk. I love you, exclamation point, and then heart and lip emojis.
There's an indication in there from Chad to Lori that there's big news about Tammy. Is that correct?
That's correct.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you indicate the date these messages were exchanged?
Yes, the date is October 5th, 2019. And the times are within minutes of one another, as well as within minutes of the prior text where Chad Daybell indicated he had big news about Tammy.
And looking at these messages, were there things that caught your attention?
Yes, there's 2 text messages on this slide and then 2 more text messages. All 4 of these text messages are from Chad Daybell to Lori Vallow. I found no response from Lori Vallow to these messages. But in these messages, Chad Daybell is providing an explanation, a narrative indicating that Tammy has been switched and that there is a demonic entity that is now in Tammy Daybell's body that she wants removed. And that word removed, I think, is critical.
And do you see in here a reference to the name of the demonic entity?
Yes, the name that Chad Daybell assigns to this demonic entity is Viola.
Judge, I'm going to object, move to strike. There's no testimony regarding who assigned what.
Overruled.
We talked about the word removal based on your review of the iCloud account, your review of other things involved in this investigation. What was significant about removal?
Removal indicates the physical death of the person who has the demonic entity.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, I believe you indicated this is a continuation from the previous slide.
It is. These are all, I believe the very first text message was for 6:36 a.m. And so the final and fifth text message in this string, all from Chad Daybell to Lori Vallow, is at 4:54 a.m.
And again, what day?
on October 5th of 2019.
What about these particular messages caught your attention in relation to the investigation?
In relation to the investigation, line 769 is a crucial piece of evidence from the iCloud that is a very specific reference to the alleged crimes involving Tammy Daybell.
Judge, object. Mischaracterization, speculation, argumentative.
I'm going to sustain that as argumentative.
We had just talked about the meaning of the word removal in the investigation. Do you see reference to removal in this line?
I do. Chad Daybell writes, not fully sure of the timing for removal, but once her actions verify the differences, I don't want to wait.
What happened on October 9th of 2019?
October 9th,
Answer, Judge.
What was that?
Objection. I asked and answered.
Overruled.
on October 9th, 2019 was the first attempt on Tammy Daybell's life.
Moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you indicate the date these messages were being exchanged?
These are messages exchanged on October 19th, 2019.
What was significant about October 19th of 2019 in your investigation?
That is the date of Tammy Daybell's death.
Who were these text messages being exchanged between?
This is between Lori Vallow and an individual who wasn't identified by name within the iCloud. So I can't tell you who this is that's telling her this information.
What was significant about these messages? Or let me withdraw that. What caught your attention in relation to these messages?
Simply that someone knew that Tammy Daybell had died and then provided that information to Lori Vallow, who was in Hawaii at the time.
Do you know where Chad Daybell was at the time?
In his residence in Sugar City, Idaho.
Do you know where Alex Cox was?
Alex Cox was in Rexburg, Idaho.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you indicate the date these messages were exchanged?
Again, on October 19th, 2019.
And who were these messages being exchanged between?
These are between Lori Vallow and Chad Daybell.
What in relation to these messages stood out to you in relation to the investigation?
Primarily the timing of the messages in conjunction with Tammy Daybell's death. And then this is the first in a series of messages over the next 24 hours or so between Chad Daybell and Lori Vallow subsequent to Tammy Daybell's death.
And again, Tammy Daybell was pronounced dead on October 19th of 2019.
Yes, the call, the 911 call was approximately 6 a.m. on October 19th, 2019.
So the same day these messages are exchanged.
Correct.
And move to the next slide and pause to allow the jurors to read. And Agent Hart, can you indicate the date these messages were exchanged?
These messages are on October 20th, 2019.
And who are these messages between?
Chad Daybell and Lori Vallow.
And this is the day after Tammy's been pronounced dead?
Well, the first two messages, as you can see, are just past midnight, so they're approximately 18 hours after Tammy Daybell's death. And then the last two messages are approximately 25 and a half hours after that 911 call regarding Tammy Daybell's death.
What else about these messages stood out to you in relation to the investigation?
Well, line 527 on that date is a text from Chad to Lori Vallow, where he indicates, "I love talking with you. It's baby night, so come get me later."
Do you know where Lori Vallow would have been at that time?
She's in Hawaii.
In the messages that you reviewed shortly after Tammy's death, any expression of grief by Chad Daybell regarding his wife's death?
None.
Any expression of grief by Lori Vallow?
None.
And if you recall, when you testified previously, you'd reviewed messages around the time of Charles' death, is that correct?
Yes.
Any expression of grief by Lori in those?
None.
Any expression of grief by Chad in those?
No.
Moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you indicate the date these messages were exchanged?
October 20th of 2019 in the early morning hours.
And who are they being exchanged between?
Again, it's a continuation between Lori Vallow and Chad Daybell.
Were there things about these particular messages that stood out to you in relation to the investigation?
We're now getting into the logistics of Chad Daybell and Lori Vallow being together subsequent to Tammy Daybell's death. Lori Vallow actually invites Chad to jump on a plane and come to Kauai. And Chad Daybell responds that she should come back to the mainland so that they can spend the night together on Thursday, and then indicates wanting to look for a condo so that they could return to Kauai at the first of the month, meaning November.
And do you recall from your previous testimony reviewing some messages regarding a plan to be in Kauai?
I do.
And who was that plan between?
Chad Daybell and Lori Vallow.
Do you know if Chad and Lori were ultimately married?
They were
Where did they get married?
on the island of Kauai.
Do you know where Chad Daybell and Lori Vallow moved to?
The island of Kauai.
And this conversation took place about 25 hours after Tammy Daybell had been pronounced dead.
About 26 hours after the 911 call by Chad Daybell to indicate to authorities that his wife was dead.
Moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, would you indicate the date that these messages were exchanged?
October 20th of 2019.
And are these a continuation from some of the previous slides we've reviewed?
Yes, they are.
And who were these messages between?
Chad Daybell and Lori Vallow.
In relation to your investigation, what stood out to you with these messages?
Again, it's a continuation of the fulfillment of their plans to be together. The first line, 5118, Chad Daybell indicates a workout plan for Lily, who is Lori Vallow, that he wants to tighten his abs, get a full body tan, grow his hair out, and that it could be really good for both him and Lori Vallow.
And in that last one, 516, do you know who Raphael and Lily is referring to?
Those are, again, alternate names for Chad Daybell and Lori Vallow.
And is there an indication there about how much they will be together?
100%.
Moving to the next slide, I'm going to pause to allow the jurors to read. Agent Hart, can you please indicate the date these messages were exchanged?
Yes, this is the conclusion of this text string, and the date is October 20th, 2019.
And who are the messages between?
Lori Vallow and Chad Daybell.
Was there anything that stood out to you in relation to the investigation in these messages?
Yes. In line 515, you have Lori Vallow indicating how consuming her love is for Chad Daybell. And then of note, line 514, Chad Daybell responds, "I know exactly how you feel." I'm feeling sad, but it isn't for the reason everyone thinks, exclamation point.
Through the investigation, did you learn what the connection between Alex Cox and Chad Daybell was?
Yes,
What was that?
Alex Cox was an adherent of Chad
Judge,
Daybell.
objection, argumentative.
Sustain.
Did Chad meet Alex through Lori?
Yes,
Based on your investigation, review of messages, and other things, would Alex do as Chad asked?
Judge, objection, argumentative.
Overruled.
yes,
Did Tammy Daybell know Alex Cox based on what you learned in the investigation?
no, she did not.
Was the only connection between Tammy and Alex Chad?
Correct.
Moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you indicate the date these messages were exchanged?
Yes, October 23rd of 2019.
And who were the messages being exchanged between?
Lori Vallow and Chad Daybell.
And do you recall in a previous slide talking about a message where Alex was going to be told information also?
Yes,
What about these messages stood out to you in relation to the investigation?
in relation to the investigation, primarily lines 482 and 481 stood out to me. In line 482, Lori Vallow indicates she's had a bad dream about Al. And primarily line 481, Lori indicates that Alex Cox would be the one they use to get us both. All this alone time is not good for him. So something that Alex Cox knows is a risk to Lori Vallow and Chad Daybell.
Based on your investigation, review of the iCloud and other information, who was the they being referred to?
Objection, speculation.
Overruled.
I believe that is a direct reference to law enforcement.
What is Chad's response in line 479?
Chad Daybell indicates I will try to reach out to him later today.
So Chad was going to be the one to reach out to Al.
Correct.
And Lori was requesting Chad's help with talking to Al.
Correct.
And again, through your review of the messages, who was seeking information?
Primarily Lori Vallow,
And who was providing the answers?
primarily Chad Daybell.
I have no further questions.
All right. Thank you, Ms. Blake. All right, Mr. Pryor, cross-examination.
Thank you, Judge. Agent Hart, there was a discussion about when you're investigating missing children, who the potential folks that you would look to if you were starting your investigation. Do you recall that discussion?
Yes,
And wouldn't it be fair to say that an obvious person to look for or look at when you're investigating missing children would be a new husband?
in addition to others, yes, we would look at the parent or the husband. I guess my point was you can't put blinders on. You can't exclusively hone in on one person at the onset of an investigation.
Right, and it would be inappropriate to do that. I mean, when you're looking and conducting an investigation, wouldn't it be fair to say that any and all evidence that you obtain, you should look at all leads of evidence and not target your investigation in one channel? Would that be fair?
Yes, that's what we did.
Okay, and that's what you're, as far as the FBI, that's what you did, right?
I participated in dozens of meetings with the Rexburg Police Department and the Fremont County Sheriff's Office. It's my belief that's what all of us did.
Okay, so again, just to reiterate, it's your contention that you didn't fail to investigate or look into evidence that might lead you in a different direction. Would that be fair?
That's correct.
Okay. Now, as part of your FBI training, you talked about that you were involved in the task of looking for identifying missing children, correct?
Yes.
And as part of that FBI training, is it your experience or the FBI's experience that they ever utilized the use of a medium to try to locate or talk to children who have passed on?
It's extremely common for people who claim to have those abilities to come forward, but no, the FBI does not employ mediums in its investigations.
And I didn't say employ, I said utilize, but do you know the name Allison Dubois?
I believe I'm familiar with that name, yes.
And Ms. Dubois is a medium who claims to have the ability to talk to children and to help.
Objection, Your Honor. Counsel's testifying. Move to strike.
Sustained.
What is your knowledge of Allison Dubois?
It's my belief that she holds herself out to be a spiritual medium.
And that spiritual medium is being able to talk to children who have passed on?
I couldn't say specifically what abilities she claims to have.
Okay, and I don't want to say employ, but has the FBI or any agency you've been involved in ever employed Allison Dubois or any other medium in helping gain information?
Objection, Your Honor. Relevance.
Overruled.
Gain information about the whereabouts or the circumstances surrounding the death of a children or anyone in particular.
Well, Mr. Pryor, when I said employ, I think I mean the same thing you do as utilize,
Okay,
not pay money to. I've never spoken with Allison Dubois. I've never requested her services. To my knowledge, nobody in this investigation requested her services. Many times these people come forward offering their services and offering what they claim to have seen.
so you are familiar that there are people out there who, as a professional occupation, claim to be able to engage in these spiritual exercises, for lack of a better word, correct?
Objection, Your Honor. Relevance.
Sustained.
Okay. So would it be fair to say that if Chad Daybell placed himself out as someone who claims to be able to have these spiritual gifts, that in itself is not unusual? Would you agree with that?
I don't believe it's common.
Okay. Your concern is that the number of text messages in reference to Tammy and the children, that's where you say that's where we potentially have a problem, correct?
Given what happened to Tammy and Tylee and JJ, yes.
Okay. Now, I noticed during your dissertation with all of your exhibits, on around 8/11, August 11th of 2019, it appears that there are some captions that were left out regarding a breakup between Lori and Chad Daybell. Do you recall that?
I believe those were included in the first testimony that I provided a number of weeks ago.
Okay, and those were not included in today's testimony, is that right?
They were not part of today's testimony.
Do you have a specific recollection of what was involved in the language that was used that you could read and provide us in terms of testimony regarding those emails?
Yes, I can certainly give you my best recollection. It won't be verbatim, and if you want verbatim, we'd have to go back to the exhibit that was used during my testimony previously.
And Judge, previously, the state and the defense stipulated to the admission of the Lori for Style contents of that particular account. I'm holding in my possession Exhibit 7U. I'm going to ask that the court mark this as an exhibit and move for admission by, I don't know that the state has an objection to that.
The state does not have an objection. I just wanted to clarify which ones.
Very well. We'll get that marked for you, Mr. Pryor, and then.
Thank you, Judge.
Can you clarify what's in 7U?
Judge, it's a content of approximately 4 text messages between Lori Vallow and Chad Daybell dating from 8/11 of 2019.
All right, Exhibit 7U is being marked and will be admitted.
Thank you. Judge, may I have the court's permission to publish?
Yes,
And it might take me a minute, Judge. For more than a minute. And Judge, if we could start publishing.
all right, we will.
No, officer, I apologize. Agent, line 856 talks about from Chad Daybell to Lori Vallow, the next 2 days will be torture. Do you see that?
I do.
Then there's a comment from Chad makes a comment, and could you read that thankfully?
Thankfully, I will be alone most of Wednesday and beyond.
Okay, and then we go to line 854. Are these there's no text messages that are in between each of these, is that correct?
So in the iCloud, there can be. So in between 8:56 and 8:54, Lori Vallow could have gotten a text from a friend about lunch. And so they're just arranged and given a line number based on the date and time. So that's how this works.
Okay, so the time on the first one, 8:56, is at 9:56. The 8:54 would be the next correspondence from Lori Vallow to Chad, correct?
Yes.
And if you could read that entire text message starting with the word is.
Is that what he wants? For me to sit around waiting for you endlessly and you miserably wasting time? It just doesn't feel right! Exclamation point.
Okay. Now, you talked about the manipulation that was engaged in these, many of these, and you said, use the word many, from Lori Vallow to Chad Daybell. Is this an example in your mind of Lori Vallow again manipulating Chad Daybell?
Absolutely. It was a two-way street. Lori Vallow would manipulate Chad Daybell and vice versa.
Okay, and Chad's manipulation would be talking about the religious knowledge that he claims to have in this vast wisdom. Is that right?
Yes.
Okay. So on two levels, we have manipulation, at least according to you. We would have manipulation because someone's claiming to have some religious knowledge and espouses that by trying to impress Lori Vallow with that vast religious knowledge, correct?
I think it's more than knowledge. I think it's direction.
Okay. And then in Lori's case, this is manipulation and trying to get Chad to do what she wants him to do, correct?
Yes, I would agree.
Okay. Okay. And Judge, could we unpublish at this point to like move to the next slide?
Yes.
Thank you, Your Honor. Okay, and then if we could publish again.
Go ahead.
And then again on 8:11, it talks about Chad to Lori Vallow. I'm frustrated. I'm sorry, honey. And then let's go to line 843, which appears to have occurred at about the same time the first text. And if you could read line 843, starting with you.
You can't just keep tearing my heart out. I really can't take it anymore. I'm sorry.
Okay. Okay. And then let's go down to line 841 and start with reading that one for me.
What about the past 2 days? I didn't even get to talk to you on your birthday. I'm clearly not a priority. I just don't want to be so sad all the time and do heartbroken.
And again, in your professional experience with dealing with this case, is that another instance where Lori Vallow may be trying to manipulate Chad Daybell?
Certainly.
Thank you. And Judge, if we could unpublish again.
Yes.
And let's publish again, Judge. Okay. And then if you would read line 840.
If you really loved me, you wouldn't want that either.
Okay. And then Chad Daybell responds. That was from Lori Vallow to Chad, correct?
Yes.
And then 2 minutes later, Chad discusses that he couldn't have talked. The girls were there. And then he expresses his true love for Lori Vallow, correct?
Yes.
And then if you would be so kind, two minutes later at 10:15, Lori Vallow texts Chad Daybell. And if you could just read the entire line starting with you.
You should give all of you love and your attention to your wife and family. I'm just a distraction. Go have fun with your family. I really do want you to. I just can't be in the way anymore. If things change, then we can talk. But we have nothing until things change anyway.
And once again, I don't want to keep reiterating this, but this is another example of Lori Vallow attempting to manipulate Chad Daybell. Would you agree?
I would.
Okay. And it seems a little bit final. And it seems as if that the suggestion here is on 8/11 of 2019 that there's a breakup between Lori Vallow and Chad Daybell. Do you agree with that?
I do.
Judge, we can unpublish this.
All right. All right, that concludes cross. Any redirect?
Yes, Your Honor.
Oh, I'm sorry.
Your Honor, I would request permission to publish from 183B, the printout of the PowerPoint. I can use the drive if necessary.
All right, we'll get you the exhibit on the drive.
Agent Hart, you were asked about manipulation by Lori Vallow from counsel. Do you recall that?
I do.
Through your investigation, did you also find manipulation by Chad Daybell?
I did.
Did you find that manipulation around the same time of the breakup?
I found it throughout the entire course of the investigation.
And again, through the investigation and based on your review, who would determine someone was dark?
Chad Daybell.
Who would determine if someone was a zombie?
Chad Daybell.
Who would determine?
Judge, I'm going to object at this point. It's going beyond the scope of cross-examination.
Overruled.
Who would determine death percentages?
Chad Daybell.
And Your Honor, I would request permission to just publish one page of the slide, but to print it out for ease.
Yes, you may publish the printed version on the Elmo if you'll identify what it is when you do that.
Yes, it is slide 18 from the printed version of Exhibit 183B. Agent Hart, who is the one that indicates there is a plan being orchestrated?
Chad Daybell.
And do you see the reference in there to the children?
I do.
Do you know where Tammy Daybell's body was located when she was pronounced dead?
Tammy Daybell's body was located in the bedroom in their home.
Where were the bodies of Tylee and JJ located?
Tylee and JJ were both located on the pasture property of the residents.
And was that the residence of who again?
Chad Daybell.
I have no further questions.
All right, thank you. That will conclude the testimony then of Agent Hart. Does the state have any additional witnesses to call in its case in chief?
We do not, Your Honor.
All right, so has the state rested at this time?
Judge, if we may have a brief sidebar.
Yes. All right, we just had a sidebar to discuss some scheduling matters. At this time, I had inquired from the state if the state had another witness to call at this time or whether the state had concluded its case in chief. Ms. Blake?
The state does not have any additional witnesses. The state rests.
All right, the state is now rested. Ladies and gentlemen of the jury, in terms of our scheduling, that is going to conclude the evidence portion for today. We did not provide lunch today, believing we'd end here early. However, before you leave, you'll be delayed a little bit while the jury commissioner is going to just talk to you about a little additional information and scheduling at my direction. And so we will take up those matters with you shortly. And at this time, then we'll take a recess. And then if the parties wish to come back on the record for any motions outside the presence of the jury, we can do that as well. So we'll take our recess at this time and let the jurors be excused to the jury room. All right.
All right. So I'm on hold here. If he comes. Okay. So the people have rested. They're sending the jury out. They're going to take a brief break, and then they're going to come back and do motions outside the presence of the jury, which is going to be the motion for judgment of acquittal. It will be denied. So if there's anyone out there thinking, oh, this case is going to get dismissed at the motion for judgment of acquittal stage, you're wrong.
All right, thank you. Please be seated.
All right, let's go ahead and take a listen here.
I'll note that the last witness, Agent Hart, is still, I'm advised by the state, I believe, going to be held under subpoena potentially for rebuttal. Is that correct?
That is correct, Your Honor.
Okay, we just advised the witness he's done for today, but he's still subject to the exclusionary order. At this time, also then, I do want to take a recess here because I do want to meet briefly with the jury commissioner, and we'll take a break. And then Mr. Pryor, is the defense intending to make any motion today?
Judge, I anticipate making a motion, a general motion for a directed verdict, Judge. I'll describe it that way.
Okay. Why don't we plan on that? I know it's maybe an inconvenient time, but in about 30 minutes probably. So
Thank you,
10
Your Honor.
after. We'll take the motion up then.
Thank you, Judge.
Okay, thanks. We'll be in recess until then.
All rise.
Okay, so if you can take me out for a quick break.
this weekend?
Okay, thanks everybody. I was trying to resolve a couple of things, and of course they were all calling right as we were getting ready to go back because the court has taken their break. Mr. Pryor has indicated that he's going to come back, make a generic motion for what he referred to as a directed verdict. Usually that term is for civil cases, but they may call it that in Idaho. We refer to it as a motion for judgment of acquittal, where I practice. And he knows that he's going to lose the motion, but you have to do it to preserve the record. Then the question is going to be, they're taking a break. The jury will come back. There were some issues about when they'll return. The last detective or special agent from the FBI was, still under subpoena for any rebuttal case. The question is really going to be then, is the defense really going to go today, or is he going to ask to set it out till tomorrow morning? The defense should be ready to go. That's what happens when you're on the defense. You know the prosecution is ending their case. You better have your witnesses lined up, ready to go. So we'll see that. And then obviously the issue then becomes, will Chad Daybell testify? He risks a lot. Obviously, he's looking at, 3 multiple life sentences plus the death penalty. So the real issue is, do you not put him on the stand? As a defense attorney, you try to get in the information that you need without having to put your client on the stand. That's usually the best way to do it. Doesn't always work out that way. Obviously, if there's some sort of self-defense, you have to have your client testify to get an affirmative defense. Here, there's no affirmative defense. It's simply, I didn't do it. I didn't know. I was duped. Somebody's going to have to explain away these text messages because that cross-examination that Mr. Pryor did to the agent didn't cut it. That did not raise any reasonable doubt at all. Wanting to be with you, ready to go on a real date with you. That sounds like a guy who knows that he's going to be with his new girlfriend really, really soon. Like, I don't know, like almost he knows that things are being taken care of. So we'll just have to wait and see. I really am quite doubtful if we're going to see Chad testify. I don't know. I could be wrong. We'll see what the defense has. We'll have some indication here. Obviously, they're going to take a break. They're going to come back to make the record. We'll see if they have any witnesses, and that'll be it. The defense has indicated they had several experts that they were going to call, various doctors as it relates to the death of Tammy, the kids to testify as to the death of Tammy. Now, of course, they may not be privy to all of these text messages and maybe get cross-examined with those, like, gee, did you know about this? Did you know about these communications the day before your mom passed away? And even though you say that it was a natural causes and she'd been struggling with her health, all that type of information, you weren't aware of that, were you? And so it's going to get interesting. We'll have to definitely wait and see what that's done. I was expecting a little bit more from Pryor on that cross-examination of the agent. And, you're seeing more and more of this stuff. It's like a PowerPoint slideshow. They did it in the Vallow case as well, where, they just dump in a bunch of information. They get admitted evidence, and then they produce this summary. Well, there's a way of doing a summary. It's called, the rules of evidence under 1002, I believe, where you have large volumes of information. You can use that to summarize it. But these are just individual pieces of evidence. And one of the slides that they had up of the text message string was some unidentified individual advising her that was doing that. Well, why the hell is that coming in? I just don't get it. So many times trial court judges think, well, it's part of the conspiracy. It's a 801D2E evidence. It's going to come in. So it all comes in. No, it doesn't. You still got to, and it's for a limited purpose. One, for something to be non-hearsay, it has to be the statement of the defendant, or there must be an exception to the hearsay rule for everybody that's coming in. Okay. So and then for 801 D2E, which is a conspiracy in furtherance of the conspiracy, if it's already been completed, it has to be in furtherance of the conspiracy, i.e., this is what we're going to do to make the conspiracy happen. That type of evidence, as it relates to, gee, I can't wait to be with you, is that really in furtherance of the conspiracy? I would venture to guess, if I was the judge, I'd say, how is this in furtherance of the conspiracy? I want to be with you. It's not saying, go strangle your wife. That would be in furtherance of the conspiracy. And that's for co-defendants' statements, i.e. Lori Vallow and, Alex Cox. So listen, I may not know much about a whole lot of anything in life, but the one thing I do know, that's the rules of evidence. Okay. That's what I've had to use to, how am I going to get this evidence in? How am I going to keep this evidence out? Do they have the right witnesses to get this evidence in to lay the proper foundation? So there's one thing I know about. It is the rules of evidence. And unfortunately, a lot of judges just don't know it. Particularly if they come from more of a civil background. Civil attorneys are like, well, we'll stipulate to this, and I'll agree with this, and you agree with that, and they're absolutely flabbergasted when you're a civil case. You're like, no, lay the foundation, bring them in. Can't agree, Your Honor. But there's always like this negotiation that they want to take. Well, I'll let you have this document, and if you can have it, no, bring your witnesses, and that's the way it is in criminal cases. Bring your witnesses. We're not stipulating to anything. So, we got Judge Boise here, who is he was primarily a civil guy, but most judges, and I can tell you most judges, unless they've been around on the criminal bench for quite a while, simply do not understand 801 D2E evidence. Somehow they think, well, it's a co-conspirator statement, everything comes in. No, Judge, you have to actually read the actual rules and take a look at that, because under 801 D2E, it must be in furtherance. Okay. And what does in furtherance mean? Well, something to make sure the plot goes forward. It just doesn't come in because that's particularly it. So just so you know, I'm not making this up. 801 statement. A statement is an oral or written assertion or nonverbal conduct of a person if it is intended by the person as an assertion. Declarant is a person who makes a statement. Hearsay. Hearsay is statements other than the one made by the declarant while testifying at trial or hearing, offered in evidence to prove the truth of the matter asserted, right? So you can always say, think objection when somebody's on the witness stand and they're testifying to what somebody else said, or verbal movement. He pointed that away. That's a statement. That's hearsay. So whenever somebody else is testifying to what somebody else said, it's hearsay, and there has to be an exception to that. And the rule's right there. So sometimes it's like, how is the judge letting that in? How is that not hearsay? What exception, right? When in doubt, object. And then we have statements which are not hearsay. Statement is not hearsay if the declarant testifies at a trial or hearing and is subject to cross-examination concerning the statement, and the statement is inconsistent with the declarant's testimony and was given under oath subject to the penalty of perjury at trial, hearing, or other proceeding, or in a deposition, or B, consistent with the defendant's testimony and is offered to rebut the express or implied charge against the declarant, or recent fabrication of improper influence or motivation, or one of identification of that person made after perceiving the person. Okay. So basically, prior inconsistent statement, prior consistent statement. Well, isn't it true, ma'am? You testified at a previous hearing to A. Now you're testifying to B. Well, you can use that to impeach, and it's not hearsay for impeachment purposes for a prior inconsistent statement. And if somebody says, well, you testified to A here in the courtroom for the first time, you can say, no. I testified to all that previously. And so to rebut the allegation of reasons fabrication, you can bring in that prior statement as a prior consistent statement. Say, no, I've testified that previously. Why are you trying to make it sound like I just testified to this before today? This is the first time. So it's a consistent statement. And then you have under 801 D2, which is admission by a party opponent. The statement is offered against the party and is the party's own statement in either an individual or a representative capacity, right? So if the defendant made the statement, it's admission of party opponent or a representative of his asking on his behalf, non-hearsay. Or B, a statement which the party has manifested an adoption or belief that it is true. Okay, doesn't really come in very often. A statement by a person authorized by the party to make a statement concerning the subject. So if you have a representative, an attorney, a spokesperson, that could be your statement, right? You send your spokesperson out and say, we did not do this. We're not responsible. And then it turns out they are. You can use that. And then D, 801 D, a statement by the court's agents or servant concerning the matter within the scope of the agency employment, once again represented. And then E, a statement by a co-conspirator of a party during the course and in furtherance of the conspiracy. The content of the statement shall be considered, but are not alone sufficient to establish the declarant's authority under subdivision C, the agency or employment relationship and scope thereof under the subdivision, or the existence of the conspiracy and the participation therein of the declarant and the party against whom the statement is offered under subsection E. So 801 D2E, the key word being, first, the court has to establish by preponderance of the evidence that there was in fact a conspiracy. So the court does that. Then he says, okay, I'm going to ask, they're going to try to move in statements of the co-conspirators, i.e. Alex Cox, Lori Vallow, and say, Judge, these are in furtherance of the conspiracy. Well, there's a lot of speculation in a lot of those. It's not like saying, hey, go kill the kids, go kill Tammy. There's some speculation in the interpretation of that. That's his interpretation of that. Pryor was allowed to, or he objected, and the judge sustained a couple of those objections as it relates to speculation. But that's basically for argument. Like the document speaks for itself if you've allowed it in, Judge. But the question then is it really in furtherance of the conspiracy? In the famous words of Freud, sometimes a cigar is just a cigar. So when he says, boy, I really want to be with you and have a date with you, that'd be great. That means one could say, oh, that's because your wife is going to be killed. Or it is because you simply realize that, hey, I really want to be with you and I can't wait to be on a date with you. And I'm divorcing my wife or something to that effect. The words just simply speak for themselves. For the court to allow the detective to say what we believe this means, I think, should have been what steps did you take to do that? But for him to hypothesize about, this being a death or something, I think I would be objecting left and right. Of course, probably going to allow it in, but I would continue to make that record that this is speculation, Judge, and his opinion, frankly, nobody cares about his opinion. He doesn't have a crystal ball. He didn't talk with anybody that said this was our plan. It's their hunch. That's their suspicion. What other evidence do you have to back it up? It's kind of cumulative. I would have been objecting under 403 as well. Scott is renegotiating Frank's pay now. He can see what Frank does. Yeah. Let's see here. As delusional stupid as these people are, I'm pretty sure they had no intention of exchanging written messages to talk about wanting to kill or having. Mel, delusional and stupid as these people are, I'm pretty sure they had no intention of exchanging written messages to talk about wanting to kill or having already killed someone. It's always the defendant's own words. I'm telling you. This thing, this cell phone, right? Even though ours, we have a little Crime Talk sticker on ours. This little phone, and I'm not telling anybody to go commit crime, but most people have no idea. And even if you think you delete it from this phone, you can't remember what's the reference? iCloud. iCloud backs up everything in your phone. And so you could have messages from years and years ago, depending on, I think, the plan that you get for memory. Like I said, it may have just been, little cute little lovebirds talking and, oh, I can't wait to be with you. I love you more. No, love you more. Oh my gosh, that's part of the conspiracy. So you have to be very careful. All right, here we go. Motion for judgment of acquittal or directed verdict, as they're referred to it as they're in Idaho.
Thank you. Please be seated. All right, at this time, we're back on the record on case CR 22211623, State of Idaho versus Chad Guy Daybell. The court will note that the state has rested its case in chief. At this time, then, I understand the defense is requesting to have a motion heard. We do have the defendant here along with defense counsel. The state's also present with the prosecutors. The jury is not present in the courtroom at this time. This motion will be argued outside of the presence of the jurors. Mr. Pryor, if you'd like to make a motion at this time, you may.
And Judge, this is a motion for a directed verdict that is permissible under the criminal rules. I'm going to do this, Judge, in a general sense without getting into specifics, but I'm going to move for a directed verdict on the murder charges, specifically with Tylee and JJ. There is no indication that Mr. Daybell was present, took an active part in, or facilitated in any way the murder of JJ and Tylee. In regards to the conspiracy charges, there's no indication that there was any act that he took in furtherance. There's reference to significant religious discussions, but that in itself is not an action in furtherance of those charges. Lastly, Judge, in regards to the fraud, the only testimony I recall is that the insurance was upped from $10,000 to $80,000, and that there had already been a longstanding $300,000 policy from 2002. At this point, I don't think the state has met its burden regarding the fraud. And again, I don't think they've met their burden regarding the conspiracy on all of the conspiracy charges, and they have not met their burden in regards to the murder as set forth previously.
All right, thank you for the argument, Mr. Pryor. Who's going to be responding for the state?
That would be me, Your Honor.
All
And I
right,
think,
Ms. Beatty, you can proceed with a response from the state.
thank you, Your Honor. On a motion for directed verdict, Your Honor, the state is entitled to all reasonable inferences that can be drawn from the evidence. And I think the case law is pretty clear that a motion for judgment of acquittal should only be granted when there is no evidence upon which to base a verdict of guilty. And that is from State versus Vargas, 100 Idaho 658. Essentially, the trial judge must review the evidence in the light most favorable to the state, recognizing full consideration must be given to the right of the jury to determine the credibility of witnesses. The jury gets to determine the weight of the evidence, as well as enjoying the right to draw all reasonable inferences from that evidence. And that's from State versus Huggins, 103 Idaho 422.
Have you heard that before, ladies and gentlemen?
Going through
I told you what the
the
legal standard
charges
would
in this
be.
case, Your Honor, first beginning with the conspiracy to commit the first degree murder and grand theft by deception related to Tylee Ryan. The state charged a series of overt acts, and the state has presented evidence on all of those overt acts. Number one being that the defendant endorsed and espoused beliefs designed to justify the homicide of Tylee Ryan. specifically statements made about her being dark. These beliefs were part of the defendant's teachings, and it would be very reasonable for the jury to draw the inference that these beliefs that the defendant was espousing were designed to dehumanize these victims and justify their homicide. As to number two, that his co-conspirator Lori Vallow changed the deposit on Tylee Ryan's JP Morgan Chase account to her BBVA account. We also heard testimony from the state's financial witnesses to that effect. Evidence that his co-conspirator and then mistress, Lori Vallow, moved to Idaho with his other co-conspirator, Alex Cox, as well as JJ Vallow and Tylee Ryan. Multiple witnesses testified to this. We heard evidence that the defendant himself did Google searches for the wind direction on September 8th of 2019, the last day Tylee Ryan was seen alive, and the day prior to when the state presented evidence that Tylee Ryan would have been buried on the defendant's property. That is directly related to the defendant. Number 5, Alex Cox went to co-conspirator Lori Vallow's apartment where Tylee Ryan lived in the early hours of 9/9. Certainly there was evidence presented to that effect. And of note, there was also evidence that the defendant was in communication with Alex Cox at that time, and that Alex Cox's phone was in the vicinity of the defendant's residence. As to number 6, that Lori Vallow never contacted Social Security. There was also testimony presented to this effect. The jury also heard that just weeks prior to Tylee Ryan's death, that Lori and Chad was aware that she would still be getting those Social Security checks after the death of Charles Vallow, which does link the defendant to that co-conspirator's actions in never contacting Social Security. Additionally, the 7th overt act, that from September of 19 to January of 2020, Lori Vallow continued to collect those checks. And during a substantial portion of this time, Your Honor, the defendant was living with her in Hawaii and enjoying the proceeds of those checks, another reasonable inference that the jury could draw. As to the first-degree murder charge of Tylee Ryan, which is count 2, the jury heard evidence that the defendant claimed that Tylee Ryan was dark, that he was, again, exchanging text messages with Alex Cox the day after she was last seen alive, that Alex Cox was in the vicinity of his residence. The jury heard evidence that the defendant texted his wife the morning of September 9, claiming that he had shot a raccoon and burnt some limbs. And then Tylee Ryan's burnt and dismembered remains were found on the defendant's property. Her DNA found on the defendant's shovel and the defendant's pickaxe in the defendant's shed. So I think there's ample evidence on that count, Your Honor, and I think that does not merit even consideration of a judgment of acquittal. As to count 3, I won't rehash all the overt acts because there is some overlap with the count 3 conspiracy to commit first-degree murder of JJ Vallow. The first overt act we've already discussed, which is the evidence of those espoused religious beliefs justifying the homicide of JJ Vallow. Number 2, we've already covered that the defendant's co-conspirator and then mistress, Lori, moved to Idaho with the children and with Alex Cox. Overt act number 3, the jury heard evidence that Alex Cox, the defendant's co-conspirator, took custody of JJ Vallow. As to count or overt act number 4, that co-conspirator Lori Vallow provided false information to law enforcement regarding JJ's whereabouts. We did hear testimony of that as well. Number 5 and 6, again, those are also ones that we've already covered related to the financial issues. Count 4, the first-degree murder of JJ Vallow. Again, we have ample evidence that a jury could use to reasonably conclude that the defendant is guilty of the murder of JJ Vallow. In addition to the planning and preparation evidence that the jury would have heard related to the conspiracy that we've already covered, on September 23rd, the day after JJ was last seen alive, witnesses testified at trial that they'd been staying with Lori Vallow, and that Lori told them that they not only saw Alex Cox with JJ, but that Lori then told them on the morning of the 23rd that JJ was with Alex. And the jury heard evidence about what Alex was doing that day because he was en route to the vicinity of the defendant's residence, and he was texting with the defendant that morning. Also, the jury had heard that JJ, according to the defendant, JJ was dark. We just heard evidence of that this very morning when the defendant was describing in text messages to Lori that JJ wasn't himself and that he was possessed by some type of dark entity. And like Tylee, JJ's body was found in a grave on the defendant's property. Again, ample evidence from which a reasonable jury could conclude that the defendant is guilty of the murder of JJ Vallow. As to count 5, the conspiracy to commit the first-degree murder of Tammy Daybell. Again, the state alleged a series of overt acts and presented evidence on every single one of them. The first one, the espousing of religious beliefs similar to the other 2 conspiracy-related charges. Evidence was submitted on that. Number 2, again, we've already discussed that defendant's then mistress and co-conspirator Lori Vallow did move to Idaho to where the defendant lived. Another overt act. Count 3, exchanging text messages regarding death percentages on July 30th. The jury did hear evidence of that. Overt acts 4 and 5, that the defendant and Alex Cox exchanged burner phones. That came into evidence as well. Overt act number 6, that the defendant's co-conspirator, Lori Vallow, exchanged texts regarding Tammy Daybell being possessed by dark spirits and being in limbo. The defendant and Lori Vallow were discussing that. And again, that evidence came in this very morning, Your Honor. Overt act number 7, that on September 8, the defendant signed an application along with Tammy to increase her life insurance policy to the maximum allowable under that policy. That came in via testimony and business records. Number 8, that the defendant's co-conspirator, Alex Cox, attempted to shoot Tammy Daybell. Evidence has been presented on that, Your Honor. Certainly, it's been a source of contention in this trial and a source of cross-examination, vigorous cross-examination, but ample evidence has been presented that that is exactly what occurred. Overt act number 9, that Alex Cox did multiple internet searches related to that shooting. Number 10, that Alex Cox went to the firing range in preparation for that attempted shooting. Number 11, that Alex Cox drove to from the Sportsman's Warehouse to the Daybell residence on the 9th of October of 2019. And number 12, that Alex Cox was near the Daybell residence on the 18th of October 2019 when Tammy Daybell died. All of those overt acts, the jury heard evidence on, and it would be more than reasonable for them to conclude that the defendant engaged in a conspiracy to kill Tammy Daybell. On count 6, the actual first-degree murder of Tammy Daybell, in addition to all of the preparation evidence that the jury heard related to the conspiracy, the defendant was telling numerous people in his life that Tammy was going to die soon. The jury heard evidence of that. They heard evidence that the defendant would send text messages to his mistress and co-conspirator Lori Vallow regarding how trapped he felt, but how freedom was coming. The defendant's mistress, Lori Vallow, was shopping for wedding rings before Tammy even died. The defendant then told conflicting stories about how she died, when she died. At the defendant's funeral, Chad claimed that he had miraculously asked Tammy for all of her financial passwords just days before his death, or her death. After Tammy's death, Chad immediately moved out, cashed out Tammy's life insurance policy, and went to Hawaii to live with Lori Vallow, who he married just 2 weeks later. And of course, the jury heard evidence that Tammy Daybell's death was ultimately deemed homicide by asphyxia. Again, we have ample evidence from which a jury could conclude that the defendant is guilty of the murder of Tammy Daybell. As to the final 3 counts regarding the grand theft and the insurance fraud, there were pardon? Pardon? There was a clerical issue. Thank you, Your Honor. As the final two counts of insurance fraud, I won't belabor this since we've already discussed it in the conspiracy portion. But the evidence does show that the defendant and Lori began an affair in 2018. Months later, Lori's husband, Charles, was killed by Alex Cox. In the immediate aftermath of that killing, Lori and the defendant exchanged text messages where Lori expressed her disappointment that she was not actually the beneficiary of Charles Vallow's life insurance policy. Then months later, not even months later, mere weeks later, the defendant goes with Tammy to increase one of her life insurance policies to the maximum allowable. And shortly after that, Tammy is killed. The jury has business records, they have testimony, they have ample evidence from which they could conclude that the defendant has committed the crimes of insurance fraud as to both the Primerica and LifeMap insurance policies. Thank you, Your Honor.
All right, thank you for the argument. The courts reviewed the motion, which is a motion brought under Rule 29 of the Idaho Criminal Rules. And this is a motion for judgment of acquittal, which reads that we're now at the time the prosecution has closed its evidence. And if the court finds, based on the standards cited there by the state, insufficient evidence, the rule reads, must enter a judgment of acquittal of any offense for which the evidence is insufficient to sustain a conviction. I've listened throughout the trial to all of the evidence submitted. There's multiple counts in this amended indictment. As I've gone through those, I'm prepared to make a ruling on nearly all of the motion here, but there is one particular issue that has arisen in the charging document, and I'd like to address that with the state if I could. So in the initial indictment filed in this case on May 25th, 2021, and I'm looking at count 4, which is the charge of first-degree murder involving J.J. Vallow. Initially, it was alleged that, quote, on or between the 22nd and 23rd of September 2019 is when the murder was committed. The state amended the indictment on February 20th, 2024, and under the amended indictment, the count 4 now reads as follows: the defendant, Tylee Daybell, and Lori Noreen Vallow, on or between the 8th and 9th day of September 2019 in the county of Madison, state of Idaho, and then goes on to describe the allegations about the murder of J.J. Vallow. When I look at the evidence that's been presented here from the state, the evidence not only does not support a finding of the dates between the 8th and 9th of September, but contradicts that in that J.J. Vallow was clearly alive after the 9th of September from many witnesses, including testimony today. And so I have some concern that the charging language, which would control in this case in the amended indictment, cites a date range that does not comport with the evidence. And I'm concerned about instructing jurors with evidence that I believe was never presented here at trial. It's an issue identified as we prepared for this hearing today. I understand the state may not have been aware of that. It wasn't argued by the defense, but the court has its own duty to also review the evidence and under 29, point out anything that may be considered for a potential judgment of acquittal. And so I don't know if the state is ready or willing to address the issue on the dates contained in count 4 now, or whether the state would like some additional time to look at the issue and perhaps come back a little later this afternoon and present some additional argument or authority. But I have a concern about count 4. The testimony does not comport with that. I'll note one additional point. We have an on or about instruction that's already been given and will be given. In some of the counts in the amended indictment, there are on or about language. There's also others that have on or between language. And in my mind, a plain reading of an on or between still gives a date range, but the range is from one date to another. And I don't know that that's the same as on or about, which allows maybe a further deviance of times listed in the charging information. And again, count 4 reads on or between the 8th and 9th of September. So, Ms. Beatty, do you have any response to the court's concern as it relates to count 4?
And Your Honor, if we could come back and address that perhaps Monday morning, so we have the opportunity to review that prior to the defendant's case. I'm not sure anyone was aware of.
And Judge, I need to respond for the record.
Yes.
What do you mean
Why
they
don't
weren't
you-
aware?
I did say a lot there, and Mr. Pryor offered the state a chance to respond. Any response from the defense, Mr. Pryor?
Judge, state has had an opportunity and an ample opportunity to review their pleadings. They've made amendments of those pleadings once, and we had a hearing on those amendments in which I agreed they could make whatever amendments they wanted. And now we sit on the eve of the defense starting their cause. The state has rested. The defense has made a motion under Rule 29 for a directed verdict. I don't think this gives the state the ability to make any modifications or amendments after they've rested their case, and at which time I've made a motion for a directed verdict. That motion for the directed verdict, Judge, tolls the state from making any further adjustments to the accusations they're making against Mr. Daybell, and I'm suggesting I'd ask the court to make its ruling on my directed verdict.
All right, I'd note there's actually a rule that governs this directly, Idaho Criminal Rule 7E. The court may permit amendment of an indictment, quote, at any time before the prosecution rests. So I do agree with the defense there that amendment of the indictment's not permitted at this stage in the trial. In terms of the timing and the request by the state, the issue with waiting until Monday is if the defense is going to be prepared to start with its case in chief, the defense is entitled to know what it's defending against. And if potentially one of these counts is dismissed on a judgment of acquittal under Rule 29, that would affect potentially, in fairness, preparation for the defense. So in my mind, it's a fairly narrow issue where we have a filed amended indictment. We've got Criminal Rule 7E, we've got Criminal Rule 29, we've got our jury instruction number 4, which might be relevant on the on or about or on or between language. And I think with the prosecution team all here, I'd like to get this done and determined this afternoon. So it might feel like quick timing, but I'll give the state 2 additional hours to prepare for any further argument or authority. And we'll come back on the record at 2:30 for further argument and potentially ruling on this, including all the remaining counts as well. So we'll be in recess until 2:30 and we'll come back then.
All rise.
Okay, what did I say right before they were getting ready to rest? They're over there, they're checking their dates, they're checking their evidence, they're doing everything they're supposed to do, because when you rest, that's it. And I didn't have the indictment in front of me. Motion for judgment of acquittal, it's pretty routine, denied, etc. And it's kind of a argument that, judge, they didn't prove this. And, the judge says, no, you can. And after the prosecution responds, and you get to lay out all their stuff. Well, in this case, the judge, sua sponte, on his own says, hey, the defense didn't bring this up, Mr. Pryor, but on count 4, prosecution, you got a big problem here. The original indictment says that J.J. Vallow died on or between September 22nd and 2020 and September 22nd and 23rd. You then amended the indictment. And remember, I got a big problem with the way Idaho can amend an indictment. Freaking crazy. Anyway, they said that it was between September 8th and 9th. They're locked into that. The judge says you didn't present any evidence of that whatsoever as to the dates. In fact, it contradicts all the evidence that he, in fact, was alive after September 9th. The prosecution screwed this. And yeah, Pryor didn't catch it. He's been trial. I get it. But he's probably thinking, I'm lying in wait. Here's the deal. Don't highlight it. Let him fix it, right? The judge is like, yeah, the rule says you can amend up until the time the prosecution rests. A plain reading of that means that They haven't presented evidence that he was deceased on on or about September 8th and 9th. Ladies and gentlemen, the judge should dismiss count 4. The headline of the day: Chad Daybell is going to walk as to the death of JJ Vallow. Why? Because the prosecution screwed the pooch. Again, remember back in the Vallow trial, remember they changed the dates right before the end of trial, completely changed everything, right? When you do an indictment, and Idaho is weird because you can just amend an indictment. Everywhere I've ever practiced law, in federal court, state court, if you want to change something in that indictment, you want to change those dates, you have to go back and bring all the evidence, same evidence back before a grand jury and get a superseding indictment. Superseding meaning that it replaces what's previously before that. That's what they amended it here. They've rested their case. That's what I said. Oh, they're going to be over there talking about how they are going to, did we present all the evidence? Did we get all our dates right? Little checklists. Prosecutors always have little checklists. Check, check, check. We got this. We got this. And they have 4 freaking DAs sitting at that table. And not one of them just happened to mention, hey, oh, yeah, we amended to September 8th and 9th. But actually, it was probably September 22nd and 23, because, in fact, he was alive on those particular dates. This is what happens, ladies and gentlemen. And you can say, oh, that's a technicality. Oh, my gosh, that's a technicality. That's the rules. Like the judge said, that the prosecutor's like, well, let's just come back Monday. We'll fix it. No, not a problem, judge. And judge's like, no, I think out of fundamental fairness, we need to know whether this is going to, be something that he has to prepare for. Because if that count gets dismissed, ladies and gentlemen, that's huge. And if the prosecution, it gets dismissed because the prosecution screwed it up, huge. Remember, the jurors aren't going to know unless, of course, they're listening to the media or somebody tells them prosecution screwed it up. But you think they're not going to notice? We heard all this evidence about JJ, but we don't get to rule on that one? Huh, that's weird. But this is why it's so important, ladies and gentlemen. Yes, and Erica notes, and then it's double jeopardy. Yeah, jeopardy's attached, the jury's there. They have presented no evidence that JJ was in fact deceased in September or on or between September 8th and 9th. He was alive. That's frankly contrary. They even asked that question today when they had the agent up there. When was the last day that JJ was last seen? Oh, September 23rd. They messed this up. Wow. Huge, ladies and gentlemen. Now, the judge has given them 2 hours. They're going to come back in 2 hours, and the prosecution's going to see what they can do. But the rule is pretty clear. I mean, under Rule 29, they made a motion for judgment of acquittal. Everybody cited the appropriate case law as it relates to viewing the evidence in the light most favorable. And the judge said, hey, the defense didn't bring it up, but I have a duty as the judge here if there's anything out of whack here. And they presented no evidence as to that. They presented no evidence of that. Wow. Huge. Headline of the day: Chad Daybell not guilty of JJ Vallow's death. That's what it could read. And you saw it here as it happened. And fortunately, you had me here to explain exactly what was taking place, because I don't think most people realize the significance of that. I mean, obviously, we have a very sophisticated audience and watch lots of trials, but everyday people that don't follow this stuff or are an aficionado and watch Crime Talk, you wouldn't necessarily know that. But this is huge. And I don't know, maybe it was just me. I don't have a great big screen here of the courtroom, but it looked like the DA was literally had her hands between her head at one point. I mean, can you imagine going to the grandparents and saying, oh my God, I am so sorry. We messed it up. and there may be no justice for JJ. I guess that's the other headline. Will there be justice for JJ? Crazy. Welcome to trial work, ladies and gentlemen. You know, you get busy, you get focused, you get in that trial psychosis, you think you've done everything. You know, I was a prosecutor for a while, man. I mean, it was all about checklists. It maybe seems silly. I always see prosecutors over there, check, making sure they got that into evidence. The dates conform. Somebody messed up. And if that is a big, I mean, they purposely amended that. They purposely amended that in the amended indictment. And, you know, maybe Pryor was just lying in wait when he said, oh, you guys can amend the date any day you want. Sure. And just save it for closing. Ladies and gentlemen, that's completely contrary to the evidence, right? But the judge caught it. And I don't think there shouldn't be a way for them to amend it. And I'm not trying to, you know, but the prosecution, you know, and everyone says, oh, if this gets dismissed, and I'm not, and I really think it should, based upon what we've seen thus far by the judge's own comments, there should be no basis for the prosecution to amend it. You know, they had honor about September 8th and 9th. You know, and you can give honor about September 8th and 9th. That because, like, hey, we don't know the exact time, but it was sometime on the 8th or the 9th, but we don't really know exactly. But so we get that date range. Or if they say the conspiracy went from this date through this date, you know, then it's easier for them to do. And maybe they got confused. I don't know. I don't know. Someone says, obviously, Scott has converted to Chad's cult. Let's put you out there. No. I'm just telling you what the judge just said. The judge is the one that brought up this issue and said, prosecutor, you screwed up. You're the one that amended the indictment. I hadn't looked at the indictment since whenever. I haven't sat through every moment of it. I was just saying, okay, motion for judgment of acquittal, going to be denied. And the judge, who's obviously taking various copious notes, is his responsibility to do so. Hey, prosecutor, I think you guys screwed the pooch on this. You had the original date and then you amended it. Under the rules, it says you can amend at any time up until the prosecution rests their case. They rested their case. Prosecution's got 2 hours. Prosecution has 2 hours to come up with some way to see if they can amend after they have rested. That is huge. And I'm not going to say I'm an expert on Idaho law, but when the judge says, hey, prosecutors, you could have amended at any time, right? So when they did their little huddle and we're going to approach, they got 4 attorneys over there, 2 on loan from the Attorney General's office, and not a single person was over there before they ended, said, oh, let's double check the dates. Gonna be a problem. And like I said, I'm not saying Chad Daybell's, listen, Chad Daybell's a kook as far as I'm concerned, but you got to give the guys fair trial. And we don't get to bend the rules because the prosecution screwed up. Well, they really tried to get it right. It's just a typo. Judge, it's a Scrivener's error. What's the big deal? It is a big deal. That charging document means something. And that's their allegation saying they're going to prove it beyond a reasonable doubt. And, nobody wants to see the bad guy goes free. But I always say, people are like, oh, how can you, people get off on a technicality. It's not a technicality. It's called due process of law. And if you think somebody gets off on a case or a charge that may potentially happen here on this one count, I'm not saying he's going to be acquitted on everything, even if the judge throws this out. But it certainly goes negative towards the prosecutors that, oh my God, maybe these guys are incompetent. Oh my God. Right. And, but if you, don't blame Chad Daybell, don't blame the judge. They're doing their job. Blame the prosecutors. That's on them. That's their document. That's their filing. Like I said, welcome to trial work. Just when you think you think something's going to happen the way it's usually supposed to happen. Somebody throws a monkey wrench into that. Did you see the prosecutors? There was one that were like, oh my God, they know they're wrong. They know they messed up. And yeah, my heart goes out to Kay and Larry Woodcock. I mean, we've been on the show. I've met them. I've spoken with them. Heck, Kay and Larry were Patreon members. They've called in on our Patreon show in the past. I feel terrible. This case would not be here. Lori Vallow would not be in prison, but for Larry and Kay saying, hey, where's my grandkid? I want to see where's my grandkid. And so if this happens, which it may, head should roll. But it needs to be on the DA side, that's for sure, because they are the ones that messed it up. So the judge is giving them 2 hours to try to come up with some authority, some legal authority in which would allow them to do that. Now, let me give you a hypothetical. As I was sitting here, I just remembered I had a case years ago with a prosecutor. He's a good guy. He's a judge right now. In fact, I saw him just the other day outside of court, and we had we each had a jumbo beef hot dog at the corner of the courthouse. And we chatted briefly. We're acquaintances, but we've always been friendly, and had a case. And he's, like I said, he's a judge now, prosecutor. And they forgot to ask that this particular crime was committed in the state of Colorado, or, state of Colorado, county of Adams at the time. I said, Judge, they didn't do this. They've rested. You got to dismiss the case. So the only possibility that I think the court could allow them to do is what the judge did in my case, because they didn't want to. They wanted to screw my client. He was a bad guy. It was a stabbing, and they didn't prove one of the elements. And I said, Judge, motion for judgment acquittal. They didn't do this. Everyone acknowledged it. Yep, I had no evidence of that. I should have won, right? It was late in the afternoon. We come back the next day. I think I'm going to win. Judge is like, I'm going to allow the prosecution to reopen their case. And they did. And they put up the witness to say, was this address where it took place? Was it then? And is it now in the, county of Adams, state of Colorado? Yes, it was. Your Honor, the defense or the prosecution rests again. So that is what I could see happening in theory here. So if the prosecution's listening, or somebody is doing that, I think what they would request to do, even though the motion for judgment acquittal has already been made, just like in my case where I got screwed, ask to reopen the case, amend the indictment to conform to the evidence, and then rest again. That's what I think they would do. I think that's the only way they can remedy this situation. And that's an extreme situation that the court would allow that, because, if I was prior, I'd be jumping up and down saying, Judge, they got 4 prosecutors over there, plus support staff, plus everybody else. And frankly, the court that lets them do kind of whatever they want when they request it. And it's just little old me. And they got it wrong. And it's unfair. And that's the argument the defense would make, probably throw out a little righteous indignation. If the rules don't apply and the plain language doesn't mean anything, then what does it, Judge, if we change the rules every time the prosecution screws up? That's the argument you'd have to make. So yeah, it gets interesting, doesn't it, ladies and gentlemen? Like I said, welcome to trial work. Welcome to trial work. Just when you think you know what's going to happen and something happens, I wasn't expecting that. I really wasn't. I'll be honest, I don't have the indictment dates in front of me to say, look at this. But the judge has been there the whole time. I haven't. So, and Judge Boise is doing what he's supposed to do. The defense attorney, Mr. Pryor, didn't call it out. Was it because he knew about it or didn't think about it? Or was he just lying in wait to get there, to the jury? But obviously he'd want it thrown out now. I mean, and then the question then becomes, well, if you throw out the first degree murder, I guess he can still be found guilty of the conspiracy to commit murder. But yeah, I mean, that just throws a whole wrench in everything, and it makes the prosecutors look silly, doesn't it? And particularly if you're going to have them reopen their case, you got to do it in front of the jury. And then they have to amend it. And then the court has to, frankly tell the rest of the world, the rules don't apply. The rules don't apply. How are they going to do that? So, all right, quick reset for those who have just joined us. In fact, I see someone says, I'm confused. What happened? Big thing happened here just a moment ago. The prosecution rested, and then the defense made their motion for judgment of acquittal, which is basically saying, Judge, the prosecution hasn't presented any evidence that no reasonable juror could conclude that Mr. Chad Daybell was involved in the deaths of JJ Tylee, as well as his wife. The prosecution then got up and said, no, we presented everything. We've submitted all this evidence as it relates to the death, the conspiracy, the overt acts, the money, etc. Then the judge says, well, I'm a little concerned because the original indictment going back to May 25th of 2021 says that in count 4, first degree murder, JJ Vallow, on or between September 22nd and 23rd of 2000, right? The prosecution amended this indictment back on July 20th of 2024. So they've had 3 years and 2 months in which to get that date right. And from that date that they amended. And the amendment said that the murder took place on of first degree murder as to JJ was on September 8th and 9th of 2020. The judge says, well, that doesn't conform. In fact, there's evidence that he was in fact alive. In fact, it completely contradicts the evidence that he was in fact alive after September 9th. So that's the date you chose, prosecutor. You amended to have that date. Why should I not grant the motion for judgment of acquittal? Rule 7 says the prosecution can amend an indictment up until the moment that they rest. They just rested. They rested, ladies and gentlemen. So the judge is in a situation where he's going to say, well, am I going to follow the rule, or am I going to allow some way to fix it? The judge gave the prosecutors, I would note they had 4 of them throughout this process. You had probably even more that amended the indictment to that particular date. They held hearings on that particular date. They knew what evidence was going to come in. We're now in day, I think, 24 of trial. And right before you rest, you always double, triple check to make sure you didn't forget something. And what should have been a perfunctory motion for judgment of acquittal and denial of such has turned out to be, well, there may not be justice for JJ in this particular case because the dates are wrong, because the evidence is that JJ was alive, but the prosecutor's charging document, the amended indictment, says that he was dead on September 8th and 9th, on or about September 8th or 9th, which clearly means they messed it up. And I didn't catch it. The judge did. I mean, I haven't been here for every moment of the trial. I don't have the charging document in front of me, but yeah, they messed it up. I gave you my proposed suggestion. I mean, if the rules mean something, motion for judgment acquittal should be granted. If, however, the judge, and I told you an example that I had years ago with a prosecutor who's now a judge, and we just had lunch the other day. I would say, Joe, we were at the hot dog stand together. We chatted. And in that particular case, they hadn't proven one of the elements. It was a jurisdictional issue. I'm like, Judge, they haven't proven jurisdiction. My guy wins. Dismiss the count. It was late in the afternoon. The judge thought about it. He comes back the next day, allows the prosecution to reopen their case after they've rested. Of course, I object up and down, blah, blah, blah. This is a travesty of a mockery of a sham. How can we do this if this doesn't matter, Judge? Why do we even have motion for judgment acquittal? Let's just, wait till the very end. And I was getting a little theatrical at the time. And of course, the judge allowed him to do that, and they got to amend their case. And guess what? They convicted my guy. Didn't really think of it until this very moment, but yeah, I remember the case, little stabbing case. And like I said, the now judge and I still talk about that case when we see it, because it was embarrassing for him, because he knew he was going to lose on judgment of acquittal, but the judge bailed him out. So the question is going to be, is Judge Boyce going to bail them out? Is he going to allow them to reopen their case? That's really the only option that he has, is to reopen the case. Otherwise, they've rested. You can't amend under the rules that the judge read to the prosecutor, unless there is some authority, case law, that the prosecution can come up with to say, Judge, you have the authority to allow us to reopen this case, allow us to amend it. Hey, Frank, real quick, can you check the front door? I ordered some food. Sorry. Anyway, I'd ordered lunch. Hasn't arrived yet. So anyway, that's the big news of the day. Will there be justice for JJ? It looks like the prosecutors messed up. So we will have to wait and see what the prosecution is going to do. That's what it comes down to. And Frank, there may be what we ordered the other night, because I hit express reorder. So there may be something in there for you if you want it.
Okay. Thank you.
So, I mean, there you go, ladies and gentlemen. Wow. Bet you didn't expect that to happen. I did not expect that to happen. And now the suspense builds. And the prosecution was worried, because I saw Ms. Woods over there with her head like this. Like I said, you got 4 prosecutors. Of course, they tried to act like it was no big deal, like anyone would, like never let them see you sweat, right? Well, Judge, this is no big deal. We'll just take till Monday to deal with this. And Judge Boyce says, nope, don't think so. The defendant has a right to know what charges he needs to prepare for in the preparation of the defense case in chief. And if I'm going to either allow him or, allow the prosecution to get around their little error here, he has a right to know that, not Monday morning when the court comes back. So, yeah, big breaking news. Nobody expected this at all. Now, the legal part of me would be like, rules are rules. The cynical part of me, the guy who's been a defense attorney for 29 years, is going to say the prosecution is going to get what they want. My guess is the judge will allow them to reopen the case. That's what I think is the issue. What they'll do. Maybe that's just the cynical side of me. That's the defense attorney side of me, where you're right and you still get screwed because the judge doesn't want what he believes to be an injustice. But the prosecutors are the ones to make sure that justice takes place. And if they messed it up, they got to be the ones to explain it away to the family, to the public. It's going to be interesting to see what they do. That's huge. That's huge, ladies and gentlemen. I mean, and to not catch it, for the prosecutors not to catch the errors of their way. I mean, we're talking, I don't think they can amend it anymore. They have rested. They've rested. And if the rules don't mean anything, and like I said, my heart goes out. If that happens, my heart will be broken for Kate and Larry Woodcock. Like I said, I've met them. We've chatted extensively. Like I said, Kate and Larry have called in on our Patreon show. And, I've credited this entire case to Kate and Larry. This case probably would not have been brought about. Somebody would have lost interest, but they were the ones that kept interest, everybody focusing, where are the kids? Where are the kids? When are they going to charge? Get these people. The prosecutors have had, the original indictment came back in May 25th of 2021, and they had the dates correct, it appears. And then they amended it in July of 2024 to change the dates from September 22nd, 2023, or I'm sorry, on or about September 22nd, 2023 to on or about September 8th and 9th of 2020, or 2020s. Let me try that again. The original indictment said that J.J. Vallow was murdered on or between September 22nd, 2020, September 22nd and 23rd, 2020. The prosecution then amended in 2024 to say that he was murdered on or between September 8th and 9th. And the evidence is contrary to that he has actually was alive on that date. So the evidence doesn't conform to the charging documents. So the question is, how do they get the dates to conform since they can't amend because the prosecution has rested their case? That is going to be huge. I'm sure there is some sweaty people in the prosecution's office right now trying to figure out how the hell did we screw this up and why didn't anybody catch it after 24 days of trial and 3 years and 2 months from the date that we charged it to the date that we amended it. That is huge, ladies and gentlemen. I mean, if you didn't have the elected DA doing it, somebody would be fired, but is she going to fire herself? It's her case. She took it over. At the end of the day, that's on her. And when the judge calls it out, like I said, the defense made a very generic motion for judgment of acquittal because that's usually what happens. And the judge basically said, hey, yeah, I get it, but this one count 4. Prosecutors, you messed up. You got it wrong. You amended it. We've had hearings on this. You said this is the date we want. This is the date you got. Here we are. It turns out it's not the date you want, but you've rested. And under the rule 7A of the Idaho Rules of Criminal Procedure, you can't amend. What are you going to do? Squeaky wheel. Scott, can Boise sanction the state and have the death penalty removed as an option? Well, you got one less murder if that's ultimately there. But the sanction is that count would get dismissed. That count would get dismissed. Like I said, I've only had one experience personally where I've seen it where I said, hey, judge, motion for judgment of acquittal. They won. They didn't produce any evidence as this actually took place because it's on my little checklist over here, judge. They didn't do it. Judge agrees. Not sure what to do. What does he do? Allows him to reopen, screw the defense. I jump up and down. It's unfair. Rules mean nothing, but the judge allowed me to do it. So that's really what it boils down to then is what is the judge going to do? I don't think that the prosecutors have a good faith argument saying, judge, we just learned of this during trial. We didn't know anything along those lines. They are the ones that were responsible for charging this going back to 2021. They amended it in 2024. Remember, they asked to amend in the Vallow case right before they closed because they had the wrong statute in the indictment. And they let them change it at the last minute. And the defense is like, whoa, how about some fundamental fairness? We've been defending on this subsection of the statute. And now you realize that's not the one. And so you amend it to this particular statute, subsection of the statute. So, this is not once. Now this is twice where a substantial error has taken place in the drafting and pleading of the indictment in the case of Vallow and now Chad Daybell. And I don't think the prosecution can come up and say, judge, hey, gee, we just didn't know. And like I said, that sucks. That sucks if that's the case, but they're the ones that are responsible for it. And this is what happens when you take on big responsibilities like this. And that's why there's big exposure, if you lose. Can you imagine if that had been on the other side, we didn't know we had the wrong dates, judge. We were planning on something else. Well, it's right there. You didn't see it. So I think that I think the state's got to be sweating bullets right about now, thinking that, oh my gosh, like I said, it's not like, oh my gosh, we just had all this new evidence come out. They've known about this. They amended the document. And for the judge to call them out on it and say, this isn't what you guys indicted. This is a real problem. Like I said, and the prosecution was like, well, we'll just wait. We'll just wait until Monday, Judge. We'll just, we've got Friday, Saturday, Sunday until Monday to come up with a reasonable solution. I wonder if they're watching Crime Talk. My solution is ask to reopen your case. That's the solution to it. Ugh. But I don't think they should be allowed to do that. I mean, this is not a little case where some DA just picked it up and, no big deal. This is a case that's being televised around the world, basically. The number of DAs at that table, plus support staff, and they filed the amendments. Where's the good faith? Oh, Judge, we made a mistake. They had hearings on the amendments of this date. The defense originally objected and then said, okay, fine, you can go ahead and amend. Okay, because apparently prior, or you think he must have known, you think you knew that, hey, that's the wrong date. He didn't raise it in his motion for judgment of acquittal, which would have been a little more interesting, to be honest with you. But the fact that the judge brought it up makes you really think, hey, well, the judge has been watching this and wondering, what are you people doing? Remember, the judge and the prosecutors were all there in the previous case. You would think they would have figured that out. Oh, this doesn't conform, but yet you amended it. Interesting. But it's not the judge's job to do their job. And now it's his turn to do his job, which is to call out the prosecutors and say, your paperwork is wrong. Big problem. Huge problem for the prosecution. And then the judge is in a tricky spot. Well, let's say he comes up and says, hey, let's do the Scott rule. Let's do the screw Scott rule. Let's allow the prosecution to reopen their case, amend the documents, and then rest to fix their error. Is that fair? I don't know. Once that jury's brought in, and the rules even say you can amend up until the time that you rest, and they've rested their case. I don't see how the judge gets around that. The only way I could possibly think of is the rare exception to allow them to reopen their case. I've only ever seen that once, and it was in my case, of course, and not my case, but a case that I represent a client on. My client was a bad dude, and they didn't produce evidence as to jurisdiction, and judge didn't want the bad guy to get away, so he bent the rules. But my guess is, like I said, I am a lawyer. The rules are made, must be followed. The plain language. We have competent attorneys. Everybody knows the dates. They amended it. They've had all these other people working on this case. There's no way in heck that this should, in fact, be amended. I'm sorry, Madam Prosecutor, but count 4 dismissed. Then the defense attorney me is going to be like, all right, this is what the statute says. They've rested. I should win. Count 4 should get dismissed. But like I said, the cynical defense attorney part of me is like, oh yeah, this judge is totally going to screw me. Because, even though the judge is there to call balls and strikes, doesn't care who wins, just to play by the rules. These are the rules, right? I mean, think about it. If you went to your favorite sporting event and the umpire or the referee, so these are the rules. You put your foot outside of the line, it's an incomplete pass. Just use football, for example. But if the judge is like, well, he was running really fast and the other guy kind of pushed him just a little bit, right? We're going to say his foot would have been in because that's what he meant to do, right? You'd say, that's not fair. The other side's going to say that's not fair. right? That's what judges are supposed to do. Just call balls and strikes. Do judges get it right all the time? No. Just like the referees get it right, umpires get it right all the time? No. That's why they got a review. That's called the appellate courts. But the point is, you're supposed to make the call based upon the rules that exist at that very moment, and you don't get to bend them basically because they do this. But my guess, I mean, like I said, the cynical part of me is going to say this judge is totally going to bail the prosecution out of the situation that they have put themselves in through their own lack of diligence. Yeah, somebody says Scrivener's error. No, not an indictment. No. Indictment is a big deal. And apparently in Idaho, like if they've done like everywhere I've ever practiced, we have to go back and do it. I mean, that's a finality. That's the charging document. And Idaho has very loose standards as it relates to amending the indictment. The judge even read it to him. You can amend the indictment up until the point the prosecution rests. That's not the way it works. That's not the way it works here. Because, you know, you want to change that date? You want to change on this to this date to on or about or a between date? You got to go back and supersede, which means you got to go back to the grand jury. So grand jurors, when they're given that indictment, they sign it, you know, they'll indict a ham sandwich kind of thing. But the prosecutors are the ones that draft it. They're the ones saying, this is what I want you all to agree with and to go along with. And so, yeah, that is the situation. Little hot water, the prosecution did that. Okay, I don't know if that's somebody does miss my humor. I don't think I was trying to be funny in any way, but if that's somebody else's. But I mean, the reality of it is that prosecution's problems. So, quick reset for those who just joined us. I noticed that we've had quite a few people join us. Today was basically the last day, the last witness that the prosecution was going to call in the case of Chad Daybell. That took place. The prosecution rested after they had a little powwow amongst themselves. That's when they all gather around. Did we get everything, guys? I think we got everything. Yeah, you good? You good? Yeah, I'm good. You good? We got everything, right? Yep. We got all our exhibits in. Yep. Good to go. Judge, the prosecution rests. They took a little break. Defense makes a pretty generic motion for judgment of acquittal. The argument by the defense was that the evidence has not suggested any direct involvement as it relates to the death of Tylee and JJ, and the conspiracy, that there were no acts in furtherance of it, and that any of this religious speak about dark people this and dark people that, and the world coming to an end, that's not an act in furtherance of it. That is just religious talk, gobbledygook as it relates to what they believe, and that there was no fraud as it relates to the insurance money. The prosecution then responded, went through every charge, saying, you know, there's all this stuff saying that he participated. Everybody knows Alex Cox is the one that was the bad guy, but obviously if it's a conspiracy, text messages where he's saying, hey, JJ was dark, not himself. He can't wait to get together with Lori Vallow. Goes through all of the exchange burner phones on October 7th. Alex Cox they went to Sportsman's Warehouse. He prepared as it relates to Tammy Daybell. Text messages saying that he will feel free soon because, you know, he would know that Tammy may be leaving us soon, right? But then at a funeral, he said it was a miracle. He had just happened to ask for all the financial passwords and everything that Tammy Daybell had. And then ultimately he, right before she died, and then he cashed out, went to Hawaii, and then 2 weeks later was married. So you think, okay, you know, I'm not sitting here reading the indictment. Did they get all the dates in? No, I'm not. But the defense didn't raise this issue. But then the judge said, hey, prosecutor, Madam Prosecutor, got a little question here. You say here in count 4 in the original indictment, which was dated May 25th of 2021, that the first degree murder of JJ Vallow was on or between September 22nd and 23rd of 2020. But then you specifically amended that in July of 2024 July of no, July of 2023, right? July last year, they amended it to say that the murder took place September 8th and 9th of 2020. And the judge is like, hey, this is what you wanted. You amended it. We had a hearing on this, and you got the wrong date. Because the last, in fact, the evidence that we heard was that JJ was still alive up until the 22nd and 23rd. He was clearly alive on September 8th and 9th of 2020. What am I supposed to do, Madam Prosecutor? I didn't force you. I didn't press you with any time limits or constraints. Rule 7A says that you can amend the complaint information or indictment in this particular case at any time up until you rest. You have rested, Madam Prosecutor. What am I to do? Of course, Mr. Pryor's like, hey, Judge, yeah, I didn't raise it, but they've rested. Not sure what you can do. You need to grant the motion for judgment acquittal as to count 4 as it relates to the death of JJ Vallow. Prosecutors got it wrong. They messed it up, and you need to follow the rule of law. Prosecutors, pretty smart people, right? They brought a death penalty case. They've had 4 years in which to prepare this case. They filed the indictment. They amended the indictment. They know the rules. They're very competent individuals, but yet here we are, and the evidence does not, you don't get to change the charging documents to conform to the evidence that you submitted when it was your pleading. It was your indictment. And so now the judge is in a tight spot. Does he let these prosecutors off the hook by coming up with some novel way of allowing them to amend after they have rested, which is, I mean, the judge read it right there to the district attorney and said, you've rested. What am I to do? Now, being the wise attorney that I am and had this experience before, I threw out a suggestion. So I don't know what authority there is in the great state of Idaho. However, I told you my experience where I had a case where the prosecutor failed to prove any evidence as it relates to jurisdiction. Never said that it took place in the county of Adams, state of Colorado. They've got to do that. Even though that everybody knew where the street address was, everybody knew that you got to say it. It sounds silly, right? Was that then and is it now in the state of Colorado, county of Adams? Yes. Then you see the little check going off, right? And the prosecutors as they stand up there. And I objected. I made my motion for judgment of acquittal. And the judge allowed the prosecution to reopen to bail them out. So, like I said, if the attorney side of me and saying, well, the system is fair, the judge is going to call balls and strikes, and he's going to follow the law. This is the indictment. The prosecution has rested. There is no mechanism for me to allow a prosecutor to make the amendment. Unfortunately, Madam Prosecutor, this is your indictment. You amended it. You've had 4 years to do this. I have no choice but to dismiss count 4, and there will be no justice for JJ, at least as to count 4 in the indictment. However, the practical, realist, cynical defense attorney will say, oh, this judge is totally going to come up with a way to screw the defense and bail out the prosecution, because that's what the prosecution does. Now, if you've been watching Crime Talk for the last several years, I'm a defense attorney. I was a prosecutor a long, long time ago, but I've been a defense attorney, and I've gotten screwed so many times by judges because the prosecutors were not good or incompetent or made a mistake, and the judges bailed them out. And it's completely unfair, but it happens all the time. So clearly it makes for great commentary and great television, and the suspense builds. And because the judge is like, I'm going to give you 2 hours. I'm going to give you 2 hours to fix this problem, Mr. Prosecutor. Give me some way to help me help you, is what he is saying. Because my guess is he goes, I'm not aware of any case law or any authority allowing me to change this. But I'm sure if there's always a rule, and it's always in favor of the prosecution. Okay, remember that, because nobody wants the bad guy to go away. or get away with it, right? That's just the way it is. And so there you go. Yeah. And Michelle knows, hey, dang, drop count 4. Yeah. That's one count, but still, he was charged with conspiracy resulting in the death of JJ. He was never charged as a direct person who did it. It was always a conspiracy. Doesn't look good, right? I mean, I swear to God, the best moments for, when like, oh, I'm going to win this case. So when the prosecutors can't get their computers to work, audio-visual issues, they can't get the computers to play, the sound to play, or they mess up. Jurors know, like, where's that case? Where's that? They didn't present any evidence. Oh, they messed it up. Well, gee, I don't know. Did they get any of this stuff right? You got to start looking at it. I'm telling you, they have got the pucker factor at the DA's office right now has got to be so freaking tight. I'm sure they've got everybody in the office trying to come up with a solution. Jennifer D, as a lawyer, this is always one of my biggest fears. Always check what is filed. And let me give you an example. Okay. We just represented somebody on a homicide case. We got a very favorable disposition. And then somebody went and sued, people will just leave it at that. But the attorney put in the wrong name of the deceased person. Well, guess what? They filed that. And now guess what? We get to file a motion to dismiss. Now they can refile, but they're going to look really silly in front of their client. Right. And you know what they say in the civil world? Oh, you mess up. Oh, you forgot to submit this evidence. You know what they do? The judges say, sorry, I'm granting a motion, but there's a remedy. It's called contact your malpractice carrier. Prosecutors don't have anything to worry about here because, they got immunity. Oops, sorry about that. That's just the way it is. But, the reality of it is that's it. And we will, somebody asked, somebody asked what's going on. Not a mistrial. I'll explain in just a minute, Pam, but I'll kind of recap. Yeah, it says I was a civil attorney. So yes, malpractice, always the biggest fear, right? That's what keeps attorneys up at night. You wake up in a cold sweat. Did I miss a date? Did I miss a date? Did I miss a date? Did I put in the wrong date? Did I not forget to do something? So yes, our fellow attorney out there gets it. If somebody says, yeah, I do law pro. Yeah, you got all kinds of ticklers, do it, everything. But at the end of the day, somebody's got to draft that complaint. Somebody's got to draft that indictment. Somebody's got to double check it. Somebody's got to do it. Okay. So yeah, that's where we are. But the remedy is, I hate to say it, is dismissal of the charge. Unless, like I said, what happened in my case years and years ago, just allow the prosecution to reopen. But like I said, the DA's office right over there right now is probably got everybody working, figuring what they can do. If they got any sense, they're saying, hey, let's check out that Scott Reich guy. Maybe he knows something. I'm throwing you guys a bone, ladies and gentlemen, at the DA's office out there. I'm throwing you a bone. Like I said, the lawyer side of me is, these are the rules. Prosecution missed the rules. Point goes to the defense. Case, or not case, but that count 4 is dismissed as it relates to the death of JJ Vallow because the prosecution got the wrong dates. The cynical side, as the defense attorney, also says, oh, don't worry, prosecution. This judge will bail you out. He's giving you everything you want from day one. Why should this be any different? And, you're going to get what you want. But right now, the whole world is watching. The whole world is watching. What is the judge going to do? And he threw him a bone like, hey, guys, you got a problem here. Big problem. Dates don't conform. You originally charged that JJ Vallow died between September 22 and 23 back in 2020. Then you amended saying he was dead on September 8th or 9th. And in fact, the judge said, but that's not what the evidence shows. In fact, we know that he was alive after September 9th. So what do you want me to do? And he reinforced to them and said, well, if you look at the rules, you can do this pretty much whatever you want before you rest. And you rested. And the defense has already made their motion for judgment of acquittal. The judge now has it under advisement. Like, give me some authority to see how you can amend this, because I'm not aware of anything. He didn't say that, but that's really what he's saying is the rule's pretty straightforward. What am I to do, prosecutors? You've had this case. You have this entire team, all the resources. And this is what it comes down to. Welcome to the practice of law, ladies and gentlemen. Like I said, one of our commenters says, hey, I was an attorney. This is my biggest fear. This is every attorney's biggest fear. You miss something. Charges get dismissed. There's no justice. You don't assert a defense. You can't raise it. You make the mistake. You ask the wrong question. This is what keeps you up at night. That's why, not everybody does trial work. It's just the way it is, because it is a risky, scary business. And if you mess up, everybody's watching. And in this particular case, the whole world is watching. What will the judge do? Will he stick his neck out for the prosecution? Probably. So short and nice, can they reverse the resting? My position would be no. But that's what they've done. Like I said, I had an experience years ago. For those who have just joined us, the prosecution messed up big time in the case of Chad Daybell. The prosecution rested. They had their little powwow where they all got together, all of them huddled. Did we get everything? Yeah, we got all the dates, right? We got our exhibits in. Yeah, we got all our exhibits in. We double-checked that, triple-checked that. Yep. Defense makes their motion for judgment of acquittal pursuant to Rule 29. They're probably going to lose. I said, they're going to lose. This is rather perfunctory. The evidence has to be viewed in the light most favorable to the prosecution, drawing all inferences in the favor of the prosecution. And it's not the judge to substitute his role as a 13th juror. I didn't have the indictment in front of me. And the judge says, hey, Miss Prosecutor, you originally charged that JJ died on September 22nd or 23rd of 2000 or 2020. And then you amended the document back in July of 2023, saying that he died on September 9th of 2020. And he says, we have evidence completely to the contrary. What am I to do? What am I to do? You've rested. You can't amend. I read you the rule. What are you to do? Huge, huge problem for the prosecution. Like I said, if the judge follows the rules, count 4 dismissed. Sorry. Unfortunate. Right? Kay and Larry Woodcock, the grandparents of JJ, the ones that have pressed this case from the beginning. Where's our grandson? We want to see our grandson. Where is he? Probably this case wouldn't have existed without them. Can you imagine the prosecutor having to go back there and say, oh my God, I am so sorry. Potentially could happen. And like I said, if you read the law as the statute, the rules state, the prosecution's done. Count 4 should be dismissed. The question is going to be, is the judge going to have some mechanism, some authority or case law that's going to allow them to somehow reopen their case, amend, then rest again? That's the only solution that I could foresee in this particular case. If somebody else has some other suggestions, I don't know. Because normally when you rest, you rest. Like, that's the prosecution saying, ta-da, we're done. We got nothing else. This is as good as we got. We got no more. And it's their job, their responsibility. Huge, 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 huge mistake. And like I said, I've gotten screwed by this. It doesn't happen that often. This, in all honesty, I have to say, and I'm not trying to disparage anybody, but that's like a county court deputy mistake, right? You got different levels. You got like county court, and then you got district court where felonies are handled, and all young prosecutors start out in county court handling misdemeanors, and you got to learn go through. Did this happen on this date? You sure about this date? Yep, positive. Was that in that particular county and state? Yes, it was. You got to give all the elements. Do you see the bad person? Identify the bad person, right? All those things that we talk about, in our loved, right? We talk everything that the prosecutor has to prove. I don't know if you can see this, right? Probably not very good. Location, jurisdiction, the offense, the victim, right? Identification. Oh, there you go. And then date and time, right? That is the Reich Law Firm summary of basically everything the prosecution has to prove. The location, did it take place in the jurisdiction where the charges are brought? What is the offense? Then you have to have all the elements of the offense. That the defendant killed somebody or conspired to kill somebody on a date about certain, and they died on this particular date, right? The victim, somebody's actually dead, deceased in this particular case. Identification, that the defendant had something to do with it. Not somebody that looked like him, not someone that used their identity, but it was in fact them that had involvement. And oh, that's right. Date and time. Date and time. And the prosecution had the date and time right. Then they changed it to a different date. How does that happen? How does that happen? I'm telling you, this is going to be the most suspenseful part of the trial because frankly, and I haven't watched all of it, but it's been pretty boring. And I was lucky enough today that I had a quick court appearance and I was like, oh, they're getting ready to arrest. This ought to be interesting. We'll see. I figured let's just see if they roll right into it. Apparently the defense is going to start their case in chief on Monday. And the prosecution's like, well, judge, let us just come back on Monday and we'll deal with this. And the judge said, oh no, this is too important of an issue. The defense has a right under fundamental fairness to know what charges they're going to have to defend against on Monday when they present their case. Does it include a charge of, conspiring to kill J.J. Vallow on September 8th and 9th? Or is it going to be dismissed and he doesn't have to worry about that? Defense has a right to know. So the judge says, I'm going to give you 2 hours. You got 2 hours, prosecutor. Come up with some argument. And I don't know. I wish we could go back. I wish, but since we're live, it's like got to download or whatever. But I swear, Miss Woods was over there like, oh my God, like had her hands at her head. She knows that's not good. She knows that's not good. Everybody in the courtroom knows that's not good. The judge called it out. Pryor didn't raise it. Frankly, it would have been, like, oh, okay, Mr. Pryor, but he's like, he did say, hey, judge, you need to grant this. I didn't raise it, but you did because that's your job. And the judge has a duty to follow the law. And Pryor's like, hey, judge, they've rested. Not only have they rested, I made my motion and they rebutted it. And not once did they say you can amend it at any time. Judge calls him out and says, no, I can't do this. What are you going to do? It's going to be huge. It's going to be suspenseful. Fortunately, we're all here watching it. I don't know, Frank, how much longer do we have till they come back? I don't even know. Do you know what time they went out? I should have been taking better notes. If I was a judge, I would do that. We did a trial recently, and the prosecutor was claiming that the trial went over because the defense was taking too long. And she's like, oh, no, actually, the prosecution, they went estimations of time that we'd have direct and cross. And the judge was like, no, you started this witness at this time and you ended at this time. Cross began here, redirect be here, had all the times written down. If I had been a judge and watched this case, I would know this and I would have written down what time to come back. If I was the attorney on the case, I would have known what time to come back. But the reality of it is, can you imagine? They've got to be dying. I mean, you think the prosecution is over there throwing stones at people? Do you think they're throwing stones at people? Do you think someone's going to step up and say, "Oh, we blew it. I got to go tell the family that we blew it," and we may not get justice for JJ? And think about it, right? The death penalty was for the 3 homicides, and if you can get,
Now for 1 hour.
they've been out for 1 hour.
Yeah.
So we got another hour to go. Frank, maybe we should, can we do the call-in studio? And we can maybe take people's calls as to what they think
Couple minutes.
should take place.
Couple minutes.
Somebody, prosecutors are Googling how to set up a solo law practice. Yeah, I mean, that's not good. It's bad. Convicted or not will require, give them approval. Yeah, it's, I mean, it's just interesting to see, but like I said, welcome to trial work. Every trial, you think you've tried to think of everything, right? Attorneys' jobs are to think, what if they do this, then I need to counter with this. What if this, what if this, what if this, right? That's what you have to do. And there's always something you don't think about. Oop, didn't see that one coming, right? Do you think the prosecutor saw that one coming? No. Obviously, the defense didn't because they didn't raise it. So yeah, interesting. Scott, if you take calls from Victor, you may lose its points. Okay. Yeah. If the one of the questions here was if the charge is dismissed, is it with prejudice? Yeah, it's dismissed. Jeopardy is attached, and so, like I said, they've presented no evidence, and that's the problem. You have to present some evidence to conform to the charging document.
Audio recording
So
on.
the charging document that was amended by the prosecution said that JJ was dead on or between September 8th and 9th of 2020. But the evidence was no, he was alive probably up until the 23rd. So there's been no evidence presented that JJ was deceased on that particular day. The only way is if the judge is going to allow, the only way that it should be dismissed based upon the plain reading of the rule. And no evidence has been presented to that. In fact, quite to the contrary. The question then becomes, is the judge going to allow some sort of an amendment or allow them to try to allow him to reopen the case, somehow amend after they've rested? I mean, the judge, you better have some case law from somewhere, and it better be like, oh, this happens all the time. No big deal. It's a big deal. Big deal. And the judge knows it's a big deal. The defense knows it's a big deal. So yeah. Huge. Let me see if I can, I didn't bring my other stuff because I wasn't expecting all this stuff. Let me just pull something up real quick. All right. So we got since we weren't planning on doing this, but hey, why not? Let's go ahead and open the Crime Talk call-in line, 725-228-TALK, 725-228-8255. We'll take your calls and see what you have to think about this little predicament that the prosecution has put themselves in. And what would you do? Do you think it would be fair to allow the prosecution to amend? I mean, is it fundamental fairness, justice? Well, Judge, the defense isn't prejudiced. They knew all along what the date was. And so, they shouldn't really be, let me go back here. It was July. Let me see here. I'm going to pull up the, hold on here. But we have one rule. If you do call in, you have to talk on your phone because if you use your computer, there's a delay. And so it'll be a very awkward conversation. So you need to do it that way. All right. I'm just trying to pull up something here really quick because I want to double check some dates here. Let me just double check something here. But you know, when the judge calls you out on something like that, the prosecution, I mean, I just couldn't imagine going to Kay and Larry and saying, "Oh my gosh, I'm so sorry. You know, geez, what can I do?" Let's see. When did they do that? May of 2021. No, they did July 2023. I'm trying to look. I just want to pull it up here. Just looking for something here really quick. Sorry. Just want to make sure we get it right. Let's go back up here to the top. Let's just go back up here to the top. Let's go back up here to the top. All right. So let's just take a look at the original indictment. Count 4. This is the original indictment. Count 4. The defendant, Noreen Vallow, on or about the 22nd and 23rd day of September 2019. I'm sorry, I've been saying the 2020. I'm sorry, 2019 in the county of Madison, state of Idaho, and as part of a common scheme or plan or continuing criminal transaction between Madison and Fremont counties in Idaho, was concerned in the commission of the first-degree murder and did aid and abet in its commission, or not being present, advised and encouraged its commission, or by command compelled another to commit the crime, and did so with malice aforethought, and did so willfully, deliberately, and with the premeditation, which resulted in the death of a human being, to wit, did either kill J.J. Vallow and or assist in the killing of J.J. Vallow, and or did encourage the killing of J.J. Vallow, and or did command another to kill J.J. Vallow. The key issue here in this particular trial is the dates. Originally, the indictment says September 22nd and 2020, September 22nd and 23rd of September of 2019. I think I said 2020 previously. I'm sorry. So that's it, on or between those two dates. Okay. Now let me get to the amended indictment, because that is what is at issue. I want to look at the exact dates. Let's see here. Was that July of 2022? I believe that they did that. Let me double check.
They did that on file and
I know we've talked about it. They're just so.
February 20th.
They amended the indictment. I thought it was. Oh yeah, February. Okay, it's 2. I can't remember. February 20th of 2024. Jeez, man, that means they had even longer. February 20th. Here we go. Amended indictment. February 20th of 2024. Count 4. The defendant, Tylee Daybell and Lori Noreen Vallow, on or between the 8th and 9th day of September 2019. Wow. Yeah, the prosecution messed this up. So here it is, count 4. Remember, the previous indictment was on or between September 22nd and 23rd of 2019. The prosecution amended it this year, ladies and gentlemen, from the original indictment, going back to 2021, they've had 3.5 years. And it says the defendant, Tylee Daybell and Lori Noreen Vallow, on or between the the 8th and 9th day of September 2019 in the county of Madison, state of Idaho, as part of a common scheme or plan, continuing criminal transaction between Madison and Fremont counties in Idaho were concerned in the commission of a first-degree murder and did aid and abet in its commission, or not being present, advised and encouraged its commission, or by command compelled another to commit the crime, and did so with malice aforethought, and did so willfully, deliberately, and with premeditation, which resulted in the death of a human being, to wit, did either kill J.J. Vallow and or assist in the killing of J.J. Vallow, and or did encourage the killing of J.J. Vallow, and did command another to kill J.J. Vallow in violation of the Idaho Code, Section 18-4001 and 18-204, 18-4003A. So that's when the amendment took place, going back to 2019. So they've had, since 2021, they first filed this case, and here they are right now, just realizing when the judge calls them out on it and says, you got it wrong. You got it wrong. All right, we got a call. Who do we have on the line?
No name.
Okay. All right. Who do we got?
Hello?
Can you hear us?
Scott, this is Beth.
Hi, Beth. How you doing? What do you think of what's going on?
It's very interesting, but it's par for the course. The prosecution team did screw up with the dates that Lori was in the mental hospital, which canceled out her speedy trial. So they took the death penalty off the table.
Yep.
Now we're here at the last minute. And wasn't JJ and Tylee conspiracy and Tammy was the death penalty?
Well, no.
So would they just take out?
No, the conspiracy were for JJ and Tylee, because everybody, is of the mindset that it was Alex Cox that actually committed the murders. Then, they're basically trying to say that he killed Tammy, but the death penalty doesn't come from a particular count. I mean, yes, it's for the financial remuneration, but also the sheer number of homicide cases that he would have been convicted of. So that's what that really comes from. So
Judge Boyce could then say, we have to take count 4 off the table, but the death penalty is still on the table for Tammy and conspiracy for Tylee.
Correct.
Because of the clerical error.
Correct.
I am just so bloody angry.
Well,
if I can say that.
Hey, I mean, like I said, this is a mistake that is totally 100% prosecution's fault. I mean, and listen,
Oh, yeah.
I think anybody would, what's the word I'm looking for? But what's the word I'm looking for here?
If you were Pryor, what would you do?
Well, and remember, Pryor's not the one that brought this issue up. It was the judge.
No, the judge did.
The judge is the one that brought it up. But Pryor said, hey, Judge, I just want to make a quick record here real quick. They've rested. You need to dismiss count 4. And I think he's right. The judge is like, hey, Madam Prosecutor. Oh, did I mention there were 4 of you over there? Here's the thing. 4 of you over there. Give me some authority to say, how does this work? You originally charged the dates of September 22nd and 23rd of 2019 back on May of 2021.
No, February 2024.
No, they originally indicted this case back in 2021 and they had the right dates. Then they change it back in February 20th of 2024, 3 years later, just about 3 years later, to the wrong dates. And then they get it wrong. Why should he allow them to change this in any way whatsoever? I don't think so.
I don't either. But then again, it's better than this coming out later and this being a mistrial. And Chad getting off of it completely.
Yeah.
Couldn't this been a reason for a mistrial?
No,
The dates?
no, no,
Oh,
no. The remedy is
Oh,
dismissal
okay.
of the count. This isn't going to result in a
oh,
mistrial.
okay.
It just means that count is dismissed.
Oh.
The jury won't get to decide anything about it. And the judge will have to instruct them, you can't consider any of that evidence as to that count because I've dismissed it. And you don't concern your, little juror heads over there with anything. I've made legal rulings. You can't do it. Yeah.
Okay.
I mean, it's
I thought this could have been a mistrial for John Pryor after the trial, that he could say, well, this is a mistrial because you got the wrong dates in
No.
there. And
it wouldn't be a mistrial.
but I was just thinking for count 4.
It's just they'll dismiss it as it relates to count 4. But that's still significant. That's
Yeah.
the count of JJ Vallow.
I know.
Right? That's Larry and
I
Kay's
know.
grandkid. I mean, to have to go to them and say,
I know.
sorry. All right? That's going to be
But they're
tough.
going to
for
have
them.
to.
Yeah.
And that's going to be the prosecution team. I mean, you've got Ingrid Beatty and Rocky Wickham that are special DA assistants to the state of Idaho.
Yep.
I can understand Rob Wood and I can understand Lindsay Blake, but when you're supposedly the assistant special district attorney for
Yeah.
the state,
They're from the AG's
you
office. They're
should couch
supposed-
posing.
Yeah. They're from the AG's office. They're,
Yeah.
Woods is always, and Clark, they're always like, oh, we're not familiar with these big city ways, right? So they bring in
Right.
the special assistant attorney generals to assist in the case. And lots of states do this, but they're supposed to be the experts, right? They're supposed to be the ones that are supervised, making sure the
Right.
little hayseed attorneys out there don't mess it up. And it looks like they all
Well, Rachel Smith was on the case, and then they moved her to another high profile case in Idaho and brought these two in.
Yep.
But they sit in the AG's office for the state of Idaho. But maybe somebody should be proofreading over the clerical recorder
Yeah.
or what?
You would think, I mean, an indictment is a big deal. I'm telling you, normally I've never seen anything like it allowed in anything where I've done. When you have an indictment, if you supersede, you go back and you had to present that evidence to the grand jury. You don't just get to amend like a simple complaint and information by motion. But apparently in Idaho, you can. And maybe there's some historical
That's not
reasons,
traffic
right?
court.
But the reality of it is the key factor here is that the case has been the prosecution has rested, and it says you can amend anytime up until you rest. You've rested. Like I said, the only thing I could think the judge could possibly do to throw them a bone would be allow them to reopen the case and then allow them to make the amendment and do that. If that takes place, completely unfair in my position, in my opinion, but I totally believe that's, like I said, as a defense attorney, you get screwed like this all the time. So don't be surprised if the judge steps in and helps out the prosecution. But that should be offensive to a lot of people, right? And not just because, oh, well, he gets away with, his involvement with the death of JJ, right? No, it's offensive. That the rules don't mean what they say they mean, right? Like I said, go to any.
It's a double standard.
Well, and that's what I'm saying. Go to any sporting event, right? And if there's an umpire and there was a referee, and he had the opposing team's hat on, right? Was going to make those close calls always go towards the team
home
that he
team.
had, right? You'd be outraged. You say the whole thing is rigged. This isn't fair. Do the rules not mean anything?
Right.
Well, they don't if they don't mean anything. So.
Yeah. And there's no consequences.
Yeah.
For those actions. And it might be that, I feel so bad for Kay and Larry and the families, but it's the consequences, and the prosecution team needs to accept that consequence, unfortunately.
Yeah.
And we'll find out at 2:30 what time, what the judge is going to, what the prosecution team is going to say, and what the judge and Mr. Pryor will say. Well, thank you, Scott. I'm sure you have other callers. Thank you for talking with me and have a great afternoon.
Thanks for watching. Thanks for calling in. Appreciate it. Really do. Looks like somebody gave a super chat there, Frank. I can't seem to pull it up. Let me see if I can find it. Okay. Shane 68. Thanks for the super chat. We don't ask for them, but it does get our attention, I assure you, because it gets highlighted on my screen here. Do you think the judge knew about this for a while and has had an idea about how the prosecutor could amend this with precedent without dropping the charge? Well, the judge, everybody's known about the dates, right? I'm a little surprised Pryor didn't mention that in his motion for judgment of acquittal, but the judge did. The judge has obviously sat through the Lori Vallow trial, as did most of these prosecutors. You would think that they would have known the dates. You think they would have, if they had an issue, they would have amended like they did. In Vallow's case, the prosecutors amended right before they rested and had a completely different subsection under the statute that they had charged. How is that not unfair? I was like, are you freaking kidding me? And that's why I was just flabbergasted. Like I said, my experience is an indictment is indictment. Nothing changes in the indictment unless you supersede the indictment. And I thought that was outrageous that the judge would allow them to do that. Like, you've had 4 years to fix this, and now you realize moments before you close, oops, wrong statute. Now, the defense had been relying upon that and could have gone and said, Judge, they charged this. But hell, in the Lori Vallow case, the defense basically asked for motion for clarification. Like, you've charged this particular subsection. Are you sure this is what you want to charge? No, this is it. This is it. And then they figured out, oop, wrong one. Okay. And the judge let them do that, but it was before the close. So he allowed it. This is a little different opportunity, a little different situation. Here, the defense has made their motion for judgment of acquittal because the prosecution has rested. And the judge, sua sponte, on his own says, hey, I got a problem here. I have a duty, obviously, make sure everyone gets a fair trial, right? Call them balls and strikes. Prosecutors, you messed up here, man. Give me some reason. He's literally asking them, I'm going to give you 2 hours to find a way for me to fix this for you because you messed it up. And that's what this comes down to. They messed it up, right? And I know some people, if you've been watching, our little show for a while now, particularly when we first started, how can you defend the guilty people? Oh my God, blah, blah, blah. It's about the due process. It's about following the rules, the Constitution, all that stuff. And I was always like, man, if you think somebody gets off on a legal technicality, it's not a legal technicality. It's called the United States Constitution. It's called the Rules of Civil Procedure. And if you think that the bad guy gets away with it, you got one person to blame, the prosecutor. It's their case. It's their burden. They're the one responsible for calling the evidence. They're the ones for producing the witnesses, bringing forth the evidence, and making sure they've met all the elements under that of the charge, right? Our little loved thing. I summarize every case we get with a loved, even if it's just on the inside of a file. All right, I know this is the date, right? Sometimes, like back in the old days when I was trying lots and lots of cases, I was like, what was this guy's name today? Right? It wasn't like that, but you know what I'm saying? You got lots of cases. I would write my little loved out there so I knew, they didn't get the date. They didn't get the jurisdiction. Is this really the victim? Here's the charges. Here are the elements, right? The defendant on about this date did this, boom, boom, boom. If they missed one of those elements of the offense, motion for judgment of acquittal. So you would think my little loved chart, I'm sure the DAs know about it. It's a quick summary, for God's sakes. I got it from somebody who brought it from somebody, but that's what you have to prove. Frank, can you pull up maybe I can do it here, the little loved thing real quick? Right, here it is. This is what you have to prove. Loved. Location. And we're talking about location is it in the jurisdiction? Are we in the right venue? right? The jurisdiction and venue. State of Idaho, is this the right venue? Madison County, but it got moved, all that good stuff, right? Then you have the offense, conspiracy to commit murder. What are all the elements of the offense? You can break that down. Obviously, you have to identify the victim, that they were alive and now that they're dead, right? Identification, you need somebody to come in and point to, or through circumstantial evidence, show that it was the defendant that had something to do with this, not the one who looked like him, not someone that had access to his computer, something along those lines, but it was in fact him. And so they have to do that. And most importantly, date and time of the offense. Now, they don't have to have the exact moment. It was at 12:56 that somebody died. No, but you got to get the date. And if you're not sure that it happened exactly on, say, May 16th, by way of example, then you have to say it was on or about. Because, well, it could have been on the, in this particular case, it could have been the 8th or the 9th or the 22nd or 23rd. Or they could have said that he died sometime between September 8th and September 23rd, if you really didn't know. But when you pick those dates, ladies and gentlemen, the prosecutor's saying, I can prove that date beyond a reasonable doubt. And here, they had the right date, the September 22nd or 23rd of 2019. They amended as recently as February 20th of 2024, saying it was September 8th or 9th of 2019. And you can't fix that much. I mean, if it was maybe it's squeaked into the 10th. But here we're talking a couple extra weeks. I just don't see how the judge should allow this unless he wants to bail them out. Okay? So for those playing at home, remember, that's what you should always look at the Lovett. It's a good little summary. This is the offense. This is the victim. This is who they're going to bring into, how they're going to ID him through cell phone records, admissions, anything along those lines, and the date and time, right? You got to prove that. Simple, simple, simple. And you would think that the prosecution would have done that since they had 4 freaking attorneys over there. And like I said, they drafted this 3 months ago, not even 3 months ago. And they had this same thing happen in the Vallow trial. They had the wrong subsection of the statute. And the judge had not allowed them to amend at the very last second. Probably, she would have had a shot, maybe. I don't know. But they could have said, Judge, they didn't prove the elements under this subsection that they charged. Remember, it's not like the prosecution shows up and says, oh, I just got this date. I don't know where it came from. They're the ones that picked it. They're the ones that went to the grand jury. They're the ones that amended it. And all of a sudden now it's wrong. Like I said, if that was you or your family member and said, hey, they screwed up, you'd say, grant it. Obviously, if you're on the prosecution side, you're like, well, Judge, where's the real prejudice if you allow us to reopen this case? That's what they're going to come back and argue. Judge, you should allow us to amend it or reopen it so that we can amend it. There's no real prejudice to it because, the defense is known. They had the original indictment, going back that it was September 22nd and 23rd, but now it's, this new date, the 8th or 9th. I mean, they should have known. Mark my words, they're going to make that. There's no prejudice. They knew. Let us amend it, Judge. If not, no harm, no foul. They're going to come out and act like, yeah, we screwed up, Judge, but the defense, they didn't need to, they didn't, were prejudiced. What's the big harm? No big harm. No. Don't make me look bad, Judge. I guarantee you, they're going to come back. They always do, and act like it's the defense's fault or something. I swear to God. Wait for it. Okay? That's what they do. Well, they're not going to come back and say, Judge, you should dismiss count 4. They're going to come up. They're going to start tap dancing. They're going to come in with the big hands finish. Dun, da, 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 right? So they're going to come up. Judge, this is no big deal. Allow us to reopen the case. No big deal. No prejudice. You weren't going to dismiss it anyway. He didn't even highlight this argument. You had to do it for him, Judge. So let us take the victory here. And, this is about justice, Judge, and it's not about Scrivener's errors. And we need to make sure that we have, seeking justice. And so there's an exception to malpractice For prosecutors, it's called we're seeking justice, and it would be an injustice if we allowed injustice to take place, and therefore we should allow it to be, amended or allow us to reopen the case. And then I'm going to lose all faith in Judge Boyce, even though I've lost faith in him several times of the way he's handled this case. But, this is his moment to say, I'm a judge, plain fair, calling balls and strikes. This is the prosecution's case. It was your indictment, your amendment. We allowed him to amend, maybe, like I said, old Pryor, maybe he, I said he's certainly a hell of a lot better than the attorneys that Lori Vallow had. And he's been kind of nice and gracious the whole time. You betcha. He said, I let him amend, and here it is. Maybe he was just figuring, I'm not going to tip them off. I'll wait till closing argument to bring this up. But now that it's here, here you go. So, maybe he's playing a little game of possum with the prosecutors, and they fell right into it. But for whatever reason, and I would love to know, but if I remember correctly, I think those amendments were done in closed chambers, weren't they? Could you imagine if they had been in the open public? Because somebody could possibly have said, prosecutors, I think you got it wrong. But remember, they didn't want that scrutiny. They want everything done in secrecy. I mean, it is. I mean, seriously. I mean, like I said, I don't know if Pryor was just playing possum or if he didn't catch it. And, like I said, maybe he was thinking, I'll just wait till a closing argument. They've rested. I'm not going to tip them off and, had some big argument. Or did he just miss it? I don't know. But, this is the stuff they wanted to amend. I would be like supersede. But he's like, okay, go ahead and amend. Knock yourselves out. He must have known something was up, right? I would hope he knew. But the point being is, once again, all this crap was done in chambers. Someone asked a question. Since Pryor didn't catch it either, can't the judge allow it since before the defense opening? I mean, there's no rule that says that. In fact, it says it can't be amended after the government rests. Yeah, I think, Jennifer, I think Pryor missed it too. He may have, and the court raised it. But it doesn't mean it's not right. Just because, the defense didn't notice it, that would have been the motion for 35C, I guess, for post-conviction relief if they've been convicted. He got convicted on a date where the kid was alive. That'd be a slam dunk post-conviction. So the judge, trying to maintain the record, which is his job, kind of helped the defense out, kind of smacking down the prosecution. And I just don't see how you can have a whole lot of sympathy for the prosecution, because this is now the second time this has happened, once in both cases. Scott, Thomas Randall, Scott, you read the amended indictment. I have. I didn't have it in front of me when the judge brought up the issue, but I since went back. We read both the indictment and the original indictment. Indictment in count 4, the original indictment came out in May 25th of 2021. That says the defendant, Chad Guy Daybell and Noreen Vallow, on or between the 22nd and 23rd of September 2019, basically caused the death of, or involved in the death of J.J. Vallow. The amended indictment dated February 20th of 2024. So this year, right? February, March, April. We started this in April, didn't we? April 16th or 15th or something like that, right? So they did it just a couple of months before the trial actually started, and they amend it. They, being the prosecution, amends it, and count 4 says that Chad Guy Daybell and Noreen Vallow on or between the 8th and 9th of September 2019 basically goes into causes the death of J.J. Vallow. It's their own motion, their amendment, for God's sakes. What do you do with that? The judge said, what do you want me to do? You've rested. Yep. they got it wrong. 77 MCL. The original had the correct date. Tylee was killed between September 8th and 9th. Yep. But the prosecution amended it. They filed it. They asked it to be amended. Defense said, sure, knock yourself out. Okay. Right. Let's just go back here. The amended indictment, that's count 4. Count 3. Let's go back here. You got conspiracy to commit first-degree murder. Count 4 is first-degree murder. I mean, he could still get justice for JJ, but not that particular count. Count 5 relates to Tammy. Let's go back up here on the amended indictment. I think it's count 1. Yeah, Tylee is dated count 1. Chad Guy DeBell, Lauren Noreen Vallow, and Alex Cox conspired between October 26th of 2018 and January 15th of 2020 as it relates to the death of Tylee Ryan. Count 2, once again, Tylee Ryan, August, yeah. Then they go through, that's the financial issue. So yeah, they just totally got this wrong, man. Totally got this wrong. Yes, they would not be able to consider JJ as it relates, well, that's that particular account. I mean, that's the conspiracy, but remember, I mean, they would still get, it's count. So count 1 is referring to the amended indictment, conspiracy to commit first-degree murder and grand theft by deception. That's as it relates to Tylee. Count 2 is first-degree murder as it relates to Tylee. Count 3, conspiracy to commit first-degree murder and grand theft as it relates to JJ. And they have a very expanded date range. Count 4 is first-degree murder. That's where they amended the dates to the 8th and 9th of September of 2019. Count 5, conspiracy to commit murder. That's Chad, Lori, and Alex Cox as it relates to Tammy Daybell. Yeah. So, yeah. Ooh. Yeah, that's the problem. I mean, I guess they still have the conspiracy count that they would consider, but the actual direct count of first-degree murder, yeah, that would be off the table. But they could still go forward on the conspiracy to commit murder because the date ranges are large enough. But still, they should be embarrassed. They should be embarrassed by that. Because, I mean, really, you know, they have this big conspiracy in count 3, and they go through everything and how JJ passed away. And this is on September 23rd, 2019 through February 1, Vallow failed to refused, but they don't list any dates. On or between September 9th and February of 2020, Lori did wrongfully continue to collect money. Ooh. Wow. You know, that's huge, ladies and gentlemen. I mean, you can work that in as a defense attorney. If you notice, there's not as many charges. You can't consider this. Ladies, this is the best argument for a reasonable doubt, right? Let me give you a quick example. Had a case years ago, simple case. It was a fight at a party, birthday party. I think it was a quinceañera to be exact. And if they brought in one person to say the defendant over there hit this person and, you know, broke their nose and had a big fight, but the prosecutor kept bringing in more and more people. And the more people they brought in, it got confusing. And the prosecutor got up and said, okay, so maybe we don't know exactly what happened. I remember looking at the judge and she looked at me and I got up and said very quickly in my closing statement, ladies and gentlemen, if the prosecution doesn't know what happened, how do they expect you to know what happened? That's a reasonable doubt. And I sat down and my client got convicted or he was acquitted. So, I mean, that's kind of what it goes to. It just kind of shows, they're going to say, well, we're busy. There's no prejudice, but there is prejudice, and they got this totally wrong. It was their indictment, their amendment, their dates. They're the ones that had all the resources. They did it. The case has they rested. The case should go forward without count 4 being considered by the jury. That's just the way the rules are supposed to be played by. But if the judge comes up with something, maybe there's some case saying afterwards you can reopen the case. That's my experience. How I got screwed on a case once. They allowed them reopen when they hadn't checked all the boxes on the elemental instructions. And here, JJ was alive on the date that they say he was dead. So obviously that's not right. And they can't amend. The only way they can get around it, I swear to God, I think they're going to have to allow them to reopen. Which, if you're the defense, you're going to be like, this is outrageous, Judge. They rested. Why do we have rules? Why do we have rules if we're not going to follow them? Why even have a judicial system? Why have due process anymore if, that's what's going to happen? And if that truly happens, I would be apoplectic if I was Mr. Pryor. Completely apoplectic, just crazy apoplectic as to what was going on. So huge issue. But they should be coming back here shortly. I think within the next 15 minutes, I do believe, to do that. All right. So for those who just joined us, I've seen on the count here, we've had quite a few people all backed up by data. This is a nothing burger. Okay. Scott, all backed up by data. I don't disagree. Can JJ's murder altogether recharge at a later date? No, it'd be done. Jeopardy is attached. The jury's been seated. That's why it's so significant. There was somebody that was an attorney, and they said, this is like my worst nightmare. This is what you dreaded. Did I file something? Did I put in the wrong date? Right. This is why lawyers get paid the big bucks, so to speak. This is what they're supposed to do, right? Failure to pay attention to detail demonstrates an inability to accept larger responsibility. Yes, when I say reopen the case, that's what I mean. Judge, we know the prosecution has rested. We're asking for you to allow us to reopen our case for the limited purpose of fixing our error that we made, that we've had 4 years to fix, so that we don't look silly. Correct that error, then let us arrest, and then everything will be okay, and all the plans will align. So yeah, we'll have to wait and see. I mean, I can't wait. The anticipation, the building right now, isn't it? Someone has a question. Has the jury been sent home? Yes, they have been sent home for the day, is my understanding, and they are going to return on Monday for the beginning of the defense case in chief, if they choose to do so. Now, Mr. Pryor offered a lot of people, a lot of witnesses calling to be called for and on behalf of the defense. We'll see if that actually takes place. Do you think Boise will reopen? I think I don't know what to do. I don't know what the judge will do. Who has that? Do you think Boyce will reopen? He's given the prosecution everything they wanted, but I just don't see how he can, in good faith, and sit here and say, oh, this is not a clerical error. Thomas, this is not a clerical error. This is a big deal. This is an indictment. Like I said, if you can go back and look at all the videos that we've done on this, in the Lori Vallow case where they amended the indictments, I've never seen an amendment of indictment, but apparently in Idaho, you can do that, right? Usually you have to go in front of the grand jury to get a superseding indictment, because you don't get to just make an amendment. So it is what it is. But so yeah, but this isn't a clerical error. This isn't a little county court, DUI where, well, was it 11:59 or 12:01, right? But they still have to do that before they arrested. It's just the way it goes. I've seen some rules where they can amend up until it literally goes to the jury, but normally it's, when they arrest. So I just don't, this is not a little Scrivener's error, no big deal, make a little pen change. We're talking about weeks off from when they're saying JJ died versus when the charging document says it is. And the reality of it is this is the prosecution's fault. Maybe the judge will bail the prosecution out, but the prosecution messed this up, messed it up big time. It doesn't throw out all the evidence as it relates to JJ, but that's the charge, right? Yeah, they got the conspiracy, but this is the first degree murder. Let me go back. Let me just go back because I want to make sure I got this right. The amended count 4 is first degree murder. Then you go into Tammy. Count 3 was the conspiracy to commit first degree murder of Jason. So he could still be found guilty of the conspiracy, but they've charged him with murder, right? Under count 4, first degree murder. So he could still be found guilty. So there could still be chances for justice, but it just shows that the prosecution, wouldn't you want the jury to say, oh yeah, not only do we think the guy conspired with it, but man, they had a little more direct involvement. Let's find him guilty of first degree murder. Who's disrespecting the Woodcocks? You're a clown. Okay, well, you know what? I know the Woodcocks. Larry and Kay, I've chatted with them directly. They're Patreon members. They've been on the show. And you know why they came? They would actually, if you're referring to me, Erica, if that's what it means, you know why they started following my show? Because they weren't getting answers from the district attorney's office. I said Woodcock. I didn't say Wood. I don't know if they're talking about somebody else or what, but Larry and Kay, I have sat and talked to both of them. Larry is a great guy. He used to fly. We have a lot in common, but the reason he started following our show when this case first broke and he became a Patreon member, they've called into this show, is because they weren't getting answers as to what the hell was going on by the district attorneys. So they turned to me, this show, to get answers as to what was going on. So, yeah. All right. Well, maybe it was somebody saying it was somebody else, but all right. But still, the reality of it is the process. This is more of an embarrassing moment because Daybell could still be found guilty of the conspiracy. Those counts would merge at trial, at sentencing anyway, if he was found guilty of both. But the point is, they blew it on this one. Prosecution blew it. Fortunately, let's say they didn't have the conspiracy charge, though. There could potentially be no JJ justice at all. So yeah, because remember, you got the conspiracy between Daybell, Vallow, and Alex Cox for the death of JJ, and then you have first degree murder, which just says Chad Daybell and Lori Vallow, both of them. Separate count. They would merge, but if count 4 goes away, count 3 still exists where he could be found guilty for the conspiracy. Okay. All right. Well, there you go. Anyway. All right. So I'm glad I wasn't disrespecting the Woodcocks. I love Larry and Kay. Like I said, I've sat down, had drinks with Larry, had Arnold Palmer, saw him at Crime Con years ago. Like I said, they're members. I don't know if they still are, but they were Patreon members and they would call into the show. And they were, they basically said, we turned to you, Scott, to figure out what was going on. Like, because I was just calling it the way I see it. I thought that was the ultimate compliment when you have the victim's grandparents in a case watching your show, looking for you for advice as to what's playing out. Like, all right, this is the argument they're going to make. And this, don't worry. It's going to be patient, take time. It'll take years. Right? Here we are almost 5 years into it, right? 4.5 years into it. It's taking time, but once again, prosecution fumbles the ball on the 1 yard line here, so to speak. And the question is, when they come back here in about 5 minutes or so, are they going to bail them out or what? That's what we're going to have to wait and see. We'll see. All right. All right. So yeah, that's where we are right now. So quick recap. We should be coming back here just momentarily. The court should be coming back. The prosecutors were given 2 hours in which to look to the district attorney for some guidance as to how he can help them fix the situation that they have got themselves into, which is by how does he fix this? By allowing them to reopen the case, maybe? The rule says once you've arrested, you can't make an amendment. That's the only way I can see it. And I'm not going to say, I certainly haven't had time since this all happened, because I've been sitting here in front of the camera trying to explain what's taking place, but I haven't been able to research to see if there's some case law that allows for that. But my guess is if there was something readily available, they being the prosecution would have jumped up and said, don't worry about it, Judge. I got it. Here's the answer right here. It's no big deal. It happens all the time. But they didn't. In fact, they said, ooh, Judge, why don't we come back Monday? And the judge was like, no, let's come back in 2 hours. Let's come back in 2 hours and you guys tell me how to fix this. Do it. Mark wants to know could there just be a mistrial? No. The remedy here is to simply dismiss the charges or dismiss that particular count. Why? Because the prosecution failed to present any evidence that JJ was actually deceased on September 8th or 9th of 2019. In fact, the evidence came out that they believed that he was alive as late as September 22nd or 23rd of 2019. So what do you do? It's your document. You charged it. You had the evidence. You could have fixed it before you rested, but you didn't. So if I were the judge, I'd say, sorry, count 4 dismissed. Probably doesn't mean much in the big picture of things. Still got count 3, which is the conspiracy to commit murder. But it just makes the prosecution look really, really bad. Really, really bad. So we'll have to see here. We'll find out very, very quickly. Nita, love Scott's honest view. I mean, it's just the way it is, man. Listen, I don't know any of the parties here. I don't really, one way or the other, whatever it comes out. The reality of it is that the reason we started this channel years and years ago was so that we can explain things in a little more detail, a little more clearly than what you're normally going to get from, I hate to say it, like a reporter, although they may be very knowledgeable, but they've never tried a case in their life, right? I was asked the question of the day, how many cases have you tried? I don't know. I stopped counting, right? I used to have a logbook when I was a young lawyer. Case, tried, result, verdict, blah, blah. Don't even care anymore. I guess I could maybe go through a calendar. Yeah, oh yeah, that was a good one. Oop, didn't turn out so good. I don't care, but that's the kind of perspective I like to think why people would hopefully watch my channel is because this is what I do. I do criminal defense, man. I actually try cases. There's a lot of people that out there that, ask them, when was the last time you actually ever really tried a case, like a tough one, right? Not like, oh, I do a little, misdemeanor practice or I've never tried a criminal case in my life. Like I said, I just did my entire month of March. If you may recall, I was gone the entire month of March because I was doing what was supposed to be a 3-week trial that turned into a 4-week trial. So, that kind of stuff happens, but it's just the way it is, man. And like I said, hopefully we've been able to explain the circumstances here a little better than what you probably find other places. But this was a big development because The prosecution just got their trousers pulled down around their ankles and they look pretty damn silly right about now. And it wasn't the defense attorney that called it out. It was the judge that said, hey, prosecutors, you filed your original indictment in 2021. You had the correct dates. You amended just a couple of months ago on February 20th of 2024. This year, you changed the dates to September 8th and 9th of 2019, where you say that Lori and Chad killed JJ. You've rested your case now. The rules say you can't amend the indictment after you've rested your case. You think, okay, motion for judgment of acquittal as to count 4. Granted. No one's going to like it, except for Chad Daybell. Maybe Mr. Pryor, he'll be ecstatic. But this is on the prosecutors. If this count is dismissed, and it's not so fatal that JJ won't get justice, he just won't get as much justice because there's still the conspiracy count that exists. But we'll definitely have to wait and see here momentarily. But I'm betting you, I mean, if the prosecutors, they could come in and say, Judge, you screwed up. And we agree. You should do that. All right, let's go ahead and take a look now and see what is happening.
All right, good afternoon. We are back on the record on case CR 2221-1623, State of Idaho versus Chad Guy Daybell. We took a recess after the court heard argument on the defense motion for judgment of acquittal under Criminal Rule 29. I indicated an issue with count 4 and permitted additional time for the state. Before going into more argument on count 4, I have taken the time to prepare a ruling on the other counts on the motion. And I think for efficiency purposes would go through the ruling I've got as it relates to the other counts in the case, and then reserve some additional time to further discuss where things will stand with the count 4 of the amended indictment. So proceeding in that manner, the court would first note that the motion under Rule 29 for a judgment of acquittal, as I mentioned before, is for the court to consider whether there's evidence insufficient to sustain a conviction. There's some case law that goes further into the standard of review on that, or the burden of proof the court looks at in determining this motion. Some of it cited appropriately by the state. I'll note from a case, State versus Taylor, 157, Idaho, 186, talks about, says under ICR 29, the district court may set aside a jury verdict or enter a judgment of acquittal if the evidence is insufficient to sustain a conviction. The 14th Amendment of the United States Constitution guarantees the right to due process. And the U.S. Supreme Court has held that as part of that due process, quote, no person shall be made to suffer the onus of a criminal conviction except upon sufficient proof defined as evidence necessary to convince a trier of fact beyond a reasonable doubt of the existence of every element of the offense. And there's some internal cites there. Going on, the case states the relevant inquiry is not whether this court would find the defendant to be guilty beyond a reasonable doubt, but whether, quote, after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. And that cites a case, State versus Adamanchik, 152 Idaho 460. And then finally, thus, the only inquiry for this court is whether there is substantial evidence upon which a reasonable jury could have found that the state met its burden of proving the essential elements of the crimes charged beyond a reasonable doubt. Substantial evidence is more than a scintilla of proof, but less than a preponderance. In short, it is relevant evidence which a reasonable mind might accept to support a conclusion. So finally, the court is required to consider the evidence in the light most favorable to the state, but will not substitute its judgment for that of the jury. on witness credibility, weight of the evidence, or reasonable inferences to be drawn from the evidence. So that's the standard of review the court considers in ruling on a motion under Criminal Rule 29. Starting then with the counts that I am prepared to rule on. On count one, having considered the arguments of the defense and the state, the court does find that the state has presented sufficient evidence that would permit a reasonable trier of fact to find the essential elements of the crime beyond a reasonable doubt. And that's on the conspiracy to commit first-degree murder and grand theft by deception involving victim Tylee Ryan. The court notes that on identification of the defendant, which is one of the elements, he was identified by several witnesses, including Detective Ray Hermosillo, Ron Arnold, Detective Kaya Kamanu, that in terms of the dates listed in count one, surveillance from Officer Joe Powell helped establish those in the testimony of the other witnesses I mentioned, that this occurred in the county of Madison, state of Idaho. There were locations testified to by Officers Joe Powell, Colin Nesbitt, that the victim Tylee Ryan was identified in that count by, among others, Colby Ryan. Looking at the overt acts that the state went through and alleged 1 through 7, the overt acts evidence of those came in sufficient to withstand a Rule 29 acquittal from Detective Nathan Duncan and Zulema Pastenis testified to some of this. Also on the second overt act, Michael Douglas, Mark Sari, Chuck Consitis. Also Chuck Consitis on the third overt act. Detective Nathan Duncan testified on issues related in the fourth overt act. On the fifth overt act, Nicholas Balance and Nicole Heidemann testified about that. On the sixth overt act, Mark Sari, Chuck Consitis testified regarding that, and Mark Sari also on the seventh element. The court then, in considering that standard on a Rule 29, finds there's sufficient evidence, and so the motion's denied and the jury will be allowed to consider count one. Count two is the first-degree murder charge of Tylee Ryan, and evidence was provided identifying the defendant by witness Ron Arnold. There was date indications of when this occurred established by Rick Wright, among other witnesses. And the plan that is referenced in there was also testified to by Rick Wright and Nick Edwards. There was also information about identifying Tylee Ryan, identifying her as a person by Colby Ryan, Tara Martinez, Dr. Garth Warren. And looking overall at the evidence submitted, the court does find the state's met its burden to withstand a Rule 29 motion, and count two, the judgment of acquittal motion is denied. Moving next to count three, conspiracy to commit first-degree murder of J.J. Vallow. The court notes there was sufficient testimony and evidence presented to also deny the motion for judgment of acquittal on this count three. The identification of the victim established by witnesses including Kay Woodcock and Brandon Boudreau, that the overt acts again were testified to by witnesses including Zulema Pastenis, David Gibb, Ashlyn Rand, David Warwick, Melanie Gibb, Colby Ryan, Ray Woodcock, Mark Sari, all testified among those seven, actually six overt acts that are alleged there. The court does find sufficient evidence in testimony and admitted exhibits to allow the state to move forward and seek jury deliberation on that count. I'll skip over count four, as I mentioned. On count five, this is the conspiracy to commit first-degree murder of Tammy Daybell. Also, the court denies the motion for judgment of acquittal under Rule 29. in that particular count, the identification of the victim was established by Samantha Gwilliam and others. The defendant was identified relating to that count by testimony from Craig Huff, Zulema Pastenes, Colby Ryan. Looking at the overt acts established, there were 12 in that count, and the court notes that there was, again, identification of the victim, Tammy Daybell, by Samantha Gwilliam. On count 1, some evidence came in through testimony of Jason Gwilliam, Ian Pulowski. Count 2, Ashlyn Rand and Chuck Consitis testified about the overt act there. Count 3, Nick Edwards. Count 4, Nicole Heidemann. Count 5, Nick Balance. Count 6, Zulema and Nick Edwards established some testimony to allow those overt acts to be considered. Count 7 had some testimony from Angela Yancey. Count 8, Coulter Cannon. Count 9, Nick Edwards. Count 10, Rick Wright. Rick Wright also on count 11 and 12. And also Nick Balance testified about overt acts in 11 and 12 also. And considering the standard I announced at the beginning of the ruling, court does find that there's sufficient evidence the state's presented to deny the motion on that count 6. Count 7 is the insurance fraud count. The defendant was identified as to that particular count, among other witnesses, by Craig Huff, and Angela Yancey established the date range that's in the count. Also Taylor Ballard, and the state did provide sufficient evidence regarding the allegations of the insurance fraud count to withstand the Rule 29 judgment of acquittal. Similarly, on count 9 of insurance fraud, again, the defendant was identified by Taylor Ballard. The date range was established by Angela Yancey, who testified also that occurred in Madison County. Prior count also, the venue of Madison County was established. And then also Angela Yancey established evidence relating to the allegation of a fraudulent claim as set forth in count 9. So upon considering the evidence presented in the state's case in chief on those counts, the court is denying the motion for judgment of acquittal. And at this time, the court is going to permit some additional argument from the state as it relates to count 4, the first degree murder count, as it relates to JJ Vallow and the issue the court brought up. So Ms. Beatty, are you prepared to argue that?
I am, Your Honor. Thank you.
I'll hear additional argument on count 4 then from the state, and I'll allow additional rebuttal argument as well from the defense.
Thank you, Your Honor. Your Honor, in looking at the case law and the relevant rules and statutes, the state really has 3 options for the court at this point. The first, and I'll talk about each of them in a little more depth, but the first option would be, because count 4 of the amended indictment did not fall within the scope of the court's December 8th, 2023 order to amend, and we'll get to that in a moment, the court can simply correct it under Idaho Criminal Rule 36 so that it conforms with what count 4 should be, which would be count 4 as set forth in the original indictment. And I'll discuss that more in a moment. Second, the court could accept that we do have a variance here and either instruct the jury on a variance between the jury instructions and evidence that they've heard, or the court under State versus Jones, which we'll also discuss in a moment, the court could address that variance by simply putting in September of 2019 in the count 4 jury instruction, which is very similar to what the court in Jones did, as we'll discuss in a moment. Third and finally, the court would be within its discretion to reopen the case to allow the state to correct the indictment if the court does find that it needs to be formally amended. So as to the first option, the state did not move to, and the court never granted a motion for the state to amend the indictment as to the date or as to count the date within count 4 as to anything about count 4. Under Idaho Code 19-14-20, the state can only amend without leave of the court prior to entry of plea. Under Idaho Criminal Rule 7E, the court grants the state leave before amending a charging document. In this case, the state made a motion to amend the indictment on November 23rd, 2023 in 3 very specific ways. The first was to modify the subsection referred to in counts 1 and counts 3 from Idaho Code Section 182403 sub 4 sub A to Section 182403 sub 2 sub A. The second change requested by the court was to modify the language in counts 2, 3, and 5 from, quote, the defendants, Chad Guy Daybell, Lori Noreen Vallow, and Alex Cox, unquote, to, quote, the defendants, Chad Guy Daybell, Lori Noreen Vallow, and or Alex Cox, unquote. Finally, the state requested that leave to amend the indictment to modify the language in Overt Act 10 under count 5 from, quote, month, unquote, to, quote, months, unquote. Importantly, Your Honor, nowhere in the state's motion did the state ever seek leave to amend any portion of count 4. On December 8th of 2023, the court granted the state's motion. The court's order states, quote, for the reasons stated on the record, the court will grant the state's motion. The amended indictment is ordered to be filed in the case, unquote. Subsequently, of course, the state did file an amended indictment, but in that indictment, it does appear that the date within count 4, the first-degree murder charge of J.J. Vallow, was inadvertently changed to the same date as the murder of Tylee Ryan. The state would note that the initial indictment was filed in this case on May 25th of 2021, and in that indictment, J.J. Vallow's death dates were properly set forth as the 22nd and 23rd of September of 2019. Just 2 days after that, counsel for the defendant filed his notice of appearance in the case. This matters in the court's analysis because it goes to prejudice and it goes to notice where we had an indictment with the correct dates for 2.5 years, during which the entirety of that time, counsel and the defendant were aware of that date range. And we'll discuss that in a moment as well. Ultimately, because this is a clerical error that needs correcting and count 4 was never properly, was just simply not amended in any legal sense because the state is not able to do that without leave of the court, and the court did not grant the state leave to do that. The court could utilize Rule 36 to make that amendment. Certainly, this would require a jury instruction of some type, and the state does not have a proposed jury instruction because the jury was read the indictment earlier in this case, of course, but that would be an option that would be available to the court. The second option would be for the court to accept that this is a variance, which does happen and is accounted for in the case law. And frankly, Your Honor, it's not a proper subject for a motion for acquittal. In fact, a date is not an element of a crime. And I know that that sounds counterintuitive, where our ICG standard jury instructions have the defendant's name, they have the date, they have venue, but venue and date are not elements of, they're simply not a factual element of a crime. And an Idaho Supreme Court's case, State versus Jones, dealt with that very issue. In State versus Jones, a defendant appealed from a lewd and lascivious conduct conviction, and he argued on appeal that the information, the charging document in that case, did not sufficiently apprise him of the nature of the charges against him. Specifically, the Jones defendant argued that the charging document did not identify the time, location, or information that he needed to prepare a defense. In that case, in that charging document, there was a range of numerous years where these crimes could have been committed. The Jones court explained that generally, a defendant cannot be prejudiced, quote, by the absence of specific details in the information when those details are already known to the defendant or are provided to him by means other than the information, unquote. And that pinpoint citation is 140 Idaho at 47. The court specifically in Jones rejected an argument about a lack of specific time set forth in the indictment. And I'll just read straight out of the case. Jones's next argument that the information was insufficient for failure to allege a specific time of the offenses is also without merit. Under Idaho Code 191414, the precise time at which the offense was committed need not be stated in the indictment, but it may be alleged to have been committed at any time before the finding thereof, except where the time is a material ingredient in the offense. Time is not a material element of the crime of lewd and lascivious conduct with a minor. The Idaho Supreme Court, and I'm still reading from the case here, has stated that, quote, any other rule would too often preclude prosecutions in this type of cases where victims are minors and where crimes are not discoverable until sometime after their commission, unquote. So I think what we have here is the court explaining that these timeframes, there are other factors that can be taken into account here. And so while it's not directly on point because we're talking about a range of many years, and here we're talking about a variance in days, I think it's important to note that the court clearly didn't see a very specific tight time frame as an element of the offense in Jones. So the Jones court went on to explain that what we're really talking about here is variance. And diverting from Jones for just a moment, Jones also discussed the Windsor case, which the pinpoint citation for that is 110 Idaho 410. And in the Windsor case, the court really set forth an explanation of what variance is and the standard for variance. Quote, the true inquiry is not whether there has been a variance in proof, but whether there has been such a variance as to, quote, affect the substantial rights, unquote, of the accused. The general rule that allegations and proof must correspond is based upon the obvious requirements that the accused shall be definitely informed as to the charges against him, so that he may be enabled to present his defense and not be taken by surprise by the evidence offered at the trial, and that he may be protected against another prosecution for the same offense, unquote. And again, the Jones court, after citing from Windsor, also discussed how variance between the information and evidence presented at trial or between the information and the jury instructions only require reversal of a conviction where the defendant was, quote, deprived of fair notice of the charge against which he must defend or was left open to the risk of double jeopardy, unquote.
I do have a question about variance.
Yes.
Because I've looked at some of the cases that do discuss variance, including the one I previously cited, State versus Anderson, 172 Idaho, 133. And in this instance, I think looking at the context of how variance occurs, I guess the point I struggle with here is it appears to me variance typically comes up when for whatever reason, jury instructions don't match the charging documents. And there is a presumption that the jury instructions should match the charging documents. And that's in a case, State versus Bernal, 164 Idaho 190. Here, essentially, what the state would be requesting is that we don't have a variance yet because the jury hasn't been instructed on something that varies from the charging document, but you're suggesting I permit or sanction a variance and allow the variance to come in to essentially cure an issue raised on a Rule 29. And I see that as very different than any of the other cases. So are you aware of any authority where the court proactively let a variance occur to fix something in order to withstand a motion on acquittal?
And Your Honor, well, a couple things. So first of all, I don't believe that the defendant did raise this specific issue on his Rule 29 motion. I understand the court is considering it at this time. But I do think that I just want to make that clarifying point because I think it goes to prejudice.
And I believe that's totally accurate. It was raised by the court.
Thank you, Your Honor. But I believe in the Jones case itself, the court, Jones, I'll just read from the case. Lastly, Jones argues that the court's instructions to the jury constituted a fatal variance because the court added, quote, on or about, unquote, to the time frame of the offenses alleged in the information. He contends that this broadened the basis upon which Jones may be convicted. We disagree. The slight expansion of the time frame does not allow the jury to find Jones guilty of a different offense than that alleged in the information. Jones has identified no fatal variances between the information and the evidence or jury instructions.
Okay, I appreciate your response to that.
Of course.
question.
Thank you, Your Honor. So that would be the states, and I understand that I certainly understand the complexities that this course of action presents to the state. But there is that third option as well, which is obviously a clerical mistake was made here. It's inconsistent with the initial indictment. It was not it was not a proper legal amendment. We're really talking about a clerical issue here. And I think that when courts look at reopening cases, that's something the court can do for situations such as this. So if the court declines to proceed with correcting the indictment on the basis that it was never properly amended, or if the court is unwilling to proceed with a variance, the court can reopen the case to address this issue, at which point the state would then amend it before resting, which would bring the state into compliance with Rule 7E. That would put the amendment in compliance with the rules and relevant statutes. So in addressing the court's ability to take that course of action, I think State versus Cutler is a good case for that. In that case, the Idaho Supreme Court stated, a justice presiding in a criminal case not only has the responsibility of protecting the rights of one accused of crime, but also an equal responsibility to the people of the state, to the end that justice is not thwarted by mistake or inadvertence. The presiding justice under the circumstances of this case are well within his rights and his discretionary powers of trial procedure in permitting the state to reopen and present further evidence after the respondent's motion for a directed verdict of not guilty had been made, unquote. And I think that's very applicable to this case, Your Honor. I also think that another case that the court could look to would be State versus Huggins, 103 Idaho 422. In that case, the court noted that some reasonable excuse, such as oversight, inability to produce, or ignorance of the existence of evidence, must be established by the moving party. And Your Honor, we're all kind of falling on our sword here. This was clearly an oversight. We're talking about a clerical error in a subsequent document that was not in the initial document. This is exactly the type of mistake or inadvertence that the court could reopen this case for. And I think defense counsel argued earlier that it would be unfair to do that after the defense made a Rule 29 motion. I'm not aware of any legal authority that supports the assertion that making an oral Rule 29 motion on totally unrelated grounds tolls the state from doing that. But certainly there might be something out there that we're not aware of. But I do think that under this case law, the court, if the court felt that a formal amendment was necessary, the court could reopen the case. Thank you, Your Honor.
All right, thank you for the citations and the well-argued points there, Ms. Beatty. Mr. Pryor, any response from the defense on this?
Judge, I'm going to work in reverse. And as far as reopening the case, the authority to reopen a case is almost exclusively applies to evidence, Judge. It does not apply to amending an indictment, information, or complaint. If the court recalls, I don't believe I objected to the original amendment to the indictment when we did that back November or December. The court read the indictment, went over it in detail with the state, and the state acknowledged that this is the indictment that they intended to go forward on. And from that time forward, that's the information that I relied on. And any change at this point, after the state has rested, is going to create a substantial due process argument for Mr. Daybell. In addition, it's going to affect the substantial rights of Mr. Daybell as well. The difficulty is this, Judge, is we have a very specific statute, 1914-20. 1914-20 says in pertinent part that the state may move after the defendant has pled guilty to a charge. Now he pled not guilty, and he did enter a plea of not guilty, and the state properly came forward and asked the court permission to amend the indictment. They then amended the indictment. And since approximately December of 2023, that indictment has remained in place in full force and effect. Now, they have that right to amend the indictment under 1914-20. But then we get to a very specific, a very direct rule, and that's Rule 7E. And Rule 7E says in pertinent part, Judge, that the court may permit amendment of a complaint, information, indictment at any time before the prosecution rests. To my recollection in reading the statute on this short notice, Judge, I never saw the words variance. I never saw, correct an error. I never saw anything to suggest that they have any right to do any of this. And there's a State versus O'Neill, Judge, I think it's 118 Idaho 244, that talks about Idaho code and the statute 1914-20. But Judge, the specificity of 7E doesn't say the court has the authority to go back and allow them to reopen. It doesn't say they have the authority to go back and create a variance. It doesn't say they have a right to go back and make a correction. What it does say is they may and they have to make any amendments or corrections prior to resting their case. There's nothing else that says, well, we got a little bit of wiggle room here and let's let them change things after they rest their case. And 4 lawyers had a chance to look at this indictment. 4 lawyers have had over a year to analyze this. And then after they rest their case and decide that the court picks up on the fact, and Judge, I mentioned to the court that there were elements. I wasn't going to key the prosecutor off that they had a problem. And if the court didn't catch it and there was subsequently a problem, someone else would have caught it and would have corrected it in the future. But they don't get to correct it now. They don't have any authority to say that. The cases they cite talk about other issues that have nothing to do with having the ability to change an indictment as I am preparing to present my case to the jury in this case on a capital murder case. They've lost their chance. They don't get to go back. Judge, I'm asking the court to dismiss the charge.
All right. Looking back over a rule here, I have an additional question perhaps from Ms. Beatty. I'm looking at Criminal Rule 36 about clerical mistakes. Is it the state's contention that an indictment would be included among the documents that may be corrected for a clerical mistake? Because it does specify, it doesn't say anything can be.
It doesn't, Your Honor. And I think we take that position just based on the language in the rule that says, quote, or other part of the record, unquote. However, I will be candid with the court. I did not specifically check Westlaw to see. That was not one of my, I didn't do a deep dive into that. But I think that where we're talking about the criminal rules, judgments and orders can be amended, and any other part of the record. That's a very broad, expansive language. The record clearly would contain the criminal record in a case. I do think that that rule in its plain language could be applied to encompass an indictment.
And Judge, could I respond, please?
Yes, you may.
Judge, Rule 7 specifically says they're not allowed to change it after it rests. It's specific. And regardless of what Rule 36 says about other issues, and it's vague, we have a very specific rule being Rule 7. And Rule 7 makes it very clear. They don't get to amend. Regardless, they don't get to amend. It's a very specific rule that references this very issue. 36 is vague. This rule is specific.
Your Honor, may I briefly respond to that?
And that'll be the end of argument, but you may.
Thank you, Your Honor. The state would just reiterate that there is a process for making these substantive amendments, and there was not a substantive amendment made in this case because it did not fall within the scope of the order. And so we're not asking the court to make a substantive amendment when Mr. Pryor is citing Rule 7E or 7F. We're asking the court to correct what is clearly a clerical mistake not within the scope of the court's order, which is how I would respond to his citation of Rule 7.
Okay. So essentially arguing you moved to amend the initial indictment and the court granted the motion for specific grounds. And on February 20th of 2024, the amended indictment was filed, which has changes. And those were all drafted by the state. And your argument is that amongst the changes you put in the new amended indictment were clerical errors that should be corrected because they were not intended to be or should not have actually been amended. Is that essentially the argument?
That's correct. And I would take it one step further and say that as a matter of law, count 4 was not amended because we did not have leave from the court.
And Judge, I'd like to respond.
Okay, I will allow another response because I'm just considering all this. Mr. Pryor, go ahead.
Judge, they made the amendment to the date. They made the change to the date. They had an opportunity to review this. And then this indictment gets read to the jury and once again published for all to hear, including the 4 lawyers that are sitting across from me. And at no time do they catch that potentially there's an issue. And at this point, Judge, the rule is very clear. They have an indictment, they made the allegations, they're stuck with their indictment.
All right, council, let me take a brief recess, discuss this with my staff attorney, do some quick research and get prepared to make a ruling as it relates to count 4. I think time is of the essence to determine this issue, so we'll go as quickly as we can to get back on the record. I'll have the marshals advise you when we're ready to make an oral ruling. All right.
Well, more indecisiveness. I'm not sure. All right. So quick recap for everybody that maybe joined us late. Here's what's going on. Here's the deal. Prosecution rested and the defense made their motion for judgment of acquittal. The judge brings up on his own, says, hey, prosecutor, count 4. You have a date here that says that JJ was killed on September 8th or 9th of 2019. But we know that's not true from the evidence. In fact, we know he was probably killed on September 23rd of 2019. How do you intend to fix this? Prosecutors saying, oops, no idea. Well, then everybody takes a break. And the judge says, I'm going to give the prosecutor 2 hours to come up with a way to help me fix this. Now, during that break, I said, well, only thing I've ever seen done when I got screwed on a case like this is the defense was allowed, or the prosecution was allowed to reopen their case, present evidence as to a specific date and time. And then we lost. And that's what I said. That's probably what he'll allow to do if he's going to do this. So the prosecutors come in and say, well, Judge, this is our argument. We got 3 arguments. The first one is, sure, Judge, we filed the original indictment and it had the correct dates. And we filed a motion to amend the indictment, but it was only to specific counts. And it wasn't to count 4. Yes, and then you granted that, and then we refiled the amended indictment. And sure, it had the wrong dates in there, but you didn't grant us the right to amend that date. So therefore, the original indictment, not the amended indictment, is what you should consider. So we're incompetent, Judge, but since you didn't catch our incompetence, we're all incompetent, so just use the original indictment. That's the gist of it. Okay. And of course, they said what I also would say in their argument is, well, there's really no prejudice, Judge. What's the prejudice? He's known about these dates since the time, and that particular count wasn't amended. I mean, sure, the amended indictment superseded the original stuff, so that's the date. And as Mr. Pryor mentioned, those were the accounts that were read to the jury. And not a single one of those 4 attorneys sitting over there caught it. The next thing they say is, well, Judge, we're entitled to a variance. Now, let's give me an example of what a variance is. Normally, let's say you have a child victim of a case. Somebody did something inappropriate to a child, and all they know is it started sometime maybe in the summer, and then it ended near Christmas. So they charge, May through December of a particular year, okay? They don't really know the dates. And as a defense attorney, it's like, hey, what date is it? What date is it? Because the date does matter. Contrary to what the prosecution says, the date does matter. And they say, well, we have young child. We're going to allow those dates. So the jury then gets what they call a variance instruction. And it says, and it's also like a unanimity instruction. Hey, we know we're not specific on these dates, but you all can pick a date. So we're going to have incident A, incident B, and incident C. And if you find that and you unanimously agree that all of those incidents occurred close enough for government work, there you go. You can convict. That's basically what they're saying is, Judge, just let the jury pick the date. And as long as they can all agree on the date of September 8th and 9th, of September 22nd and 23rd of 2019, we're all good. Okay. And they say, well, it doesn't really matter precise time. Well, it does. That's why they put the date in there. If it didn't matter, it wouldn't even be in the elemental instruction because, of course, it does. And it'll be read to the jury on that. And then the final option was, well, just Judge, let us reopen the case, make the amendment, formally do it, and everything's fine. Bygones, no big deal. Now, Mr. Pryor, and of course, their argument is no prejudice, no prejudice. We're incompetent. It's Scrivener's error. Judge, this is really your fault because, you didn't catch it. And basically, it's the defense fault because they never raised it either. That's what they're arguing. It's not the defense's obligation, Mr. Pryor's obligation to do the job of the district attorney. And like they said, this was read to the jury. They've had 4 years since they've amended it since February of this year. Not a single one managed that. No one bothered to take a look at it the entire time. I mean, just as sheer incompetence, this should be granted. Now, I think the judge is going around because now they want to look at this Rule 36 in the Idaho procedures. But basically what it's saying is that, well, you can change Scrivener's dates, not a big deal, clerical error. No, that's like when the clerk puts in a clerical mistypes. We appeared on, May 16th and it was actually the 17th or vice versa. You can go in and change that. That's what they're referring to, not amending a freaking indictment, for God's sakes. They did say a little bit, she did kind of fall on her sword. Yeah, we should have noticed this, but we didn't. But Judge, in all our motions to amend, we didn't amend count 4. We just, filed the wrong indictment. I mean, is that really our fault? I mean, it's only our responsibility, our job, but we didn't file the right indictment. That's really what they're saying. I mean, that's what it boils down to. So those are the arguments. The judge took yet another recess here to try and figure out what he's going to do. He denied the motion for judgment of acquittal on all the other counts. The only thing that remains is this particular count 4. And so I don't think the judge is going to allow him to reopen the case. I think the Rule 7A is that you can amend any time until you close. They've clearly closed. I don't think variance is appropriate in this particular case. That's more for like a sexual assault on a child type of case where there's really a legitimacy as to you don't know the date ranges because they weren't, they're a small kid. They just know it was warm outside and then it got cold and it all stopped at Christmas time, right? That's what kind of a variance like that would be for. And they're basically saying, well, Judge, we didn't ask to amend that count. We just filed the wrong indictment. So don't hold it to us. I mean, jeez, you can't expect us to get it right. We're only the prosecution charging a man with 3 counts of capital murder and want to put him to death. How dare you think that we have a duty and obligation to get this correct? Can you believe such a thing? But let's see what the judge is going to do. Now, we don't know. The judge went back. He's going to check with his staff attorney. Nice to know you get a staff attorney as a district court judge in Idaho. Most judges don't get that. But the reality of it is we'll see. I think if the judge really wants to do the right thing, and at the big end of the day, is it really going to affect anything? No, because count 3 remains because that's the conspiracy for Chad, Lori, and Alex Cox to conspire to kill JJ. And then you have the first degree murder, which is Chad Daybell and Lori Vallow. They just got the dates wrong. And yes, dates do matter. Like I said, the little Lovett thing, remember the judge, he's literally going through location, jurisdiction, identification, right? Who's going to come in and prove the identification that was the guy, right? Oh, like maybe Scott knows what he's talking about, right? And then you got date and time. Yes, you don't have to have the precise time. Nobody ever said that. But you got to give a date range, right? If you don't know the exact date, like, someone walked in, boom, shot Scott, killed him, May 16th, right? They don't say, approximately 3:13 on May 16th, Scott was shot and killed on his Crime Talk set. The defense is going to say, it was actually 3:12. His beautiful Breitling watch that the lovely Miss Kristen recently just got for him because he loved Breitling watches, was off, and therefore they got the time wrong, right? No, we're not talking about the exact time, but you have to give a reasonable time frame because you have to know the time. The DA basically said, time doesn't matter. Date doesn't matter. Really? Well, if date doesn't matter, then why charge it? In every case, the date is charged. And the reason the date is charged is because it does matter, because you have a due process right to know what date it was, because maybe you weren't even there. Maybe you were in a different city, a state. Maybe you were in a meeting on a phone call, and you can document that. So we saw some pretty big tap dancing going on by the prosecution there. Dun, da, da, dun, da, da. I mean, it was the big hands finish coming on here, tap dancing. Dun, da, da. There was some serious tap dancing there. So we'll see. Now, am I still holding out hope? And not because, I mean, listen, if he's convicted, they're going to get him on count 3. Right? This is going to be an all or nothing kind of case. They either believe he conspired and did everything that he was alleged to have done, or he didn't do anything at all. So really what it boils down to is that, what's the word I'm looking for? It probably won't make that big a difference in the long run, although it will still a little integrity into the system, that there are rules, the rules are meant to be followed. Professionals have standards. And if you don't meet those standards, guess what? Bad things happen, which is to see exactly what happens here. So those are the arguments. That's what we're going to have to wait and see. I mean, it is a difficult situation. I mean, the judge obviously wants to get it right, needs to protect the record. And that's what they need to do. But the judge is in a tight spot. You got you got all the, family in there. You got everybody that, wants him to do what they want to do, which is, keep the count there. But the rules have to be followed. And if they don't follow here, if they not meant to be followed and not meant to be, adhered to everybody, then why do we even have them? And like I said, maybe the cynical side of me, the defense attorney side of me is saying, oh yeah, he's going to find a way to help the prosecution and bail them out. I hope he doesn't. Not that I want, Daybell to get away with it. If anything, if he is involved, we'll give him the presumption of innocence because he hasn't been convicted yet. But the reality of it is, if he's, nobody wants him to get off if he did it. But there's rules. And the rules are meant to be followed. And this is just a screw up. Like I said, if this was a civil case, if these people had filed a wrongful death case or something and they lost, guess what they'd be doing? They'd be on the phone right there calling their claims, their insurance carrier saying, oh, I think we got a claim for malpractice coming our way. But since they're prosecutors, they don't have any concern. They're playing with house money, right? They don't care. At the end of the day, I mean, it's like gambling for them. And they're the house. Oh, I got a big old stack of chips here. No problem. Oh, we lost one. Okay, we turn over a couple of chips. No big deal. It's the defendant that has to worry. And for the prosecution to say that there's no prejudice. I mean, he knew of those dates and Pryor wanted to correct that record. Like, no, judge, this was their amended indictment. This was their amended indictment. And it sounds like I said, when we were talking earlier during that break, it sounds like he was playing possum because he said there were issues as it relates to the elements, but he didn't say anything because he knew that if he did, they would then come and try to fix it. So old Mr. Pryor playing possum with those old prosecutors. And he did notably punch him right in the freaking walk up and poke him right in the eye. There were 4 of you over there. You've had 4 years to do this. You filed the amendment in February of this year. You prepared for trial. You prepared your witnesses. You had the indictment read to the jury, and not a single one said, ooh, something just doesn't sound right about that. We better double check that date. Oh, let's amend, right? But the prosecutor's like, well, judge, we filed to amend this thing over here. We filed to amend counts 1 and 3 and 2, 3, and 5, and you allowed us to modify that. So technically, you didn't allow an amendment as to count 4, is what they argued. They just filed a wrong amended indictment. I mean, they're basically blaming the judge, right? Well, judge, you didn't amend that, so I mean, it's bygones, it's no big deal. But then the argument of the defense and the judge is, but your amended indictment is like a superseding indictment. You amended it. That's the rules that we're playing by now. Okay, I had a case like this once, and this is why I think he's going to get screwed. Serious case, very serious case. And it's a really great case. I swear to God, I think it's the greatest cross-examination ever done. All right. And I'm trying to figure out a way to work this into like a great podcast because it's a super interesting case. It was a cold case, brutal facts, right? Stuff that people would, I think, just love. And so they gave an indictment and it had all these charges, right? Okay. They superseded the indictment and then it only had one charge because they had indicted under the new statute for murder versus the old statute when this took place like 20 years ago. So the superseding indictment, and the plain language of superseding indictment is it replaces what previously existed. So, we show up to trial like a judge. We have a superseding indictment. This ought to be really quick. We got one count. And everyone's looking around like, what are you talking about? Look, judge, superseding. If you look at the plain meaning of the word superseding, it means to replace. We're on the eve of trial. Judge is like, oh my God. The prosecutor's like, oh my God, what are we going to do? Judge says, well, we'll just treat it as two indictments. Engaging in complete legal fiction. That the word superseding doesn't mean superseding. And this is why I think there's always, if the defense is going to get screwed, they're going to get screwed. Stuff like this. Anyway, so they're allowed to go forward. I raise it, everything. Judge, I move for dismissal, mistrial, anything, you name it, supersede. I mean, I did it every day. Judge, I object. We should only have one count, supersede indictment. Goes up to Court of Appeals, and they're like, well, your guy's a real SOB. We don't like your SOB client. And they screwed me. Never been done before, never been done since. That's what they refer to as the SOB rule. If your client's an SOB, we're going to change the rules so it doesn't happen, so he doesn't get away with it, so to speak. So that's why I keep thinking the judge, this is pretty straightforward. It's your amended indictment, prosecutor. You had all this time. You blew it. I'm going to dismiss count 4. In the big picture of things, it probably doesn't change anything, but I have to punish you. And, those DAs, I mean, their attorney general over there is just like, oh my God, I cannot believe we did this, right? Can you imagine the legal assistant back at the DA's office? Oh my God, did I file the wrong indictment? Oh my God. Or how about the attorney that actually signed it? Let's take a look at the amended indictment really quick and see if there's an attorney just presiding grand jury. See, it was presented to the grand jury. So not only did they present it to the grand jury, they had all this time to do everything. I mean, they presented to the grand jury and got the wrong dates. When they submitted the amended indictment, that's the rules of the road. That's it. They screwed the pooch. I mean, they presented it to a grand jury. It's not like they just filed a quick little motion saying, Judge, I want to amend this or that. The amended indictment has the date changed. So that's what they presented to the grand jury. So not only did they screw it up in court, they screwed it up in front of the grand jury as well. Because the amended indictment is signed by the grand juror. Can't read that signature, but that's the grand juror. Deputy presiding grand juror. Acting presiding grand juror, Fremont County, state of Idaho. So not only did they screw it up with court, it's just a Scrivener's error. No, it's not just a Scrivener's error. It was a freaking amended indictment, a superseding indictment. And if the judge lets them get away with this, I will lose all faith in the legal system. And I'm going to quit my job as an attorney, and I will just criticize the legal process here on a daily basis. Just kidding. But seriously, these guys screwed it up. They should be absolutely devastated, embarrassed. And even if the judge bails them out, they should be absolutely mortified that the world got to see such a level of incompetence. Now, I always say that because, God, what if I screw up something big, right? I don't want to be that guy. But this is pretty big. I mean, there's the kind of things you fall on your sword. I mean, I've had to fall on my sword before too. I remember once it was a homicide case, and I remember I had an associate, had a lot going on, And we literally, we got some status thing. It was like, we're supposed to, well, there was no motions filed. And looking at my associate, and I was like, I thought you filed them. She's like, no, I thought you were going to file them. Right. Got on the phone with the prosecutor, said, hey, here's the issue. We called the judge, falling on my sword, judge. My name's on the letterhead. Had a bunch of stuff going on. And I thought somebody else had filed it. She thought I was going to do it. Doesn't really matter. My name's on the door, on the letterhead. I'm the lead attorney on the case. It's my fault. Just, it is what it is. And, we got to redo it. Now, was there any prejudice in that case? No, because the prosecution, had sufficient time. But, I assure you, sure felt stupid doing it. But, mistakes happen. I get that. But this was a big one that should have been caught long, long ago. So, there you go. Let's see here. Let's look at some of these questions here. We should have the judge coming out shortly. I mean, we're in the same time zone. It's 3:25 here in Colorado. It's 3:25 there. And hopefully the judge will come around quick, because he said time is of the essence, because people need to know what's going on with this. I mean, this is just, I think it's a no-brainer. The judge can, say, hey, look, this is what the court system's for. We're going to hold everyone to professional standards. And, the prosecution dropped the ball on this one. Let them go explain to the family what took place. It's the government. It's not like they fire anybody for screwing anything up. Hell, they probably promote them, give them a bigger office or something. It's not like anything bad will happen to them. They'll just be like, oh, be more careful next time. Okay. So, I mean, it's, like I said, I'm not, like I said, I just told you, I've made mistakes. I'm not going to sit here and say, this is like, there was another attorney that commented, said I was either am or was a practicing attorney, is what somebody said in the comments. And like, this was my worst fear. You put the wrong dates, you miss a typo, you miss something. That's why it's so important to read this stuff over and over and over and again, have other people read it over and over again, because that's what lawyers do. If you miss something like that, right? You miss a deadline. It's not, oh, no big deal, I'll just file it. No, you could be committing malpractice, right? Oh, you didn't have that stuff documented, right? Ooh. We got ticklers. I mean, on our calendar systems, you file a complaint like that, man, you have everybody read it. More than one person read it. But we'll see if they bail them out. But I hope they don't. And the reason, like I said, and it's not because I'm rooting for Chad Daybell. I'm not. I could really care less about Chad Daybell. I have no sympathy for him whatsoever. He got himself into this mess. Maybe if he had, certainly Lori Vallow, has a way of trying to find her way into situations. But if he had just ignored her, maybe this never would have come about. I think that's reasonable to possibly say. Had he just said, sorry, I'm a married man, happily married, or even if he's unhappily married, say, you know what, I'm not going to do this. Just make it all go. Maybe this never would have happened, but for him, he could say I was duped. I had no idea what was going on, but he was also the one that didn't tell her no. So just call it the way I see it. Just calling the way I see it. And so I'm not rooting for Chad Daybell in any sense of the word. I let the chips fall where they may. Really don't care where it goes. But I'm more interested in the law being applied equally and fairly because, what we say all the time, if we allow the government to railroad a guilty person, well, guess what? They'll start doing it to innocent people as well, because, well, if the rules really don't matter and the rules are set for everybody to play by, but if the prosecution commits, listen, if this was a civil case and they got this wrong, it would be civil, it would be malpractice. It would be malpractice. I mean, they have committed malpractice. Fortunately for the prosecutors, there's no consequence for them. The worst case, charge gets dismissed. Nothing's going to happen to them. Nothing. They're up there tap dancing. Well, Judge, we didn't actually amend that. So no, it's not human error. No, it's malpractice. LA, human error is malpractice. I guarantee you. I guarantee you. You miss docket something, you miss a deadline. Oh, human error. People make mistakes. Tell that to the other side. Tell that to the person that's going to sue you. Legal human error is malpractice. Doctor, human error. We accidentally left that surgical device in there. But we all counted. I mean, we had 6 people in there. How could we all miss it, right? Human error. No, that's called malpractice. So yeah, it really is, and so that's the way it is. But they've committed legal malpractice. But there will be no consequences other than maybe the count 4 would be dismissed. Personally, professionally, maybe professionally they'll be a little embarrassed by the whole thing. They'll get over it, but nothing will happen. And like I said, I don't care about Chad, but follow the freaking rules, man. It's your indictment, prosecutors. You filed it with the court. You had the grand jury sign it. You presented it to the grand jury. You had all that time to fix it and correct it. You heard it read aloud, as Mr. Pryor said, to the jury. And it wasn't until the end of their case that the judge mentioned it, although Pryor said, hey, Judge, I did say there were some elemental flaws in it, but he didn't want to raise it. He wanted to save it for closing argument. I say, ladies and gentlemen, they got it all wrong, because he was concerned exactly with this. Is the judge going to let them fix their problem? And, I'll be honest with you. I mean, this is appellate stuff. I mean, if the judge wants to make a good, clean record, dismiss count 4. That's what a judge would do. But if he's going to try to bend over backwards and do legal gymnastics, then he should, just come out and say, I'm just going to let him reopen the case. No harm, no foul. Come on, Mr. Pryor, you knew it. You're just being sneaky, you. No, he was just lying in wait. He wasn't being sneaky. It wasn't his indictment. He was playing by what was provided to them. So, I don't know. The longer it goes, the more likely I think the judge is going to screw Mr. Pryor and the defense. And like I said, not that I care for Mr. Pryor or the Chad Daybell, the defendant. It's just the plain rules are pretty much what they are. You can amend up until the time you rest. They rested. They're stuck. Trish says, no, JJ's grandparents will be so upset. I understand. Kate and Larry Woodcock, I get it. Like I said, we know them. We've had them on our show. They were Patreon members. They would call into our Patreon show on Tuesday night. And I always thought that was the greatest compliment, that here we have the grandparent victims, because no one in the prosecution office would explain what the hell was going on, that they turned to a YouTube channel and they would call the show and we'd explain what was going on in their case, in their son, grandson's case. And like I said, Larry and I have talked, and, at one point I think he even said, I hope you're not offended in any way. I said, like this, I just tell you, this is going to be the defenses. This is what they're going to, and he was very appreciative. I goes, I just like a straight shooting. So there you go. There you go. Barley Hops. How did no one in the true crime community catch this? We all read it. Well, I think you think that if it's on the indictment, you take it as true. My thinking is that had a lot of this stuff been flushed out in public? Yeah, the amended indictment had been out there. Okay. Grand jury indictment comes in. Okay, they sign it. They amend dates. Okay, fine. Hadn't been any real litigation on it. I mean, that's been out there, I guess. I don't know. I mean, I didn't catch it when we were sitting here watching it. I hadn't been watching the whole trial, thinking, taking copious notes of, this doesn't match up with the indictment. That's interesting. I hadn't watched it all, but the judge did. So, I don't know. We'll have to wait and see here soon. Hopefully here real soon. The judge should be coming out soon. Do we still have the phone line set up, Frank, in case somebody wants to call? If not, that's okay. Okay, no worries. Indictment is supposed to be true bills. Yes. Well, like I said, I'm looking at the amended indictment, and it's an amended indictment. It doesn't say superseding, but it's really what it is. And it's saying this is our amended indictment, and it's signed by the grand jury. So I guess my question is they presented some evidence as it related to count 4, right? That they had heard some evidence as to count 4. The JJ was killed on the 8th or 9th of September, not the 22nd or 23rd, right? So did they just go through the motions with the grand jury as well? I mean, you've heard the phrase, you can indict a ham sandwich. Apparently you can. Apparently you can even put the wrong dates in and nobody will catch it at the grand jury, at the DA's office, when it's read, up until the motion for judgment of acquittal. And if the judge doesn't allow it, I mean, it's a huge issue for appeal. Now, what would be the remedy? Would they get a new trial? Probably not, but it would be, I mean, they could actually, if you think about it. Let's think about this a little further. Let's say the judge doesn't grant this. He gets convicted and it goes up on appeal. Judge, they erred in allowing this count to go through to the jury. It prejudiced him as well as violated his due process rights as a right to present a defense because he didn't know and he prepared based upon the indictment, etc. Would they just say, well, count 4 would be dismissed, doesn't really matter, it's insignificant? Or if it affected and prejudiced him enough in the presentation of his defense, he could be entitled to a new trial. So, I mean, if I was the judge and trying to protect the record, I'd be saying, prosecution, sorry, but you guys blew it. This is your indictment. You filed it. We relied upon it. I mean, talk about prejudice. The court was prejudiced by the prosecution. Oh, it looks like here we go. Let's see what happens,
Please
ladies
be
and
seated.
gentlemen.
All right, we're back on the record on CR 2221-1623, State of Idaho versus Chad Guy Daybell. We took a recess after argument on continuing issues the court raised on the defendant's motion under Rule 29 for a judgment of acquittal, and in particular as it relates to count 4, after noting that the dates of count 4 in fact, were dates that matched those in count 2 relating to the alleged murder of Tylee Ryan on JJ Vallow's count 4 dates. So the court allowed time for the state to research and further argue as well as the defense. And the court's considered those arguments and at this time will make a ruling as it relates to count 4 of the amended indictment. First thing I'll note is at the stage we're at this point is a ruling on criminal rule 29, which is for a judgment of acquittal. I already indicated the standard and the case law as it relates to the burden that the state has on that. I went through the other counts and denied the motion and reserved ruling on this count 4 for further research and consideration. The court, having considered the arguments of the state and the defense, I'm going to rule as follows as it relates to count 4. First of all, the court would note that the state has argued that in its motion to amend the indictment, and I'll note the indictment initially was filed in this case May 25th of 2021. An amended indictment, which has governed this trial, was filed on February 20th of 2024. So there was a time frame between May of 2021 and February of 2024 where the governing charging document was the initial indictment filed in this case. The state by motion in November of 2023 sought to amend the indictment. And the court went back and reviewed that motion to amend the indictment. And specifically, leave was sought as required by the rule to amend counts 1, 3, and 5. And the court did have an objection filed, ultimately issued an order on December 8th of 2023, granting permission to amend the indictment. Among the charges sought to be amended, count 4 was not one of those. So when the amended indictment was filed, it did have an alteration on count 4. And so the court thinks it's important here to consider this procedural history. The original indictment on count 4 sets forth the dates of the alleged murder of J.J. Vallow of honor between the 22nd and 23rd of September 2019. The state's argued then this is a clerical error that should be allowed to be cured, among other arguments. And looking at the history of the proceedings here, the court can make some conclusions. Number one, the court didn't permit or authorize any amendment to count 4 in the new amended indictment. So count 4 should not have been amended. Second, the dates that were put into the count 4 of the amended indictment of 8th and 9th of September 2019 mirror those dates of another count, count 2, which is the alleged murder of Tylee. Looking at that history, I think the court does believe it's a clerical error that led to the change of those dates. And so then the court has to consider whether or not there would be prejudice is one of the things I need to consider, the manner in which this could be fixed if it could, and whether or not there's any prejudice to the defense, which is always a big consideration and what the rules govern in seeking to protect due process rights of defendants. The court would note I also have to weigh that out with the right of the state to seek justice in a case with the charges it's filed. The state's argued it should be allowed to cure this, that it's a clerical error. The court notes that the defendant was on notice for a period of several years from May 25th up until that amended indictment in February of 2024. So nearly 3 years that the allegation was this murder of JJ had occurred on or between the 22nd and 23rd of September. In addition, the court would note that the evidence in the case all pointed to the dates of the 22nd and 23rd of September. And not only that, that same allegation's been made in a previous case that was tried last year by this court of co-defendant Lori Vallow with those dates. And of course, the defense here was aware of that trial, the evidence in that case, and a resulting conviction. So there's certainly no surprise that would come to the defense knowing that the dates that have been alleged are the 22nd and 23rd. So in terms of any prejudice, I wouldn't find that it would be prejudicial at this point to permit the amendment of the dates. The matter before the court now is just simply whether or not a Rule 29 motion could be granted, and then additionally, again, what could be done to correct this if it can be corrected. Going back to count 4 of the amended indictment, if I were to disregard the dates in there, The court does find there's been sufficient evidence in terms of the elements that are alleged, that the defendant, Chad Guy Daybell, was identified by multiple witnesses, including Ron Arnold and Whitney Arnold, that in terms of the elements of the murder that are alleged, there was testimony from Brandon Boudreau and Garth Warren, among others, about this alleged count of first-degree murder involving J.J. Vallow as a victim. And he was also identified by those witnesses, and then other testimony from numerous other witnesses that testified about the murder of J.J. Vallow in this case, lead the court to believe there's sufficient information under Rule 29 that the motion for judgment of acquittal would be denied on that. And then leaving for the last part of the analysis here, the dates, the court, having considered that history and the fact that count 4 just never should have been changed because there was no permission to do that, I do find it's an inadvertent mistake. I've also seen case law cited by the state that the actual date or time of is not necessarily a required element of the murder charge. So while these jurors have already heard the information contained in the amended indictment, the court believes that the jurors can be fairly and properly instructed with a curative instruction or some other manner in which to correct what they've heard, so they can properly be instructed in conformity with the evidence submitted. So the only determination the court makes here today is that the motion for judgment of acquittal as it relates to Rule 29 is going to be denied. And on one final point of that, I'll also mention that it was a matter the court raised itself. It was not specifically argued by the defense. And so the court again finds it's not prejudicial at this stage of the proceedings to allow for that change to occur. What I don't feel like I have had time to properly and fully ferret out on the issue is precisely how that will take place, whether it's through a allowance under Criminal Rule 36 has been suggested, an amendment to the charging document, or simply a curative jury instruction or explanatory jury instruction. I need some additional time to think about that. But for purposes of allowing the defense a fair opportunity to be prepared going forward with its case in chief, I am making the ruling that the Criminal Rule 29 motion on count 4 is denied. So the case will move forward. That count will be included in the court is going to issue a substantive follow-up order to the parties that will be directive in how the court thinks it's best to cure the mistaken dates in count 4. So that's the final ruling on the motion for judgment of acquittal. Ms. Beatty, do you have any questions about that ruling?
And Your Honor, do you need any further briefing from us or anything of that nature?
I don't believe I do at this time with the ruling made.
Thank you very much, Your Honor.
Any questions from the defense?
No, Judge, thank you.
Okay, thanks all for your consideration this afternoon. We'll be in recess until Monday morning for the defense case in chief to begin.
All rise.
Well, there you hear it, ladies and gentlemen. The judge bails out the prosecution yet again. Yet again. All right, quick recap. The prosecution is calling their last witness. They then rest their case. The defense makes a motion for judgment of acquittal. No specific mention as to count 4, but Mr. Pryor says there's some elemental instructions that are flawed. Doesn't go into great detail. Very low standard for the prosecution to get past a motion for judgment of acquittal, but they have to present some evidence. Well, the judge on his own, because they have a duty to protect the record, sua sponte says, "Hey, prosecution, I got a question for you here. Remember that indictment that you all amended that we read to the jury? Well, the original indictment said that J.J. Vallow was killed sometime on or between September 22nd and 23rd of 2019. But the indictment here says that we read to the jury that he died on September 8th or 9th of 2019. Problem? How do we fix that? Because I've heard no evidence that he was dead on those particular dates." So the judge sends everybody away, gives them 2 hours to come up with various issues. And the prosecution comes back and says, "Well, judge, we filed a motion to amend Sure, we went back to the grand jury. And I'll be honest with you, I'm not sure how the hell the Idaho grand jury works, because if you got grand jurors signing grand jurors as an amended indictment, but it doesn't mean anything, what the hell is going on? There's some things in Idaho I just don't get. Okay. So they do their motion to amend and say, Judge, it's not a big deal because we only filed to amend counts 1 and 3, and then specifically counts 2, 3, and 5. They moved to amend counts 1, 2, 3, and 5, not 4, and therefore count 4 never should have been amended. Now, sure, the amended indictment has this wrong date that we now know is wrong, and nobody bothered to change that. And yes, that's an official filing of the court record, but don't worry about it. If not, Judge, then go to our second argument that dates don't matter. The jury can decide what date this all took place. Don't worry about it. Or third, let us reopen it, formally amend the indictment as necessary, and no harm, no foul. Hey, the prosecution has made the argument that the defense has been prejudiced because they had the original indictment. No big deal. The defense says, yes, I was prejudiced because that's what I prepared for based upon the amended indictment. So the judge comes out, does a little more research, and basically says, the prosecution's right. You know, it's practically the defense's fault for not raising this up, and they knew better. They knew better. They knew the count 4 wasn't amended. Therefore, it was never amended, even though the grand jury indictment signed by the grand juror has a new date, and that's the official document pleading in the case. You know, amended means to replace, but apparently only if you file a motion for a specific count. But even though we change other things, doesn't matter. So the judge says, well, you know, even though, like I said, you guys had 4 lawyers over there, nobody mentioned it. They read it, reread it, read it to the jury. No big deal. And so the judge comes out and says, well, you know, sure, that indictment back in 2021, there really isn't any prejudice because count 4 was never amended. So don't worry about it. And the defense should have known better. There's just a clerical error. I mean, it's not like it's an important document. It's only the indictment. And, you know, there's really no big deal here. And what did I say? He's going to say, seeking due process, prejudice to the defendant, the state's right to seek justice. We got to get the bad guy. And so he says, hey, the defense is on notice. You should have known better. This was all a big brouhaha. I'm not really sure why. I would have let the prosecution do whatever they wanted to do. You know, so there's no prejudice. And so dates don't really matter. Dates don't matter. And hey, you know what? Now the judge is going to take a little more time to think about when the defense case starts next week, how he's going to figure out how we're going to amend this. Do we just, you know, are we going to let them reopen their case, amend it, just ignore it and put it in a jury instruction so they don't really know? You know, that's all. I mean, just a pen change. What's the big deal? I mean, I'm not even sure it's really been changed. So I'm not even sure it really matters. So once again, I told you once I had a similar situation where the judge allowed, in my case, the prosecution to reopen the case. So I said, well, if rules matter, we'll count 4 will be dismissed. But if not, the judge will engage in legal gymnastics to get to the conclusion he did. My opinion, and that's legal gymnastics. How can you have an amended indictment that's filed with the court that everybody's relied upon and then say that one doesn't matter? Legal gymnastics. And this is why prosecutors get sloppy, because the judges always bail them out, ladies and gentlemen. They always bail them out. And I'm not saying it's necessarily, I get it. You want justice, but if the rules don't freaking matter, why do we even do it? Why do we even have trials? Why do we even come up with the rules if we're not going to find that they apply equally to everybody? And every time the prosecutor commits legal malpractice, we're going to help fix them and bail them out. I don't get it, ladies and gentlemen. I don't get it. All right. Next week, we have it. The trial, it will resume. It's going to be interesting because that's going to be the case that Chad Daybell puts on. We'll see how lengthy or not. We'll just have to wait and see. Thanks for everybody joining us today. We had a lot of people join us. I appreciate you coming here. Hopefully we kept it interesting for you while we were waiting and all that anticipation for something that really the prosecution wanted it done. So what does it really matter? They're going to get their way. And you wonder why I said my cynical side, the defense attorney side says, oh, he's going to find a way to come up with a way to screw Chad Daybell, who I really don't care about. It's the point is it's the rules that matter. And if the rules don't matter and the documents don't matter and dates don't matter, why the hell are we even going through this process, ladies and gentlemen? If it just doesn't matter, why? All right. That's all we have for you today. Thanks for joining us. We'll see you next time on Crime Talk.